everybody. Good to see you all back here. We are just now getting ready to go live in the case of State versus Alec Baldwin. This is a new one to my channel. I have not talked about this case on here before. This has been going on for quite some time, and I've been sort of monitoring things as they've been happening, but haven't really gone super in depth into it up to this point. So this is going to be an opportunity to kind of get to know a little bit about the case, about the people involved, and a little bit of a preview of what we should expect to see over the course of this trial. So let's start with the basics. Very basic stuff. Alec Baldwin, he is charged with involuntary manslaughter. And the indictment has basically two different theories for how the state believes he is guilty of this crime. One alternative is based on negligent use of a firearm. And the second one is based on just an act committed with the total disregard or indifference for the safety of others. This is the without due caution or circumspection prong. So it looks like it's two counts if you look at the indictment, but they are charged in the alternative, meaning he can only be convicted of one count. This is the same charge, involuntary manslaughter, that Hannah Gutierrez, the armorer on set, has already been charged and convicted of. She had her jury trial earlier, well, late last year, I believe. And she has since been sentenced. She got the maximum term of 18 months. I think there were a lot of reasons behind that, but her attitude after the trial, not particularly helpful. There were some jail phone calls that she had made that were recorded that didn't really go very far towards showing any kind of remorse or, learned her lesson, anything like that. So not necessarily the best attitude to take when you're getting ready to throw yourself on the mercy of the court. Well, if Hannah Gutierrez had that much difficulty with accountability, I can only imagine what we might be dealing with in the event Alec Baldwin gets convicted. Obviously, he has been in the public eye for a long time. He has had many issues with his temper.
You're on record. The matter I'm calling is D101 CR 2024-13, State of New Mexico versus Alexander Ray Baldwin. Parties state their name.
Your Honor, on behalf of the state, Carrie Morrissey and Erlinda Ocampo Johnson.
And on behalf of the defense, this is Alex Spiro. I'm joined by Luke Nikas and Heather LeBlanc and my client, Baldwin.
All right, thank you. All right, well, first of all, I have some housekeeping, and that is determining who is going to be the official record. And it sounds to me like Haven is going to be the official record, and that Summer Green is working for the defense. And if that's the case, Summer Green needs to move over there. And the reason why I'm making that basis is we were getting some confusion on who was doing exhibits, et cetera, et cetera. And so I asked Faith to basically ask the defense team what was going on with the court reporter, and it says, this is from Sarah Clark, for the avoidance of doubt, Summer Green is a member of the defense team who will provide the defense with real-time and transcripts so as to avoid burdening the court staff with requests for records. So it does not sound that she is going to be the official record.
Understood, Your Honor.
So thank you so much, but you're going to have to move.
The defense is going to have their own court reporter there for their own benefit.
That's what she said.
Be unofficial.
So she's asking for real time. That's up to the defense whether they're going to give you real time.
So we, I think both sides are using Ms. Green when we realized that she'd been hired by the defense. We wanted the real time also. just to, even the instruments here. If Ms. Green needs a place to sit, she's welcome to sit over here. And I agree with the court, the official record is
That means that all the exhibits go through Faith.
Absolutely.
All right, so at the end of the day, she collects the exhibits.
Yes,
sorry,
that's appropriate.
All right,
Definitely
so if
report
you don't mind
staff.
moving, this is optics, and that's how it's gonna be, I'm sorry. And then so,
Yeah, guys, it's just going to take us a minute to kind of get the audio sorted out
all right,
here
I'll let you do it
because
today, but tomorrow.
it's
yes.
coming in quite hot from the court, and there is
All right, so
only
let
so
me
much we
hear
can
from
do
you
about
all
that.
on what I'm prepared to do is hear the motion on excluding late filed witnesses and then going into the motions in limine, and we can do state defense, state defense. What do you all want to do?
That's fine with the defense. I think many of the motions hopefully will be far shorter, and some of these issues, I think, have somewhat been dealt with the briefing, because as much time today as can be spent on things to make sure we have an orderly and good trial, I think are helpful. Some of those were raised in the middle and some were not, so that's a fine system, and we're going to hope, at least on the defense side, to move quickly.
Okay. All right, so
So
let's take
guys,
up.
There are 23 motions in limine pending before this court. Some of them are stupid from my perspective. They're just trash things that are not, you
Okay,
don't
State of New
realistically
Mexico's amended expedited motion to exclude defense witnesses
expect a
Ryan
ruling
Winterstern and Christopher Zook.
on a motion to compel the prosecution to make ethical arguments. It's just,
You
it's,
can
it's
use the
dumb.
left turn or you, yes.
But there are some that are pretty compelling. And so this one is the state's motion to
And just so you know, so everybody knows, if you have a green light, that means your
defense
microphone's
witnesses.
on, and if you don't want anybody to hear what you're saying, you want to turn that off.
May I proceed, Your Honor?
Yes.
Your Honor, the state filed this motion on June 26, 2024, after the defense disclosed on June 24th a witness by the name of Brian Winterstern, and I understand he is one of the producers of this film. Mr. Winterstern had not been disclosed by the defense on any of their witness lists prior to June 24th. And while they argue that the state
thank
had
you, Court
Mr.
TV. I think
Winterstern
they
on its witness list in the Hannah Gutierrez trial,
might have
we
improved
would
things.
respectfully submit that that's a different issue. So here, the state did not have Mr. Winterstern as a witness. And so we understand that the defense is claiming that the reason they added him is because the state, at the last minute, added this producer theory. However, as the court, I think, noted in one of the hearings that we had previously, this producer issue was known to the defense, and in fact, during the grand jury presentation, and it begins at page 186 of the grand jury transcript, Ms. Morrissey questions the state's expert Brian Carpenter about Mr. Baldwin's role as a producer. And so this is not something that was new to the defense. Under State versus Lemire and State versus Sanders, the state is asking the court to exclude Mr. Winterstern because, number one, we have not been provided with the statement that he is going to be making or has
Look for
made.
closed captions,
We didn't have an
guys.
opportunity to do a pretrial interview of Mr. Winterstern. So as it relates to this case, the
not
state has
gonna
no
give us
idea
any-
what he is going to be testifying about or any previous statements that he made relating to this particular case. Setting Gutierrez trial aside, the issue is, what is he going to say in this case? And because of the late nature of this disclosure, we'd ask that the court exclude Mr. Winterstern. With regard to Mr. Zook, now, while the defense is right, the state did not request pretrial interviews of law enforcement witnesses. They were made available. Mr. Zook was set for a pretrial interview, but apparently he has left the sheriff's department, so
Guys, it's not
defense
going to give us
canceled
closed
his
captioning,
subpoena
unfortunately.
and did not proceed
I'll
with the
have it
pretrial
on,
interview. So he was
just
not
in case
interviewed.
they start, but it looks
We
like
would
they won't.
respectfully ask that because of the fact that the state has not interviewed these witnesses, and particularly Mr. Winterstern was disclosed so late in the game, we ask that the court exclude these witnesses. And unless the court has any questions, Your Honor, we rest on the motion.
The court does not. Thank you.
Thank you.
Good morning, Your Honor.
Morning.
So we'll start first with Christopher Zook. As the state has already conceded, the state did not actually request a pretrial interview of Mr. Zook. It is something that they do have to request. The defense did set up an interview that was for our own benefit. We did inform the state that we had set the interview so that as a courtesy, they could come if they wanted to, but it was not something that they requested. And if the party does not request the interview, then it is deemed waived. And at any point, they had an opportunity to do so. I do have an exhibit to provide to the court. I also have a copy for the state. And so
At any
I
point
do
in the
have,
last, like, 10 days.
an exhibit A, which is to this motion, if I may approach, Your Honor. And what I've presented the court with is a series of emails that were exchanged between the parties. And these begin with the request that the state made for witness interviews in this case. And as the court can see, and as the state has already conceded, Mr. Zook is absent from their request. Now, the reason we've included these additional emails as well is because there were multiple occasions on which the defense actually asked the state if they wanted to amend or add any additional witnesses for whom they wanted to request pretrial interviews. At no time did the state then change their mind and say, yes, we want to interview Mr. Zook. And so that was deemed waived, Your Honor, and we canceled the pretrial interview that we had set for our own benefit, for our own reasons. And so the state cannot now seek to exclude him when they did not take advantage of the process that was available to him. Additionally, with respect to Ryan Winterstern, it is somewhat ironic that in their motion, the state claims that the defense recently added Mr. Winterstern to gain some sort of tactical advantage, when really what we have here is that type of behavior on the part of the state. And one of the ways that we see this is that with respect to the initial filings before there was a dismissal in this case, when the case was originally brought before the court against Mr. Baldwin, originally, it had been clear that the previous prosecution team had intended to produce and to pursue a theory that involved liability based on a producer theory on Mr. Baldwin's alleged role as a producer. Based on that, we also then had a conversation with the new prosecution when they took over through Ms. Morrissey. And a conversation was had about the producer theory. And that was gone into in-depth and private conversations, at which point in time, Ms. Morrissey indicated that she did not believe that that had that could hold any water, that it was a viable theory.
I kind of doubt that.
Certainly, there was the grand jury presentation. Now, there was really not much of anything related to Mr. Baldwin being a producer. They didn't call anyone who was on the set. There were a number of different producers. I believe it was 6 different producers who were actually on the Rust set. They didn't call a single one to testify. And so it was not clear to the defense. And the fact that it was unclear to the defense is apparent in the fact that we have an additional exhibit, Your Honor, if I may approach.
I don't really buy this idea that they didn't expect the state to argue he's part of his recklessness is because he had a
And the
producer
exhibit that I
role.
just now handed to the court, which would be then Exhibit B to this response, is an email correspondence between, again, the state and the defense, wherein, as the court can see, and I think the court will have to flip to the back page to see the beginning of the chain. And so on November 1st of 2023, the defense inquires and says, your target notice identifies 2 involuntary manslaughter charges on which you will be presenting information to the grand jury. We then proceed to ask that in order to ensure that the alert letter that we submit actually is efficient, that we don't waste everyone's time, that they identify the 2 theories that they're going to be proceeding on.
And they said we don't have
The state,
to.
Ms. Morrissey, then responded, basically just reciting the statute. We then asked and followed up on that to say, we assume that the producer theory is not going to have merit, and so you're not proceeding under that theory. There was no response. The state easily could have responded, could have let us know. They knew where our mind was.
Okay, that's
They knew
rich.
that we were thinking because of the prior
We're
conversations.
going to put
that we'd
words
had
in
with
your
Ms.
mouth
Morrissey,
and
that
then
this was
say,
not a theory that
if
they
you
were going
don't
to proceed
take up
under.
your time
Additionally, Your Honor, with respect
disagree,
to the witnesses that they've listed in the actual
you agree.
case itself, and this again goes beyond just the grand jury. In the case itself, the state has not listed a single one of the producers who were on the Rust film, not a single one. And so at this point, they have 3 different individuals who they're going to call to try to have them testify about what Mr. Baldwin's role as a producer would be on this film, what responsibilities he would have. 2 of those individuals have never been a producer before, and the other individual has very limited experience and was not actually on this set. So we sought, after the state had then disclosed, basically for the first time to us, their intent to proceed under this additional theory through some of the motion practice when we filed a motion related to one of their witnesses. They then first identified that they were going to move under this new theory. So we then, just a matter of days later, added Mr. Winterstern to the witness list, and it was for the first time. But this was because the defense was not on notice that they had intended to pursue this theory.
Yeah, that
And
seems
he was not on the
quite a
witness list
stretch to me.
You know, to try to gain some kind of tactical advantage. It was because he wasn't relevant due to anything previously that we understood the case to be about, which was, again, according to the indictment as well, it specifically lists the date of being October 21st, 2021. It does not list a series of dates. It doesn't list the length of time that Mr. Baldwin was on set. It lists one particular date. And so Mr. Winterstern
when
was
the
not
shooting
relevant to the
happened.
defense theory at that time. However, now we have added Mr. Winterstern, and the state cannot claim prejudice because Mr. Winterstern was a witness in Hannah's trial, and I'm almost finished, Your Honor. But not only that, he was the state's witness, and they did conduct a pretrial interview of Mr. Winterstern, and during that pretrial interview, it was actually asked by Ms. Morrissey what Mr. Winterstern's role was as a producer.
When was this pretrial interview?
This pretrial interview, Your Honor, that I have was January 8th of 2024. And so January 8th
the
of
state
2024.
did interview him.
He was asked a number of questions about his role as a producer by Ms. Morrissey. Ms. Morrissey also asked Mr. Winterstern about other producers' roles. Ms. Morrissey also asked about Alec Baldwin's role as a producer on set. And this is someone who would have personal knowledge of that, unlike any of the other witnesses that the state is calling to try to make out this producer theory. So there is zero prejudice to the state because everything that we would be going into in the trial has already been covered by Ms. Morrissey in their own pretrial interview for a witness whom they called in the previous trial. And so we understand that they're now trying to claim prejudice, but it's because that they know that this sinks their claim and that this is a much more appropriate witness than any of the 3 whom they've listed to try to go after Mr. Baldwin on this producer theory. So we ask, Judge, we are just asking for basic fairness and due process. There are other avenues. If the court wanted to give them another interview, they could do that. But again, they've already had a substantive interview of him, and we would ask that the court allow Mr. Baldwin to present this defense.
Thank you. Reply?
Yes, Your Honor.
So if they've interviewed him and they aren't going to,
Your Honor, the
defense isn't
issue
going
is
to exceed
The court issued a
that
scheduling order
interview,
in this case.
I don't
not in
see
the Gutierrez
prejudice to
case,
the
in
state
this
then.
case. The court set deadlines for pretrial interviews.
The
It set
other guy,
deadlines
though,
for
not sure
witness
about.
disclosures. And the fact that Mr. Winterstern was interviewed in the Gutierrez trial does not obviate the need to have a pretrial interview of him in this case. Because in Gutierrez, he was listed as a witness for The state, in this case, the defense is calling him. The state has no idea what he is going to be testifying about. The state has not been given any prior statements as it relates to this case. And as the court can see, Your Honor, what we have here is by this email is that the defense was put on notice, and they call it a producer theory. It's really not an independent theory of liability. What this evidence goes to, it goes to Mr. Baldwin's knowledge that his conduct on set was reckless, and it
state of
was
mind.
in essentially wanton disregard for the safety of others. And his role as a producer made him keenly aware of the safety rules that apply on sets, what his responsibilities are. And so, as we'll argue in the 404 or the intrinsic evidence motion, this particular type of evidence is germane to the defendant's recklessness in order for the state to prove the involuntary manslaughter. They cannot claim that this is a new theory. As I noted, Your Honor, page 186 to 187 of the grand jury transcript, which was attached to the state's June 21st, 2024 response to the defendant's motion to file a supplemental brief, Ms. Morrissey goes into great detail with Mr. Carpenter, the state's expert, about Mr. Baldwin's role as a producer, his responsibilities as a producer. Mr. Winterstern, from what we understand, has very little producer experience, but nevertheless, we would argue to the court, Your Honor, is what is he going to be testifying to in this case? The state has no idea. That Ms. Morrissey spoke to him in the context of the Gutierrez trial is irrelevant to the court's analysis in this case. Under Lemire and under Sanders, and in Sanders, it's 1994 New Mexico Supreme Court 43 at paragraph 26. The court noted a defendant's right to present evidence on his own behalf is subject to compliance with established rules of procedure and evidence designed to assure both fairness and reliability in the ascertainment of guilt or innocence. If the state had done this, you know they'd be up here screaming to the court that we have sandbagged the defense. Your Honor, the state is entitled to a fair trial as well, and so we'd ask that the court exclude Mr. Winterstern. Thank you.
Well, did they move off Zook?
All right, the court makes the following ruling. The court denies the state's motion. With respect to Mr., well, first, with respect to both of them, I don't think that you've established prejudice, and to the extent that you want them excluded, certainly there are other remedies. I will have the defense make Mr. Wingerstein available for a pretrial interview. And with respect to Zook, I'm not quite sure now. They're saying they want an interview. All right. Is that a problem for you?
We can confer with the state and work out the issue.
All right. Thank you. All right. Remember, I believe it's 10 minutes aside, half an hour for lunch. So I'll
this
start
could be
with-
taking some time to get through all these motions.
All right, state's motion in limine to exclude evidence or separate civil suits against defendant and/or Rust Productions.
This should be a given unless it's admissible for some purpose, like to explain people's conduct, why they behaved in a certain way or said, certain things after the case has been initiated.
If you're going to do a reply, you're going to need to
But in and of
figure out how you're
itself,
going to do that. 3 minutes for the reply.
the fact that people
Okay,
are suing,
I'll be brief.
it's not
And
admissible,
I hate
it's
to
not
tell you, I'm
relevant.
going to cut you off right away. Okay?
Understood, Your Honor. Your Honor, in this particular case, as the court is aware, there have been multiple civil lawsuits filed against Rust Production and against the defendant himself. Mr. Joel Souza, one of the state's witnesses, filed a civil lawsuit that I understand, has since been settled. There are 3 other states' witnesses, or 4, I believe, other states' witnesses who have pending civil lawsuits. We would respectfully ask that the court preclude the defense from cross-examining first Mr. Souza about his settled civil lawsuit.
Now-
And there's a case right on point, which I cited in the motion, which is United States versus Whitehead, It's a U.S. 10th Circuit Court of Appeals decision.
I can see this going to bias,
at 701,
potentially.
wherein the court affirmed the district court's denial of cross-examination on a civil lawsuit that was related to the criminal case, but that had since been settled before the criminal case went forward. And that's the issue with regard to Mr. Souza. The fact that he had a civil lawsuit and settled it is irrelevant and should not be allowed. With regard to the other witnesses, Your Honor, although we understand and the state acknowledges that under State versus Santillanes, the court noted that the pendency of a civil action by prosecuting witnesses seeking damages is a proper subject of inquiry. But the court also recognized that it's proper if the civil action is for the same offense that is being tried. And that's where the state respectfully submits there is a distinction between the pending civil lawsuits that four of the state's witnesses have versus what the court looked at in
I don't think I'm going to buy
Santillanes.
this. It's the
My
same
understanding
shooting.
is that the pending civil lawsuits that the four states' witnesses have to do with intentional infliction of emotional distress and negligence as a whole in the filming or during the time that this filming was taking place between
You just said in your
October
last
6th and
motion you're
October
relying
21
on that to prove his
of
recklessness.
2021.
So I kind of
So
think
it's not
it's going to
specifically
be related.
related to the charge the defendant is facing. Now, if someone had a pending wrongful death lawsuit, I would concede that that is germane.
For those
and
of
is
you
subject
asking
to
about the prosecutor, I
cross-examination.
believe
But
this is
because there
Erlinda
is a difference
Johnson.
between the civil lawsuit
She is the
and this pending criminal prosecution,
co-prosecutor
we would
with
respectfully
Carrie
request that the
Morrissey.
court deny or preclude the defense from questioning these witnesses about their pending civil lawsuits, unless the court has any questions, Your Honor. Thank you.
Your Honor, the defense has no present intention of questioning Mr. Souza about his settled lawsuit. I'm not waiving that issue, but I don't think the court needs to get there today. The rest of this issue is quite easy. This cross-examination was done during the Armour's trial, as the court no doubt remembers. In that case, there was zero financial motive. In this case, there is suits against Mr. Baldwin directly, an extreme financial motive. And number three, the lawsuits are exactly on point. It almost actually looks.
Yeah, I gotta agree with him on this one.
Lawsuits versus the state's case, like they copied and
It's
pasted
the
it.
same
And I know this
incident.
case seems in some ways like a civil negligence case, but it literally looks like they may have copied and pasted part of the lawsuits. So they're directly on point. None of their cases say what they claim. The case law on this is clear. It's actually one of those issues that's universal amongst all 50 states and all courtrooms in this country. You can always cross-examine a witness about their motive and bias. You can always ask them if that's the reason they're testifying in a certain way. And that's what the Confrontation Clause promises us, and that's what the Constitution demands. I have nothing further.
Any reply?
Quick and effective.
Your Honor, it's a fine distinction, and it's made in State versus Santillanes. If the civil action, and I quote, was for the same offense being tried in a criminal action, absolutely agree, it would be subject for cross-examination. But I would respectfully submit that there are differences here between the civil actions and this criminal
Well,
prosecution.
of course, there
So
are
we'd ask
technical
that the court
differences
preclude any
because you can't
cross-examination.
civilly sue someone for a crime. It's always going to be.
All right, the court makes the following
Court.
ruling. Evidence of pending lawsuits against defendant by testifying prosecution witnesses is proper impeachment evidence. The motion is denied.
Yeah. Okay for
All right, next
impeachment
up
for bias.
is Defendant Alec Baldwin's motion in limine to preclude improper impeachment evidence. Is that what you all have as the next one? Or was that at the end?
Is there a number?
Is it
Well,
Baldwin?
that's the problem. In the beginning, you didn't number.
That's my fault. I'll take responsibility for all faults to date.
Okay, so you want to do these at the end, and you want to start with, what do you want to do?
I'm happy to do motion, what looks to me like motion eliminate one from,
Okay,
the-
we'll do
the
these other
defense.
ones later, all right. Defendant Alec Baldwin's motion in limine to preclude improper prosecutorial conduct and require an orderly trial.
This is one of these silly motions.
And yes, Your Honor, I think this
He's
is a
just
good
gonna
place to
rant
start,
about what they did in Gutierrez.
today, because this is sort of my main issue throughout the day and what I'm going to ask to address at various points, and that's why I'm going to keep my remarks so brief on on my motions, because hopefully the court will give me the courtesy of a few more minutes when I need at the end. But essentially, the court has the papers. Their response that the state is allowed to burden shift in certain places, that's their sort of strongest response, misses the mark. I mean, even in the case they cite, right, what the prosecutor does, it's one remark in summation, where the prosecutor says, I, of course, have the burden of proof. It never leaves this table. This is a very serious proceeding, and I have the burden of proof. Just so you know, though, you can consider, and then they make one remark. That's the context of any case that goes against these basic propositions that are also the same in every single state in this country.
Rules
So
that
the
say,
reason that I had to
motions that
make this
say make
motion,
them follow the rules
is
are
because
silly.
in reviewing some of
Object,
the trial, and I haven't
and
been
it will
able
be
to get
ruled
through
on.
Every bit of it that I want to on this subject, but it's constant issues with controlling the prosecution from doing things that are just straight and proper. And so I don't know what to do in that circumstance. I've never made
You
a motion like
object.
this before. But it's objection, this witness doesn't know that, objection, they don't know how to identify the picture. We have plenty of other witnesses. Sometimes it was no objection at all. Sometimes the prosecutor just called out from the prosecution table and started saying, I would request the witness read the entire transcript. He can't answer that. And then there's the questions, and we'll get to this in another mill, which is constantly, every single witness, they'd ask a question, what happened next? And where was Miss Hutchins during that? Where was Miss Hutchins? Oh, she was in the helicopter. And then they would go on. And they would ask another question about the chronology. And they say, well, where's Miss Hutchins? She's in the helicopter. And so,
What's
this is,
improper about that?
it's misconduct. You can't do that. You can't do that as a prosecutor. You're not allowed to do that as a prosecutor. It's very
What?
serious to do that as a prosecutor. And so
You can't
eventually
ask
the
a
court at
witness
some point
Where
stopped
somebody was?
Miss Morrissey from doing the coaching, speaking objections. And then Miss Morrissey began, every time her name was mentioned in a question, she began to stand up and say, well, I'm being talked about in this question. And she began interrupting the proceedings. So I didn't know how to address this. I don't know how to address this, even as I stand before Your Honor. But my request would be objection, relevance, objection, hearsay, and nothing else. And in the very rare circumstance when an issue rises to the level of extreme importance or constitutional imprint, a lawyer can approach. If there's something very complicated, a lawyer
an
can approach.
instruction?
But otherwise, none of those
admonishment?
tactics and devices should be used at this trial. We've come a long way to get here. The court has been very patient. All that we want is a fair trial. And for the rest of this, I would rely on my papers. Thank you.
Yeah, this to me is a ridiculous motion. The rules already exist. The judge doesn't have to rule on the existence of the rules. She has to rule on specific instances of
Your Honor, I think we
conduct,
can
which is
agree
why
on
you
one
object
thing.
when they happen.
Absolutely, without a doubt, and that's beyond dispute. The state has the burden, and the state cannot shift that burden to the defendant. Absolutely agree. However, there are those limited circumstances where the state is given latitude with regard to countering defendant's arguments. For example, the defendant comes in and, as the court has heard, presents argument that somehow somebody modified this firearm. Where is that evidence? The state should be allowed, and has been allowed, and in fact, in State versus Aguayo, which is cited in the motion, 1992, New Mexico Court of Appeals 124, the courts have allowed the prosecution to argue that the defense didn't present witnesses to support their defense theory. But the state has the burden. There's no question about that. So we would ask that the court give the state some latitude with regard to responding to defendant's arguments. And I can guarantee you, we will not, the state will not, under any circumstances, shift the burden to the defendant, because that's improper and it will not happen. With regard to vouching for opinion or for witnesses, I agree it is improper to vouch for a witness's credibility. But there are
Vouching,
circumstances, Your Honor,
but-
where the state is permitted to comment on the veracity of a witness as long as it's based on evidence. If the prosecution says, it's my opinion that this witness was truthful, absolutely improper.
Yes.
Absolutely agree. But if it's based on evidence that a witness testified to X and
You
there's
should find her
corroborating evidence
credible.
of
This
X,
is not hard to
the
stay
state
within these
is allowed and
rules.
should be allowed to argue to the jury that this witness has testified truthfully based on the evidence. And finally, part of this, during closing argument, Your Honor. Yes, no, not during the trial. With regard to coaching witnesses, Your Honor, which is the last part of this motion, I agree as well. A prosecutor must not coach a witness, particularly must not coach a witness to testify falsely or to phrase the witness's testimony. However, it is absolutely proper for the prosecution to meet with witnesses, to prepare to testify. The defense has taken the position, I believe, that any sort of preparation with witnesses is improper. I would ask that the court not allow the defense to try to imply to the jury that meeting with witnesses prior to their testimony is improper. Coaching, absolutely. That the prosecution to tell a witness what to say, absolutely agree. But to meet, to prepare for their testimony is completely proper. And we'd ask that the court not allow the defense to comment on that as being improper. Thank you.
Anything else?
No, Your Honor.
All right. Well, I have to say, I don't like these kind of motions.
Thank you,
because,
Judge.
I'm not going to be bound
I
by
already
it
love this,
during
Judge.
trial where someone
It's a
shows me an
stupid
order and
motion.
says, this is what I said. I was going to tell you, but I'll tell you now, based upon the ruling, every time you want to say something that is not a question to your witness, you're going to come up to the bench. So you do not get to say, objection, blah, 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 and then wait for me to say to come up. You're going to come up. And this happened in the Hannah Gutierrez trial. So,
Yeah, just point of clarification. I don't have any intention of a coaching during the trial, other than the rarest of circumstances.
no. You have to come up to the bench and put on the record your objection. You don't get to do it from there.
No speaking objections.
I have to internalize this. I've never had a trial
Alex,
that way.
you know that.
I would ask to potentially address this issue. I mean, I don't think the defense or anything that I've done would necessitate changing the rules. At least I would ask them to.
This is, a court can do what they want with respect to objections, and this is what I'm going to rule. So I'm trying to, the sides have been contentious with one another. I think that you all may not intend to, but you might want to try to get the jury to see what's wrong with that question and, or make some argument to try to influence the jury. And if you're going to object, it's going to be up here, and you're going to put on the record what the objection is, and I'll make a ruling up here.
And may I just approach for just
Yes.
a second, my friend? So I'm glad I saved my rebuttal, because I do want to address this issue, Your Honor.
She's already
What
ruled.
I would
This
ask
is not
and urge the
rebuttal.
court, because I think that this system could disrupt the ability to cross-examine and it disrupt the defense.
Oh, don't be a drama
It is not,
queen.
as I think the court will acknowledge.
gotta
It is
tell
true
ya.
The court has great discretion. I think that deciding
Not a
that
big
before
fan
the
of
trial even
Alex
begins is
Spiro,
extreme use of
myself.
discretion, just genuinely. I know that issue happened at the prior trial. I'm asking and urging the court to give an opportunity, at least to the defense, to just simply say, and I think my suggestion works, right? It's just objection, relevance. There's no other words coming out of my mouth ever during objections at a trial in front of the jury, and to allow us to have an opportunity to have what I would call a normal procedure. Because if every time there's any progress going on with a witness, they're standing up and they're making everybody come to the bench, they're disrupting the ability to cross-examine. They're disrupting the ability to put on our case. So what I would urge the court and ask the court to please do is to allow us at least, if after the first witness even, the court wants to revert to what they did later on in the Hannah Gutierrez retrial. But I can tell the court I've tried many cases. I've never had that issue before. I've never had that issue with one witness in one case. So I'm asking the court to at least give the parties a chance to do it. I also am very concerned about the time, schedule, and everything else. There are lots of objections that are just objection relevance. The court will rule. If the court needs to hear more, we come up. And I'm urging, almost begging the court to at least let us start that way, and then the court can, like this, and not hear from me further on this issue. Thank you.
I'm not going to change my mind. I can see, what I want to do is I want to start with you all getting the lay of the land. And I'm going to be in control of the courtroom. So this is what I'm going to do. I'm sorry that you haven't experienced this, because it can happen, and it does happen. So that's what I'm going to do. If
I don't
you
give a
all
shit
seem to
about your
be
experience.
doing well, and you get it, and I'm hearing relevance, I agree, then we can perhaps relax the rule. But that's how it's going to start off. Okay? All right, so,
Show you can be
I
good
don't
little
know what
boys and girls,
basically,
and you'll earn
didn't
yourselves.
really rule except that I'm in control of the courtroom. All right,
You'll
thank
earn
you.
yourselves a little lenience from the
All right,
naughty
next up
sidebar.
is State's motion in limine 2 to exclude UNM hospital records of Ms. Hutchins' medical treatment.
Your Honor, we have no present intention of admitting this exhibit. I don't think there's any grounds to exclude it based on redactions, but this case isn't about the medical issues of Ms. Hutchins, and we're going to address these issues in
All right,
another
so
bill.
what is the bottom line? You are no objection?
No objection, Your Honor.
All right.
Thank you. Just get him on,
All
no
right,
objection.
No objection. I'll just write this down.
He's trying to keep the door open. We don't intend to, but it should be admissible. No, just commit to a position and then go.
All right, so the motion is granted. All right, defendant's motion limine number 2 to preclude inadmissible character and prior evidence and statements unrelated to the events of October 21, 2021.
Now this one, yeah, I'm not buying this
Morning, Your Honor.
either.
It's nice to finally see you in
This
person.
is all going to go to mental state.
So I'll be brief. You just heard Ms. Johnson, in response to our arguments about the civil suits, say the civil cases are about October 6th to October 21st, the whole negligence. And that's very different from what Mr. Baldwin has been charged with. He's been charged with what happened on October 21st. And yet, when you look at the 404B disclosures that the state has provided, all of those disclosures relate to events that happened before October 21st. Mr. Baldwin swore on set. He cussed. And therefore, what? He committed homicide? Mr. Baldwin pointed the gun earlier,
No.
or rushed people
Therefore,
earlier.
the crew
And
was
therefore,
scared
on October
of him.
21st, he had a propensity to do it again, or he committed homicide. That's exactly the kind of propensity
Because they
evidence
felt
that must be
encouraged to
excluded,
cut
Your Honor.
corners in order
The
to
state
satisfy
cites
him.
3 cases about this. The first one, all of them illustrate it, but the first one illustrates it best. The U.S. v. Reggio case. They say Reggio was a commercial trucking driver. And the state was allowed to introduce evidence of what he did before the commercial trucking accident that he was involved in. But when you look at the case, what actually happened was Reggio had a medical condition. His doctor diagnosed him with it. He went and he applied for his commercial trucking license, and he denied having the physical condition. He knew that condition made it unsafe for him to drive. He got his license, procured by that lie. He drove, he got in an accident, and someone died. And he was charged with involuntary manslaughter based on an unlawful act that he committed before. What was that unlawful act? He was driving knowing that he wasn't physically qualified. That was the predicate act. So the state said, we're going to admit evidence of that predicate act. He lied to get his commercial trucking license. And that's going to show, A, the predicate act. It's also going to show he knew it was dangerous for him to drive. And they were going to bring the doctor in there to say so. That's not at all what's happening here. Mr. Baldwin swearing on October 16th is not a predicate act. It's not a crime at all. Whether he checked the gun or not on October 16th, not a predicate act. And so the cases that they cite, starting with Reggio, have nothing to do with how they're trying to use the evidence here. Now, it might be different if they said, look at Mr. Baldwin on October 16th. Look what happened. He was rushing people. He was pointing the gun. He was doing all these crazy things on set. And look what happened. There was an accident. Someone got hurt on the 16th.
Why does it
And he
matter
knew
that
it was
that's the
dangerous
culture
to do
that
what
he
was
fostered
doing, yet he
a
continued
week
to
before?
act on the 21st in the same way, knowing that harm happened before. That might be relevant, but that's not what happened here. No one was injured. because he swore at someone on the 16th or threw a gun on the ground on the
Fortunately.
16th. They're trying to use it to show propensity. Reckless before, reckless now. They cite two other cases, the Coughlin-Lambert cases. Coughlin, they say, the court allowed the government to introduce evidence of his prior athletic activities when he had submitted a victim's compensation claim after being injured at 9/11. The state says, see, look, prior activities, case now about a fraudulent claim, 9/11. But the fraudulent claim charge against him was that he wasn't actually injured at 9/11 as severely as he said he was, because look at, he's running around, he's an athlete. He's clearly not injured. So it had nothing to do with propensity, it had nothing to do with he's a bad guy and therefore he committed fraud on the victim's compensation fund. It was directly relevant to it. Same with the Lambert case, it's a bank robbery case. The defendant was talking about robbing a bank before, planning the locations, plotting it out, and
This
then
is a
lo and
very
behold, not
different
so long after he
circumstance.
robs a bank. He
These-
says
these
you
aren't
can't
good
do that, you can't admit
analogies.
character evidence. The court says, no, you were talking about robbing a bank, you were planning the location, that is directly linked to the fact that you did, according to the state. So all
Yeah,
of the
so,
cases
like,
they cite have
You
a very direct
FaceTime
link.
through your safety training?
The evidence
Shouldn't
that
be
they're trying to
relevant?
admit against Mr.
Of course
Baldwin,
it is.
it's all propensity.
You're
Mr.
being
Baldwin's not a
reckless
murderer on the 21st because he swore on the 16th.
throughout this
They're gonna
production.
try to show that, that's highly improper, it should be excluded.
So that tends
Thank you,
to
Your
show that when when a shooting happened, it wasn't due to an accident. It was due to a culture of recklessness.
May I please the court? Your Honor, first, these other acts evidence constitute res justa. This is intrinsic evidence. And I can tell you, I'm intimately familiar with the United States versus Riego case because that was my case. Mr. Riego was charged
Always
with
love
4
that.
counts of involuntary manslaughter. And the court allowed the introduction of his prior medical records from about 2 years before the incident happened. So the traffic accident happened on September 7th, 2019. And Mr. Riego was driving on the interstate on a phone call with his wife. And then he unfortunately crashed into the victims and killed 4 people. The court allowed evidence of those medical records and allowed evidence of his application to get his commercial driver's license, where he indicated that there were no medical issues. And also, the court noted in allowing this as res justa or intrinsic evidence, that this evidence goes to the defendant's reckless state of mind. So for involuntary manslaughter under the state statute, as the court knows, the state has to prove that the defendant acted without due caution and circumspection. And so we have to prove criminal negligence, that the defendant willfully disregarded the rights and safety of others. And the uniform jury instruction, and it's cited in the Henley opinion, that the defendant should have known of the danger involved in his or her actions and continued to act. So intrinsic evidence is evidence that is directly connected or provides context to the jury of the charged offense, and it's connected to the factual circumstances. So what the defense wants is for the jury to be, for the state to only be allowed to introduce in a vacuum the moments leading up to October 21st, 2021, when the defendant shot Ms. Hutchins. However, intrinsic evidence allows the introduction of evidence that's inextricably intertwined with the acts that form the charged offense.
So the handling of the firearm?
I would respectfully submit, Your Honor, that this is...
Pretty relevant.
The state has submitted this notice on June 17th as required, putting the defense on notice that these different videos show the defendant acting in a wanton and reckless manner. For example, there are 8 videos, and those are exhibits 61, 62, 63, 67, 68, 72, 74, and 76, where his finger is on the trigger when it shouldn't be. There are some videos, 7 videos that show the defendant sort of horseplaying around with guns, exhibits 95, 111 to 115, and 65. evidence of the defendant using the gun as a pointer, Exhibits 91 and 58. These are inextricably intertwined with what he did on
Yeah, I would
October
say so.
21st, when he pointed that gun at Ms. Hutchins, cocked the
Isn't
hammer and pulled
habit
the trigger.
an exception
And
to
so that
404B?
prior evidence, those other.
You wave the gun
acts,
around with your finger on the
excuse me,
trigger?
Other acts evidence basically put into context what happened on October 21st and established the recklessness mens rea. In the alternative, oh, and there's another issue, Your Honor. So the defense are going to be arguing to the jury, and we've seen the preview, that this gun was modified and that it didn't work. Again, as intrinsic evidence, these videos show on a number of occasions that this gun was working perfectly fine. It had no malfunctions. Every time the defendant fired it, he pulled the trigger. There were no issues. So it is actually relevant to demonstrate that there were no issues with this gun. In the alternative, Your Honor, these other act evidence, instances of the defendant's conduct are admissible under Rule 404B to show knowledge and to show lack of mistake. Knowledge in that the defendant should have known on October 21st, when he was pointing that gun at Ms. Hutchins, that his conduct was wanton and reckless. And we prove that by the evidence of the other instances where he acted in a wanton and reckless manner as it relates to this gun. And so, and it also shows that there's no mistake. The defense is going to argue, oh, this gun just discharged on its own. I didn't do anything. This is not a mistake. Each time he had his finger on the trigger, previous occasions when he shouldn't have. And so I would respectfully submit that they are admissible as intrinsic or in the alternative under 404B.
Frankly, it's not clear to me that it matters whether he pulled the trigger or not. You're not supposed to be waving the gun around at other people on set.
2 points, Your Honor. Number one, the state told you what it's going to do. It's going to try to show recklessness before and therefore recklessness on October 21st. That's propensity evidence. That is not what Reggio allows, not what Coughlin allows, not what Lambert allows. They cannot do that by showing what happened before is an indication of what happened after. There was no, as I said, aha moment connecting state of mind before to state of mind on the 21st. No accident happened. Reggio, the reason state of mind was inextricably linked was because he lied about his medical condition, knowing he couldn't drive. That's the proof. That was inextricable. It was a predicate act. None of these are. On top of that, most of the clips don't show Mr. Baldwin shooting. They show him swearing or putting a gun on the ground or taking a gun when he's lying on the ground and sort of accidentally pointing it. These issues are not what they're trying to show about the 21st.
Isn't that the
He's
problem?
not shooting, showing a malfunctioning gun in most of them. They're trying to bring it all in, not to show what happened on the 21st, but to use it as reckless evidence of before and therefore after. She just told you that, Your Honor. I have nothing further.
All right, thank you. You're going to see me looking at my laptop. That's because I took notes on these matters on my laptop. All right, the court rules and reasons. Evidence regarding defendant's handling or firing of the firearm or firearms firing during the filming of rust are relevant in that they have any tendency to make a fact more probable, to wit that the firearm worked properly during the filming and that defendant Baldwin was not handling the firearm safely. This goes to facts of consequence in this action. Applying the balancing test in which the court may exclude such relevant evidence if probative value is substantially outweighed by unfair prejudice, confusing the issues, etc. The court balancing test does not weigh in favor of defendant. However, any of the videos or any evidence or pictures which relate to Mr. Baldwin not handling or that goes to the defendant's the gun didn't work, and they're showing that it did work because he's shooting videos that show that he's cocking the gun when he doesn't need to cock the gun, goes to the negligent use of a deadly weapon. However, everything else regarding him yelling at the crew or telling people to hurry up, none of that is relevant, and that is propensity evidence. So I think that you all can look at the videos, look at the any of those exhibits, and agree which ones meet my ruling. And if you can't do that, then I'll have to help you out. Okay? So denied and granted in part.
So that seems pretty fair and
All right,
reasonable
state's
to
motion
me.
in limine to exclude irrelevant evidence and witnesses.
I would tend to be okay with the yelling at people to hurry up because that goes to his producer role and the control he had over the circumstances that led to a live round being in that gun. But that's
Let know
just
if
me.
you all need a bathroom break or anything. Otherwise, we're going to noon. Now you need a bathroom break.
This is state's motion in limine 3, correct?
Yes, it is.
Okay. Your Honor, we filed this motion because we understand that the defense plans to call Robert Schilling. Mr. Schilling was a private investigator that was hired, who was hired by the prior prosecution team. When Ms. Morrissey took over the case, Ms. Morrissey terminated Mr. Schilling because he had done absolutely nothing on the case, essentially. So in response, Mr. Schilling sent an email to Ms. Morrissey and copied Mr. Bowles as well, and essentially criticized the law enforcement investigation and essentially said, I can't undo this disaster of whatever, I'm paraphrasing, of this investigation. So it was essentially a strong critique of the law enforcement investigation. I would respectfully submit that under United States versus McVeigh.
His opinion isn't relevant,
153
I
F.
wouldn't
3rd,
think.
1166, page 1192, this type of evidence is inadmissible. Now, if there was, for example, evidence of what happened to the gun is going to be admitted. The state does not dispute that or disagree with that. But just to bring in a witness to critique and criticize the law enforcement investigation is improper. And it's the type of evidence that McVeigh, the 10th Circuit Court of Appeals in McVeigh, noted would be improper. So we would ask that the court exclude Mr. Schilling from testifying because the entire purpose is to bring him in to talk about how disappointed and disgruntled he was in terms of the investigation, but there's a motive there. He was terminated and he did nothing in the investigation. We're also asking the court exclude Sheriff Adan Mendoza from testifying. I believe the defense in one of its responses indicated that they don't plan to call Sheriff Mendoza, but in the event that they do, we'd ask that the court exclude him as irrelevant. There is nothing that Sheriff Mendoza did with regard to this substantively, with regard to this investigation. He oversaw his deputies who were conducting the investigation, but he wasn't involved. And so to bring him in again, it's just to set him up there to criticize the quality of the investigation. And we'd ask that his testimony be excluded as irrelevant. And I believe all he did was do some press conferences too. So I don't know if they're planning to inject that in front of the jury. And I would argue that that's irrelevant. And even if the court believes it's somehow relevant, it should be excluded under Rule 403 as more prejudicial than probative.
What just happened? We've just lost the feed here. See if I can find it on another
Investigating
channel. Okay,
the
here we
case.
go.
That's irrelevant. Those are prosecutorial decisions that have no place before the jury. I would ask that the court exclude any argument or any presentation that the state did that. We also would ask the court to preclude the defense from making arguments that are aimed at garnering sympathy. For example, that Mr. Baldwin feels remorseful.
This is another one of the
irrelevant.
stupid-
It doesn't go
stupid
to any issue, and
motions.
it invites jury nullification.
Object
So that type
if
of
they do
argument
it.
should be precluded. I believe they conceded on the biographical information because, as we heard during many motion hearings, that Mr. Bash was the former U.S. Attorney for the Western District of Texas. That's irrelevant. Mr. Spiro was a former Assistant DA. That's irrelevant. Just like my time as an attorney for the U.S. Department of Justice is irrelevant as well. that those should be excluded. And the last part of this motion has to do with arguing inappropriate legal standards to the jury. Again, I believe in one of the motion hearings, Mr. Bash argued that, or it was argued actually to Judge Ellington before the grand jury, that the only way that the state could prove this case is if they proved that the defendant knew that there was a live round in this firearm. That's improper argument of the law. That's not what the law is. And so, and I guess this is an issue that the court will have to take up as we proceed during trial, but just wanted to alert the court because there's been some argument in the past that the defense is trying to rewrite the law in this case, and that's improper. Unless the court has any questions, John. Thank you.
So I want to point this out because, yes, they are allowed to criticize it, but you do that by drawing out the facts that, like, what they should have done, what they didn't
Just to go through
do,
quickly
and so
each of the
forth.
issues, 'cause
Not
some of
by,
them are premature. and
I
we
think
can
this was
push
a
them
bad
off.
investigation.
Probably won't raise issues. But to
Rando's
start with
opinion doesn't matter.
The testimony of Mr. Schilling. Mr. Schilling signed the probable cause affidavit in this case. He was an investigator in this case, just like Detective Hancock and the others. And there hasn't been a criminal defense case in the history of criminal defense cases where the defense lawyer didn't stand up and say the government's investigation was biased or improperly motivated or incompetent. That is Hornbook law. Why didn't you follow down this lead? Why didn't you put the gloves on? Why did you turn the lapel video off then? Why didn't you turn it on? These are all issues that are central
Yeah, you
to
get to ask
cross-examination
those kinds of
in a case
questions,
to challenge
but you ask
bias,
them of the
improper motive,
investigators.
or incompetence. We've cited dozens of cases to you, Your Honor, cases where this wasn't admitted and it was reversible error. Schilling is part of the investigation. He's relevant to bias, motivation, and competence. He should not be excluded, number one. With respect to Sheriff Mendoza, we don't presently intend to call him. It's premature, I think, to exclude him. To the extent we want to call him, circumstances come up where it's appropriate. We'll raise that with you, Your Honor, in advance. But as of right now, we don't presently intend to, so I'd ask that you hold off on ruling because it's premature. With respect to biographical information, we don't intend to present biographical information, Your Honor. Don't think that's an issue. With respect to the evidence of what Mr. Baldwin's subjective knowledge was, we don't intend to argue that we are the givers of the law. Your Honor will, of course, instruct the jury as to what the law is. We do intend to argue that Mr. Baldwin didn't have subjective knowledge of a substantial risk to Ms. Hutchins' life because there wasn't a live bullet. In his mind, he didn't think there was a live bullet in the gun. You'll instruct the jury what they do with that.
That's going to
But
be the
that's certainly
issue.
something we should be able to
Is
argue
every gun a
as to
loaded
his state
gun
of mind.
for
We
safety
won't tell the jury
purposes
instructions. We won't
or
tell them
not?
what to do. You will, of course, do that, Your Honor. And so you
Because
should deny
it's
the motion with
foreseeable
respect to that issue.
that mistakes happen.
We don't intend to raise that either, Your Honor.
Thank you.
And again, if it comes up where there's a circumstance where it's appropriate, we don't foresee that at all, Your Honor, then we'll raise that with you, but we certainly don't intend to raise that.
And get garnering sympathy?
Same thing, Your Honor. We don't intend to raise those issues.
Okay, thank you.
You're welcome.
All right. The court rules and reasons as follows. The court finds that Robert Schilling's testimony regarding the Santa Fe County Sheriff's Office investigation as to what he saw and learned during the investigation is relevant. The state will present evidence of its investigation and how Mr. Baldwin came to be charged as a defendant for involuntary manslaughter. Mr. Schilling's testimony addresses that part of the state's presentation of evidence at the trial, and the investigation is of consequence in determining the charges against Mr. Baldwin. The probative value of his testimony is not substantially outweighed by a danger of unfair prejudice. I will reserve on Sheriff Mendoza. Nole prosequi is stipulated to that it will be not introduced. The garnering sympathy is stipulated to that it will not be introduced. And I'm not going to, certainly you all can describe an opening statement what you think the facts are intended to show, and I think that you can describe what Mr. Baldwin's state of mind was without going into the elements. Okay? So it's granted and denied in part. All right, next up, This is state's motion limiting number 3.
So the ruling,
Defendant Alec Baldwin's motion in limine to preclude argument, testimony, and evidence relating to Baldwin's role as a producer.
It's the defense
they
motion.
really
Yes.
don't want this coming in.
Did we?
They do
Yeah, I
not
just did yours.
want
Now it's theirs.
the state being able to argue he had control over the conditions on this set.
Your Honor, the state intends to introduce evidence of Mr. Baldwin's role as a producer, even though Mr. Baldwin's role as a producer happened leading up to October 21st. As I just said a few minutes ago, Ms. Johnson told you nothing that happened before October 2021 in those civil cases is at issue here. The whole of the negligence, October 6 to October 21, that's the civil cases. That's not why we're here today. But the producer evidence is everything leading up to October 2021, October 6th through the 21st. They're trying to hold Mr. Baldwin responsible for what he did as an actor on the 21st because they claim he was reckless as a producer leading up to that time. That's a theory of vicarious liability in the criminal law that is not recognized.
It's not vicarious liability.
It's
He's the
also
same guy
far more
wearing two
prejudicial
hats.
than it is probative. Because the jury's going to hear about what a producer does. They're going to hear about the producer being the boss, the buck stops with him, etc. And the risk is that they think Mr. Baldwin's responsible for what he did on the 21st because he's the boss, he's the CEO, he's in charge. But that's
Yeah.
not a theory of liability, Your Honor.
Well,
On
it
top
is.
of that, there's no evidence at all.
Goes
You won't
to
hear
his
any,
knowledge.
that he hired Hannah Gutierrez-Reed, that he set the schedule, that he set the budget, period, full stop. What else did you hear? The state said Mr. Baldwin's role as a producer shows that he was keenly aware of the safety standards. 2 issues with that, Your Honor. The state has said repeatedly in this case that Mr. Baldwin didn't violate the safety standards under Safety Bulletin number 1. He violated New Mexico law. They said that, page 29 of their opposition to our motion to dismiss the grand jury indictment. The fact that Mr. Baldwin was a producer is entirely irrelevant, highly prejudicial. It should be excluded.
I don't think that's correct because I'm pretty sure the OSHA report that they're going to be talking about pretty quickly here said they
Your Honor, as
violated
the court
safety
is aware,
standards.
relevance does not exist in a vacuum. So the evidence that the defendant was a producer is relevant to demonstrate to the jury that as a producer, he is aware of his safety obligations, the safety duties, and there will be evidence of the bulletin number 1, which sets out movie set safety rules, and how Mr. Baldwin indeed violated those. I think what Ms. Morrissey indicated in her response is that he did violate New Mexico law. But to demonstrate that the defendant's conduct was reckless on set, the state is also going to introduce evidence that he violated these set safety rules that are in place for actors and producers to follow. The arguments of defense, they go to the weight and not to the admissibility. They can cross-examine the witnesses because many state witnesses are going to testify that the defendant was the boss on set. And Your Honor, with regard to what this is relevant to, it's relevant to his recklessness. Because we have to establish, again, it's not just in a vacuum, that the defendant's conduct on this set was reckless, and therefore, on October 21st, he should have been aware that his conduct of pointing a firearm at another human being, cocking that hammer, and pulling that trigger is reckless conduct. And so I think that both sides quoted the producer agreement. There are no limitations to this producer agreement. And it goes to the issue of the defendant's reckless state of mind. And Your Honor, I just wanted to briefly address something that I think was relevant to the
Tell me what the safety bulletin says that the producer, you're referring to bulletin number 1. What are you relying on?
Well, there are a number of requirements as it relates to firearms, that the actor and producers are responsible for the safety of others on set, for the safety of themselves and of others on set, that they are to treat a firearm as though it's always loaded. Do not point a
number
firearm
1.
at another person.
I thought that was for the
That is also, it's for both, Your Honor. These are set safety rules.
But what about, so you're not even relying on that?
We are, Your Honor.
In your response, you said that you weren't talking about the SAY guidelines, you were talking about New Mexico law.
Well, Your Honor, I think that these are two different issues that are being conflated. So Mr. Baldwin is charged with involuntary manslaughter under New Mexico law. And how do we prove that? We prove that by demonstrating his conduct, not just on October 21st, but in the days leading up, that by violating these on-set movie set rules, that his conduct was reckless. Because it's not recklessness in a vacuum from
You're talking about the gun, okay? So tell me what you think he did wrong as a producer.
So not just about the gun, Your Honor. So there are two, and that's what I wanted to address. There are two components here. So we have his conduct as it relates to the gun, but then his conduct as it relates to, for example, rushing the armorer to reload that gun. That goes to demonstrate his recklessness. There's no regard for the safety of other people. When you're rushing the armorer to reload this firearm, mistakes can happen. And so with regard to his producer role, there is evidence that will be presented that Mr. Baldwin, as a producer, should be aware of all of the safety regulations.
So I did have trouble wrapping my head around this, as you can tell, okay?
I understand.
So the jury's going to hear this and they're going to go, well, Mr. Baldwin was the actor that was rushing, but he was also being a producer at the same time.
It goes to, Your Honor, because it goes to the recklessness. So he is a producer, and his contract states he's also the leading actor. So he's got a dual role, and with both roles, he fails in maintaining the safety of other people.
He's got
See, what the
standards
defense
that
is
apply
trying
to both
do
roles.
is just basically pigeonhole Mr. Baldwin as just an actor who relies on everybody else, and he relied on this armorer to not give him a gun with a live bullet. But his role as a producer requires him, there are more duties imposed on him as a producer. And those duties include, and there's expert testimony that will be presented, that his duties as a producer, well, I understand, Your Honor, but if the court allows the expert testimony, the state will present evidence that the defendant had not just his role as an actor, but as a producer, it's heightened in the sense that he is supposed to be aware of the regulations, of the safety, and that's the most important thing.
I'm just having trouble with this. Okay, I don't understand how you're going to say as a producer he shouldn't have as an actor and a producer he shouldn't have he shouldn't have said quick move.
Well, but so as an actor, of course, he shouldn't have done that, but also as a producer, Your Honor, he is the boss. And as the boss, he is responsible for the safety of other people. So it goes to his state of mind, his willfulness.
I don't know that telling them to be fast
He essentially
is like super reckless. I don't know that I really buy this argument.
Failed the people who worked around him. And it gives him the power to control the safety. So as the producer, he has the power to control safety on set. And there was a tremendous lack of safety on this set. And so as the boss, he's emboldened to do whatever he wants to do. So this goes to the willfulness that the state has to prove.
Producer to do whatever he wants to do.
Because you're going to hear testimony from witnesses, if the court allows this, who will say he was the boss, he was calling the shots, he would rush people because without regard.
Maybe that's his personality as an actor.
Well, but that's irrelevant, Your Honor. With regard to his role as a producer,
She needs to make that
he
link.
has responsibilities, and he has a responsibility to maintain the safety of this set. Whereas an actor, perhaps those may be lessened, but as a producer, those are heightened. And so it's relevant to demonstrate his willfulness, the willfulness of his conduct, that on October 21st, he once again disregarded the safety of Ms. Hutchins and Mr. Souza and pointed that gun directly at Ms. Hutchins. And so that is why this is relevant. We can't look at this in a vacuum. And in fact, the court in State versus Duncan noted that relevance does not exist in a vacuum. Instead, it's the logical relationship between evidence and a proposition and issue that the party seeks to prove. We have to prove willfulness. We have to prove recklessness. So in order to do that, the fact that he was a producer and the boss is absolutely
Let
relevant.
me ask you something. So in the involuntary manslaughter, with respect to the first negligent use of a deadly weapon, okay, that's not the producer, that's the actor.
That is the actor, but he's also charged in the alternative.
The alternative, that he failed to check the gun.
It's more than that.
Well, that is what was given to the grand jury, that he failed to check the gun and pointed a loaded gun at a person. That's what it was in the grand jury. So you want the producer, you want to introduce that he was the producer and what he was required to do to be able to prove that alternative theory that he was supposed to check the gun.
Well, and that he wasn't supposed to point it at another human being and to pull the trigger. And so, and as a producer,
How does his role as producer, as a producer, he wasn't supposed to do that?
well, his role as a producer goes to what he is required to know when it comes to safety of others. He has a responsibility to ensure the safety of other people. So it goes to the issue of his willfulness, that on October 21st, when he points that gun at Ms. Hutchins, he should know that as a producer, he's responsible for her safety, because that is one of the things that producers are responsible for, safety on set.
I don't think they're arguing this very well.
Lack of safety on the
I'm not
set.
convinced
Mr.
this
Baldwin
is what
should have known
makes
that by
his
his
producer
action,
role
of what he
relevant.
did, moments leading up to the shooting of Ms. Hutchins, essentially show a willful disregard for his safety and recklessness. So it's not a theory of prosecution, it is evidence that goes to prove an element of the offense. And we would respectfully ask that the court allow the introduction of the fact that he was a producer, and that as a producer, he has obligations to ensure the safety of others.
And who's going to be your expert witness on that?
May I have a moment, Your Honor, to confirm?
Yeah, I don't see he was rushing people on
So we have
set
two
as being
witnesses, Mr. Carpenter, who testified before the grand jury. In fact, he testified about the producer
But
role.
for cause.
And then Kent Jorgensen, who is one of the individuals involved in drafting and updating the safety bulletins for onset
You
safety.
know that Brian Carpenter was not an expert admitted as a producer in Hannah Gutierrez. He was a firearm expert. And he has not been admitted as an expert because there was no judge to get him to be an expert at the grand jury. So he has not, at this point, been admitted as an expert as a producer.
Right, and we would tender him. Obviously, the court will have to do its gatekeeping duty and role. Mr. Jorgensen, however, and in fact, I think there's a motion pending about Mr. Jorgensen, but Mr. Jorgensen is also an expert on this. He's familiar with what the safety guidelines require of producers and of actors. And so these are germane issues that the state is required to prove, and we'd ask that the court allow the state to introduce this evidence.
Thank you.
To me, they need some kind of direct link from somebody saying we were pressured to not do safety protections by him.
Your Honor, I
Because he
hardly
was the
know where to
producer?
begin, because I honestly don't understand the theory or the facts that they intend to articulate.
But I'm
to
not sure we have
demonstrate
that.
On October 21st, Alec Baldwin, the actor, committed involuntary manslaughter. They said, well, the safety bulletins explain that. Two things. Number one, they already said in their response that the safety bulletins weren't violated, New Mexico law was. Number two, look at those safety bulletins carefully. I'm sure Your Honor's read them many times. They say nothing about the producer not pointing the gun. They say the exclusive responsibility of gun safety is on the prop master, the armorer, the first assistant director. Doesn't say anything about a producer. There are a number of actors doing the same exact thing that was required by the safety guidelines. Those are SAG guidelines for actors, armorers, the first assistant director, and the prop master. They say, well, maybe it's because Mr. Baldwin was rushing before October 21st, and there, as a producer, I'm not sure what that distinction is, producer, actor, and therefore on the 21st he was.
It has to do with his
But you
authority.
just excluded the evidence of him rushing because that's propensity evidence, that's inappropriate. The fact that we're so confused about what the theory actually is goes directly to the prejudice that will far outweigh the probative nature of this testimony. And we'll get into Mr. Jorgensen and Mr. Carpenter later, unless Your Honor wants to hear about why they're not qualified to testify as experts on producers. I'm sure we can push that on. But the reality is this will confuse the jury. This will be highly prejudicial. They want to show that he's the boss, and therefore on October 21st, as an actor, he committed involuntary manslaughter. That is highly prejudicial, inappropriate evidence, should be excluded.
To me, his role as a
What I think is
producer.
more appropriate is I'm going to revisit this, make my ruling, no more argument on it. But I think that we should do the well, you didn't raise, Mr. Carpenter, except duplicative testimony. And
No, that's just the cumulative expert motion, Your Honor, that's correct. We raised Jorgensen.
Right.
If you want to do Jorgensen now, I'm
Right.
happy to come back up and talk about Jorgensen.
all right, let's do Jorgensen.
Okay.
Okay. Well, anyway, because it puts him on notice that safety conditions are not being satisfied on set.
The state
That's
intends
what the
to
producer
offer
role.
Mr. Jorgensen on two issues.
To
One
me,
is the
should do.
role of a producer in managing the safety of the set, and the second is the safety bulletins that govern actors on movie sets. Mr. Jorgensen should be excluded. First things first, on the evidence of producer, his opinions on producer. Mr. Jorgensen has never been a producer in his life. He was a camera grip back
That's not
25,
persuasive.
30 years ago. Never been a producer. We asked him, what is the basis for your testimony as to what producers do, know, what their obligations
There's
are
all
on a
kinds
movie
of
set?
people that
He
study
said,
things
well, it's
they
because I
become
get to sit at
experts
the
on."
kids' table, these are his words, and listen to the adults talking.
You know how many
Your Honor,
cops
this is
come
not the
in
kids' table.
and
This is the adults'
testify as
table. Mr.
experts
Jorgensen has
about
absolutely
gangs
no expertise.
when they've never
and
been a
sitting at
gang
the kids'
member?
table doesn't allow him to sit over there and give testimony about what it is a producer is required to do on a movie set in a criminal trial on involuntary manslaughter, number one. With respect to the safety standards, Mr. Jorgensen didn't draft the safety standards. He's not a gun expert. He was a camera grip. Sets up camera angles and scaffolding, etc. He is not a gun expert. He's not an armor. He's never been a prop master. He's never been a first assistant director with the safety obligations. His role, as he described it, is administrative. They want to draft safety guidelines. Mr. Jorgensen says, I'm going to go find gun experts. I'm going to delegate the drafting of safety bulletins to gun experts. They're going to draft it. Not Jorgensen, the gun experts are. And then the gun experts are going to send it back, and Jorgensen wordsmiths and edits. But it's the gun experts who determine gun safety standards on movie sets, not Mr. Jorgensen. He has no basis to offer an expert opinion about gun safety standards, what the standards mean, how they're supposed to apply, because he didn't draft them. He's not the expert. He doesn't know anything about them other than how they got drafted. But how they got drafted is not an issue in this case. His evidence, his opinions should be excluded.
Oh, we
Your
finally
Honor,
get Morrissey.
Mr. Jorgensen teaches producers about their responsibilities with regard to set safety. He's going to take the witness stand. He can outline his experience, the position that he holds that allows him, that puts him in the position where he teaches producers about set safety. So I want to be clear. I am not calling Mr. Jorgensen so that he can come and just generally talk about this is what a producer does. I am calling Mr. Jorgensen to come in and talk about the producer's responsibility with regard to set safety. And Mr. Jorgensen is acutely familiar with this because he actually teaches producers what their responsibilities are and how they can have a safe set and avoid getting sued for killing someone. So we've got that as the first issue. Mr. Jorgensen is indeed one of the people who drafts the safety bulletins. I'm not sure where the confusion came in. Mr. Jorgensen is the chairman of it's on the tip of my tongue, the industry-wide labor relations, it's on my computer, my apologies. So in that role, what Mr. Jorgensen does is, here's how it works. Representatives from all of the different film unions come together. So we've got somebody from the Directors Guild, and somebody from the Producers Guild, and somebody from IATSE, and that's who Mr. Jorgensen is. They all get together and they agree and draft these safety bulletins. Mr. Jorgensen is one of those people who sits at the table, who drafts these safety bulletins. So his testimony is entirely relevant, one, because he actually drafts the rules that Mr. Baldwin is required to follow, whether we're talking about him as a producer or an actor or anything. And number two, Mr. Jorgensen sits with people from the Producers Guild of America to sit and discuss these safety bulletins and whose responsibility is what, in addition to teaching producers how to do this. So I think that his testimony is absolutely relevant with regard to, these are the safety bulletins. He lays a foundation for the safety bulletins. These are how the safety bulletins are created. This is a safety bulletin. This safety bulletin says, don't point a gun at anyone. Keep your finger off the trigger. Assume that anything that you point the gun at will be destroyed. Those are the safety bulletins that Mr. Jorgensen participates in developing. So his testimony is wholly relevant. Now, whether or not the court decides that Mr. Jorgensen's testimony with regard to a producer's responsibility as it goes to set safety is something that I think the court has indicated that you may want to reserve ruling on until you see and experience how the trial is unfolding. But there's no question that Mr. Jorgensen gets to come in and testify about the safety bulletins that he himself participates in drafting. Thank you.
Well, I don't know about that, because it's up to the judge.
Just a few points, Your Honor. The fact that Mr. Jorgensen is allowed to teach at some university about how people shouldn't get sued in civil cases, it doesn't make him an expert in this court. He's never been a producer. He's not an expert in being a producer. The kids' table doesn't allow him to sit at the adults' table.
The
Period, full
kids'
stop.
table.
He also is not a gun expert. Didn't draft it. They're going to have Mr. Carpenter come and testify about safety standards with respect to using the weapon, pointing it, not pointing it. Now they want a cumulative expert, Mr. Jorgensen, who doesn't actually develop the guidelines. He's not the gun expert. He admitted that. He doesn't develop the standards. He said, I hire gun experts to draft those standards. They're going to have two experts, one of whom clearly not qualified on gun safety, Mr. Jorgensen, testify, and then put Carpenter in too. This is a afternoon, a day of testimony of cross. We already have a short schedule, Your Honor. You should limit this testimony. He's not qualified to give opinions on these issues.
The court makes the following ruling. The court will accept Mr. Kent Jorgensen to be able to testify before the jury as to what the guidelines say, but he has no qualifications to opine on what a producer does. He doesn't know how a producer implements those guidelines. So he can say these are the guidelines, but he needs to be a producer to say, this, as a producer, this is how I follow, this is how I meet these requirements. The other thing noteworthy about Mr. Jorgensen is
So she's
that
going to keep out the
based
producer
upon his
stuff.
pretrial interview, which is what would have been the time to let the state know, or I mean the defendant know what he was going to testify about, he was all over the place. And basically, he was like, well, I relied on Ross. I didn't talk to anybody. So yes, he will have hypotheticals about, and he may maybe sit over there in the gallery while he's and listen so that he can opine. But I think that that interview indicated on top of it that my finding that he's not qualified to know what a producer does. So he can testify about the SAG guidelines, but he cannot opine on whether what Mr. Baldwin did as a producer was good or bad.
I think it's fair if she's saying he personally isn't qualified.
I'm going to
If she's
revisit the
saying
producer.
You have to be a producer
I'm
to
going to
be
make the following
qualified.
finding.
I don't agree
I'm
with that.
having real difficulty with the state's position that they want to show that as a producer, he didn't follow guidelines, and therefore, as an actor, Mr. Baldwin did all these things wrong, resulting in the death of Helena Hutchins, because as a producer, he allowed this all to happen. I think that when you look at the relevancy, I think that one of the reasons why I think I'm having a hard time wrapping my hand around it, to be able to say, Mr. Baldwin, because he was a producer and he was the boss, although there are more than one producer, and he couldn't do anything without, looking at those contracts, he couldn't do a thing without running it by, including hiring somebody, without running it by whatever that entity is in the contract. But I do not believe that it has any tendency to make more probable than it would be without the fact that Mr. Baldwin individually as an actor committed involuntary manslaughter through negligent use of a deadly weapon and the alternative theory. The probative value is not substantially outweighed by unfair prejudice and certainly confusion
So yeah, she's going to exclude it.
of issues to the jury. So I'm
The way they
denying
argued it, I gotta
evidence
agree with
of
that.
his status as a producer.
I don't feel like they made a very good argument
All right.
for why it
Shall we
would matter.
continue?
Just that he rushed people on
All
set.
right, so we're going to the states now. That was Mr. Baldwin's motion. We have Jorgensen, we finished. All right. State's motion eliminating number 6 to preclude accusations of prosecutorial misconduct.
They should just concede this one too, honestly. You don't get to
Your
argue
Honor,
that to the jury.
Unfortunately, in this case, this case has been fraught with numerous accusations of prosecutorial misconduct. And they were raised in the context of motions to dismiss for constitutional violations. They were raised in the context of motions to dismiss the grand jury indictment. The court has ruled on those. Those allegations were perhaps relevant to those legal motions, but they're not relevant to what the jury is required to find. So I would respectfully submit, Your Honor, that the court preclude the defense from making arguments to the jury about prosecutorial misconduct and that the state did X, Y, or Z and it was unethical or improper, because that, number one, is irrelevant. Number two, it would be more prejudicial than probative. It also invites jury nullification. And that would be the main issue I would submit to the court, that the defense would be introducing this. And I noted on page 4 of the motion the allegations, for example, that obviously the jury's going to hear about the accidental discharge test that resulted in the damage to 2 internal components of that firearm. But to argue to the jury that that resulted in a constitutional violation to the defendant's rights is improper. The court has ruled on that motion.
Yeah, she's right about that.
There have been numerous allegations of discovery violations
None
and
of it matters.
disclosures, and that they were designed to prevent the defendant from receiving a fair trial. Again, those are legal issues that the court is going to be deciding and has decided and have no place before the jury. That the prosecution conspired with law enforcement to intentionally damage this firearm, again, that went to the Trombetta motion that the court has already ruled on.
There's another issue that there was a meeting you heard about in the motion hearing that Mr. Haig, Lucian Haig, had a virtual meeting with Mr. Ziegler from the FBI where counsel were present. And during that meeting, he asked Mr. Ziegler how he conducted the accidental discharge test. Now, while that is a proper area of inquiry for cross-examination, any implication that that was improper or unethical should be precluded, because under Rule 703, experts can confer with other experts in forming their final opinion. And there's nothing wrong with that. And so I had to bring this motion to the court, Your Honor, because I am concerned that there will be, throughout this trial, numerous allegations that the state has engaged in misconduct and in trying to deprive the defendant of his right to a fair trial, and those have no place before the jury, and we'd ask that the court preclude that.
From my perspective, yeah, this should be granted, and the defense shouldn't even argue it. Let's hear why they think it's going to come in.
What we intend to do and what we don't intend to do. This is not going to be a trial about the ethics of the prosecutors. It's not going to be a trial about they should have dismissed the case a long time ago. They did. They took it back. Well, none of that's coming into this trial. No intention. What we intend to do is exactly what I discussed we were going to do with Schilling, for example. We're allowed to demonstrate that bias, improper motive, incompetence of the government investigation. We're allowed to attack the credibility of witnesses as it relates to the government investigation. For example, Your Honor already ruled that with respect to that meeting between Mr. Ziegler and Mr. Haig, that gets to be disclosed to the jury. In fact, the prosecutors are required to disclose it to the jury, you ruled. And so all of that goes back to the black letter law that we started with on that prior motion in limine. We're allowed to demonstrate the bias, the incompetence, the improper motivations. We're allowed to attack credibility. We're allowed to attack the fact that the FBI destroyed this gun.
Among the investigators.
Et cetera, et cetera. All of those issues
You don't
are
get to
fair
say
game,
the
Hornbook
prosecutors
law.
engaged in misconduct.
We intend to introduce that. The state shouldn't be allowed to
You
preclude
get to
it.
get to the underlying facts
I
of
have
the
nothing further, Your Honor. It's
investigation.
black letter law.
Any reply?
Just briefly, Your Honor, I think we may be in agreement. I think what the reason for this motion was essentially to preclude the defense from essentially making personal attacks and allegations of prosecutorial misconduct. We agree, and we will present evidence about the Ziegler-Haig virtual meeting, about the gun. But we just ask, given the contentious nature of this case so far, that we focus on the evidence and not on allegations, personal allegations and attacks during this trial.
All right, thank you. The court rules and reasons. The court agrees that the prosecutor's misconduct as alleged by the defendant in his pretrial motions may not be brought out at trial. The misconduct is not relevant evidence, and even if it were, its probative value is substantially outweighed by the danger of unfair prejudice and confusing issues. However, to the extent that the defense may elicit evidence about the Santa Fe County's investigation, the FBI testing, the Haig's 3 reports, and his meeting with Ziegler, this evidence is relevant as it makes a fact more or less probable, and the fact is of consequence in the action. And weighing it, the probative value of the evidence is substantially outweighed by danger of unfair prejudice, etc. All
Yes.
right.
We didn't
Thank
need to
you.
spend 15 minutes
Now
on
we're
that
going
one,
to,
but we did.
let me just back up and do these two that. Is that it? State's motion in limine number 4. Let me just make sure I haven't missed one. Okay. State's motion in limine number 4, which is no reference to the potential punishment in the case.
There's no issue, Your Honor.
All right, so that's
Good.
agreed, stipulated. State's motion limiting number 5 to prohibit the defense from arguing to the jury examples of the definition of reasonable doubt.
No present intention to do so. I know we'll discuss reasonable doubt, but those random hypotheticals, I don't think the court should preclude the defense from arguing anything that they choose to, where you decide the law as long as it's relevant. But we have no present intention.
You're not going to give them an example of reasonable doubt, okay?
Yeah, I have no present intention to do that.
Okay, and that doesn't come up, and that doesn't come up in voir dire either. Okay,
Hey, welcome to everyone coming over from Vices. And Jeff himself.
All right, where are we? We've got
Hey,
defendant's
everybody.
motion in limine number 4 to preclude improper expert testimony from lay witnesses.
Thank you, Your Honor. The state wants to admit evidence from the camera grip, for example, about how dummies are made, safety standards for armors on set, safety standards for producers, etc., the camera grip. It wants to have the medic testify about the standards for armorers on set. This is improper opinion testimony that can only be given by an expert, not by a lay witness. The state cites the State versus Vargas case, Your Honor. They say it's a two-part test. Part number 1 is, can the lay witness testify about it based on personal observation? Part number 2, can the lay witness rationally connect their personal observation to the opinion testimony? They say they can, because the medic has been on movie sets, it's personal observation. What the state overlooks is that before Vargas states that two-part test, it actually addresses a third one. That's the third prong of Rule 701, which says a lay witness cannot give testimony if it's within scientific, technical, or specialized knowledge. So Vargas says, testifying about movie standards, safety standards, armor standards, how dummies are made, the things that the camera grip and the medic, they want them to testify about, are within the specialized knowledge of someone on a movie set. As Vargas put it, it has to be only within the common experience and knowledge of a lay person. Now, how do we know that that testimony is not within the common experience and knowledge of a lay person? Because the state says so in its other motions. And I brought my notes up here so I can get the language exactly right. In one of its in limine motions, with respect to the cumulative expert testimony, that's motion in limine number 8, here's what the state says. Many people, like many jurors, are not at all familiar with safety protocols on movie sets. And many of the state's experts are being called to educate the jury with regard to safe practices in movie sets. On the Jorgensen
If the
motion
state's got
that we just
experts,
went over,
then they
Your Honor,
should
let me
stick
read
with
from
the
that one too.
experts.
Safety bulletins and protocols on the use and handling of firearms on a movie set, as well as movie production requirements to ensure a safe working environment, are not within the average layperson's knowledge. They try to admit Mr. Carpenter's testimony on that too. They say this is specialized knowledge, expert testimony. They try to get experts in on it, but then they try to say it's just lay opinion testimony that the medic can offer, the camera grip can offer. They cannot have it both ways, Your Honor. And in fact, Vargas reversed a conviction when the court allowed that evidence. That was a police detective who was allowed to testify about his experience with a stun gun, how it was used, how it was made, etc. And the court allowed that at the trial level. The defendant said that's lay opinion testimony that doesn't satisfy that third prong. It has to be tested under Rule 702. The appellate court said, you're right, reverse conviction. That was an expert testifying because the average and common experience is not that of a detective. And so it had to go through the gateway of 702. The state has not offered, has not disclosed Ms. Schaefer, Mr. Looper, or any of the other witnesses on this set as expert witnesses. They never made that expert disclosure. And to the extent they did, we would have obviously filed an in limine motion to exclude them as experts. They weren't offered as one, so we filed it this way, as experts, because the medic doesn't have the expertise to testify about armor standards, or the camera grip doesn't have the expertise to testify about movie production requirements. We just went through that with Jorgensen. And so this is lay opinion testimony that violates Rule 701, that has not been offered under 702 or met the guidelines of 702, and therefore any witness that they want to testify about any issue outside of what they observed on Rust, what they saw in other movie sets, what armors do on other movie sets, what actors do on other movie sets, is improper opinion testimony that should be excluded when it's offered by these lay witnesses. Thank you, Your Honor.
The state should just concede this if they've got experts to testify about these things anyway. If you're relying on a layperson, you got a bigger problem.
If I were the defense, I'd want this testimony excluded also. And let me tell you why it's relevant. Mr. Baldwin, part of his defense, and he's made these statements repeatedly, is, I had no reason to think that Hannah Gutierrez wasn't a good armorer. I had no reason to think there was a problem here. This is what he says. He called Jason Bowles' office himself and said, I never had a problem with your client. I never had a reason to think that she wasn't a stellar professional. Well, Judge, you're actually in a unique position because you sat through the Gutierrez trial and you saw and heard the other people, the other crew members who worked on that set come in and say, we knew immediately this lady wasn't following the proper safety protocols. How do we know that? Because Ross Audiego has worked on 60 to 100 films and TV shows.
Experience can qualify people as experts.
Same thing with Lane Looper. Same thing with Sherilyn Schaefer. She's the set medic. She's paying attention to what's going on with regard to safety. These are not people who are being called as experts to come in and talk about set safety. These are people who are going to come in and say, we had safety concerns on this movie set because we knew from our experience, and by the way, this gentleman was the most experienced person on set, Mr. Baldwin. So if these other folks who had slightly less experience than him had concerns about whether or not Ms. Gutierrez was doing her job properly, this is the way that the state gets to combat the defense of there was absolutely nothing wrong with her. She was an amazing, stellar professional. This court knows that is absolutely untrue. So it is perfectly appropriate for lay witnesses to come in and say, I've been working on movie sets for the last 15 years or 20 years, or in Mr. Baldwin's case, 40 years. And I know exactly how these safety protocols work. And here's what makes it a little bit unique on a movie set, is that the safety protocols that take place between the armorer and the actor and the first assistant director is this thing that happens out in the open, where the armorer says to all of the crew members, all of these people who are going to come in and testify, hey, does anybody want to see the rounds? Does anybody want to come and see me load the gun? Because you're the people who are standing potentially in the way. So all of these crew members actually get to participate in the safety check, even though he's a dolly grip, as though there's something wrong with being a dolly grip, even though someone is a first assistant cameraman or a boom operator, they actually get to participate in that safety check because it is their lives that are at risk. So each and every one of these people should absolutely be able to come in and say, I noticed that Hannah Gutierrez wasn't doing her job because Mr. Baldwin has told everyone Hannah Gutierrez was a stellar professional. We're not asking them for a bunch of technical knowledge. Absolutely, I will tell the court, I am not asking any of these witnesses to come in and talk about the difference between dummy rounds and blank rounds. Absolutely not. These witnesses are coming in to talk about, in part, their safety concerns as it related to Mr. Baldwin's conduct and the conduct of Hannah Gutierrez, and we can't really separate those two out because Mr. Baldwin's defense is she was really good. I would also point the court to this is Farner versus, I don't know if I'm going to pronounce this correctly, Pakar. This is a federal case, 562 Fed 2nd 518. The admission of the lay witness's opinion that the Pakar suspension system was improperly designed due to its failure to incorporate the safety change was affirmed by the Court of Appeals. Much like the federal courts have allowed lay opinion testimony based on the witness's particular knowledge gained from their employment experiences, keeping in mind this is their workplace, so too should this court. There's a case right on point. Thank you.
Experience can qualify people.
Few issues, Your Honor. I'll talk about the cases first, and we'll go back to what Ms. Morrissey said she's going to try to use these witnesses for, and that's expert testimony. The Farner case, it's a design defect case. Farner was driving a truck. The truck suspension failed. There was an accident. Someone died. His widow, he did, and the person in the passenger seat. His widow sued the company that built the truck. She got a person who had driven, his name was Curtis, driven the same exact truck before. Not the same one in the accident, but the same exact make, model, etc. And he said, I drove that same truck. And you fix that design defect by wrapping these chains around the suspension. It was a design defect case where the question was,
I was
is
on the
that
same
design
set.
defect fixable?
Would seem
This
to
was
be
an expert testimony. This was fact testimony.
equivalent.
The same with the other cases, the Kate cites, the Valencia case, the Munoz case. Those are cases where the people worked at the company that was at issue in the fraud. And they were asked about that very company when you worked there at the company. What'd you experience? What'd you see? That's relevant to the fraud. They didn't come in and say, I worked at some totally different company. And my experience at that different company, I'm going to apply it here. That's not at all what happened in that case. This case is Vargas, based on the experience that these witnesses had in other movies. Ms. Morrissey told you they want to say, I've been involved in 40 movies before, and applying my experience there to this one, these are the safety problems I had. Even though there's A, that's expert testimony, because it falls right under that third prong, and number two, it is testimony that they are not qualified to give. There's nothing wrong with being a camera grip, Your Honor. If there's something wrong with being a camera grip and testifying about the safety bulletins for armors. That's exactly what 701 and 702 say, and Vargas says it's reversible to allow it to happen. I have nothing further, Your Honor. Thank you.
All right, the court makes the following ruling. A lay witness can testify if rationally based on perception, helpful to clarifying an understanding of the witness's testimony or determining a fact in the issue, and is not based on scientific, technical, or other specialized knowledge. Particularized knowledge is acceptable here, although I don't find it here on what they intend to do. Lay witness testimony of what they observed on set, providing that it's relevant, as compared to what they saw on other sets, makes a fact more probable than it would be without this evidence, and the fact is of consequence in determining the action. That is criminal negligence. It's they are not going to testify about the safety bulletins. They can only testify about what they observed on set, in this set, and what they observed on other sets, provided that they have a sufficient history to do so. However, again, we're going to have to decide relevance. Okay.
Understood.
Yeah, that seems
All right.
quite fair.
Court wants to take a bathroom break.
You get to testify to what is
Here
within
at quarter of. Okay.
your experience. People can have
Thank
unique
you very much.
experience that qualifies them. Hence, for example, the one I used before, police officers talk to a lot of gang members. They never actually been in a gang, but they'll come in and say, you know, they're an expert based on all these conversations that they've had with a variety of people about the culture and the, you know, processes and the structure and the symbols and just all that kind of stuff. So to me, this seems perfectly fair. Well, so, okay, let's work through some of these, because it's clear they are not going to let the state, she's ruled the state is not going to be able to rely on the fact that he was a producer in order to try to establish his liability. And just off of the argument that was made as to why, I think that makes sense, because all they really gave us was, well, he was rushing people. There needs to be something a little bit more substantial about how his authority as a producer did what? Is the argument that it contributed to the unsafe standards on the set? Is it an argument that he therefore was in a better position to know and or did know about all of these other things that were going on, these problems, these concerns that people had, and so forth, so that he then disregarded that. These would all, to me, be much stronger arguments for why his role as a producer would be a potential basis for him to be liable, because it would tend to establish he was in a position to know what the situation was, and he had a responsibility to correct that. But we got none of that foundation. It's just basically, well, he was rushing people. Well, yeah, lots of jobs rush people. I mean, look at truckers, okay? Look at commercial truckers. They get rushed all the time. All the time. Lots of people get rushed in their jobs. It doesn't mean that, you know what, the only way to respond to that is to cut safety standards. I don't see that. I don't see that they made a particularly good link between those roles. His handling of the firearm on the set, yes, that's not a prior bad act that gets excluded. That seems to be pretty much the heart of the issue in this case. Was he being reckless with this firearm? And that's going to come down. It's going to come down to the jury's perspective on what did the rules tell him? What safety standards were in place to try to prevent situations like this from happening? There is no magic halo that surrounds a movie set that makes it somehow safer to handle firearms in an unsafe manner. And so this is why there are so many of these standards in place, because out at the range, you point a gun at somebody, even if, you've already checked it, it's unloaded, you're getting kicked out of that range, okay? Certain things are regarded as just intolerable because the risk of being wrong is so bad. And this is, from my perspective, what makes the firearm and the delegation of firearm safety very different than the counter example that I see used sometimes, like a vehicle. Like you trust your vehicle safety to a mechanic, right? Your brakes are getting bad. You take it to the mechanic, you trust them to fix it. The difference here is that the ordinary operation of a vehicle is not inherently unsafe. It's got extremely high utility. But it is still sometimes going to be foreseeable that there will be problems. And so I think a little bit better example that might make it a little bit more equivalent to how I personally see this situation with the firearm on set is if you take your car to the mechanic to get the brakes worked on, right, to get the brakes fixed, and the mechanic gives you the car back, problem solved. And you then proceed to speed your car at somebody standing in the middle of the road and then slam on your brakes and your brakes don't work. Is that all the mechanic's fault? No, it's not. It's not all the mechanic's fault, because you are the one who engaged in the unsafe behavior. And the question just then becomes, how foreseeable is it that something can go wrong with your brakes? You know, this is why people tend to not do extremely risky things like that, because it is very foreseeable. Yeah, something can go wrong. There can be a problem. There can be a mechanical failure. It's not that unusual. And with firearm safety, rule number one, as you know, anyone who handles firearms knows, is treat every gun as if it's loaded. You treat every gun as if it's loaded because it is foreseeable that accidents can happen, that you can accidentally load the wrong round, that the chamber can be advanced not where you think it was. One of the cases that actually got me interested in being a lawyer in the first place, this was many years ago. I was working as a court clerk, a little jury coordinator in the El Dorado County Superior Court up there in South Lake Tahoe. And there was a trial. I'm trying to remember the name of the guy off the top of my head because I just can't remember it now. There were all kinds of articles about it at the time. Anyway, this was a young man. I think he was 19 or 20 years old. Seemed a little bit not socially all that well adjusted. He would hang out with a lot of younger kids and kind of try to impress them and stuff like that. Didn't have a lot of his own kind of peer group that he associated with. This gentleman worked as a security guard, and because of that, he had a firearm for his job. And so one night, they're having a party at his house. This is a revolver, like we're dealing with here. Double action, though not single action, but it doesn't really matter for purposes of this example. And so he decided he was going to show them this very fancy trick. And so this very fancy trick is if you load a bullet into the top cylinder of the gun, right, and close up the cylinder, every time you pull the trigger on a double action revolver, it advances the cylinder before it fires. And so if you have the gun loaded correctly in this, bullet is in the top chamber, you can pull the gun and pull the trigger. In this case, it was, I think it was a 5-round cylinder. You can pull the bullet, you can pull the trigger 4 times, click, 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 click. It won't fire, because it's not until the last time that the trigger pulls that the cylinder will advance to the live round. So he does it. Points the gun at his friend, pulls the trigger, bang, 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 bang. Last time the gun goes off because he hadn't gotten it in the right cylinder. So this is foreseeable kind of stuff that things like that can happen. And so that's why it's so important to always be just so extremely cautious when you're handling a firearm. And there's no magic halo on a set that is going to protect people from consequences of things that ordinarily happen. And the problem, unfortunately, is that other people's negligence, other people's mistakes, other people's accidents, these are foreseeable. They can happen. And that's why you have to be overly cautious to make sure that you're not just taking for granted that everybody else is looking out for the safety here. I kind of take a little bit of an issue with these standards anyway, just to the extent that they have diffused the responsibility for the firearm safety so thoroughly that it kind of lets everybody off the hook. The problem is that if everybody in the line of the safety practices does their job, then you're never going to have an issue. But the problem is when everybody fails, which is kind of what it seemed like happened here. Everybody failed. The armorer failed, the assistant director failed, and the actor failed. Then who do you blame? They all just get to point the fingers at each other and say, well, because because that person didn't do their job, it shouldn't matter that I didn't do mine. I don't buy this argument personally. You're all responsible. You all failed. You all had standards that you were supposed to follow, and you didn't. So now with Mr. Baldwin, I think the issue is really going to come down to the question of whether he went off script. My understanding of what the situation was that day, he was not supposed to have his finger on the trigger. He was not supposed to be cocking the hammer. They were setting up a shot where he was supposed to remove the gun from his jacket, basically, and point it in the direction of like towards the camera. And so the set and the people in charge of safety on the set are going to be designing the safety parameters for that particular shot, given what's supposed to be happening in the scene. So if he's not supposed to have his finger on the trigger, if he's not supposed to be cocking the hammer, well, the risk of an accidental discharge is quite a bit lower. Whereas if you know he's going to be pointing it over here, he's going to be firing the, even if it's a blank, even if it's supposed to be a blank, we still know you get people out of the way, out of the target zone if that trigger is going to be pulled. So if he went off script, I think that's going to be a real potentially dispositive fact in this particular case, because you would know that the reason the safety standards have been set up and directed in a particular scene are based on what is the risk to the people on set as a result of what's supposed to be happening in that scene. The scene suddenly changes without notice when there's a firearm involved. Well, that changes a lot of the safety dynamic. Just changes a lot of the considerations there. So I don't know that it really matters one way or another here, whether they, talk about his role as a producer or not. If they had some evidence that like he knew there was all this stuff going on behind the scenes with like target practice, as has been alleged, live ammunition on set. Like if he knew any of those things, well, yeah. I mean, I don't know that it even matters if it's because he's a producer or not. Just knowing it, even if you're on set, it's not necessarily your job to know, but because you see it happening. I mean, that would be relevant. But I just don't think they have that. I didn't get any indication here that was kind of part of their justification of suggesting that being a producer, I don't know, made it like more reckless or something like that. So Jorgensen gets to say what the SAG guidelines are, but not to opine on what producers do. I don't know that I necessarily agree with this one. Although I guess if he's, we just didn't necessarily get a very good foundation from the argument here about how does he know, and how does that relate to then what Alec Baldwin would know or should know based on his having been in that role of being a producer. I think it'd be one thing if Jorgensen is the guy that did the safety training on the set. Clearly that would seem to be a different situation. But just this is what safety training for producers is supposed to be like. I don't know that that's really helpful, because if you haven't established that Alec Baldwin had that actual safety training, it doesn't help you. It doesn't go to his knowledge of what the correct practice should be, and therefore, the state's allegation that he fell short in that way. So this ruling, I think, to me, makes sense, seems appropriate. Yeah, you can talk about the guidelines, what the guidelines are, because that is something that he, should have had notice of. But other than that, it would be kind of trying to impute something to him as far as knowledge that I don't think there's been a fair basis to establish that he would have that. The prosecutorial misconduct, stupid art. I don't even know why we wasted time on that one. Everybody knows you don't get to argue. You don't get to argue that stuff. These were pretrial motions. It has nothing to do with the jury's decision. Attack the facts of the investigation all you want. But this is just kind of part and parcel with, this has been a pretty high conflict pretrial process. Like these lawyers, they do not like each other. So everybody's kind of gotten a little taste of everybody. Erlinda Johnson is the prosecutor, the second chair, who's handling most of these arguments. I personally I'm enjoying her presentation. I think that it's pretty effective with how she makes her point, and she does it in a way that's pretty unemotional. Ms. Morrissey has a little bit more of a flair for the dramatic, doesn't she? She likes to kind of load things up and color things, and just generally speaks with a lot more emotion and a lot more. I think loading is just really the best way to put it. She characterizes things rather than just saying directly, this is what the facts are, this is what the evidence is. She wants to tell you what it means all the time, rather than just the basic facts. So people are going to have different reactions to that, is the thing. Some people will find it persuasive. Some people will find it very grating. I tend to be the type of person that you don't tell me what to think. Okay. I will decide for myself what I think. Just give me the facts, ma'am. So I don't particularly find that style all that effective, but that's just me, and I'm just one person. There's going to be a whole jury of people to be able to evaluate this. So now the defense team, I don't know who this second chair guy is that's been doing a lot of these arguments. I'm not sure if this is Mr. I think his name is Nikas. Alec Baldwin has a big legal team. He's got like 8 lawyers, 10 lawyers, something like that on his team. In fact, I've been kind of looking to see, there's a woman who is like the sponsor, the local counsel from New Mexico, because his whole team, by and large is not from New Mexico. They're from, other states all over the place, and they're admitted pro hac vice. So at least in theory, they're being supervised by this lady on the defense team who's the member of the New Mexico State Bar. Like, I can't say I've really seen a lot of her so far. I'm sure she's there in the courtroom, but clearly not playing a big role. But Alex Spiro, I do recognize. I have seen him doing a lot of the pretrial motions, and clearly a very skilled attorney as far as just being sharp on what the issues are, being aggressive. But I gotta tell you, his style really grates on me too. I don't necessarily love either of these primary lawyers, which is kind of I don't know. I mean, that's fair, right? I don't like either of them particularly. He just comes off to me as the sort of male equivalent of Carrie Morrissey. Likes to load things up, likes to characterize things instead of just being direct. One of the pretrial hearings that I watched was within just the last couple of weeks. They had a hearing where the prosecutor's firearm experts were there to testify, and he's just being unnecessarily jerky to these people. It's a pretrial hearing, so maybe it doesn't matter, and you're going to have this totally different demeanor in front of the jury, but I will say, if Mr. Yannetti got criticized for occasionally maybe coming across as too mean to the witnesses, if Mr. Spiro is doing what he did in that pretrial hearing I watched, if that's his mode with the state's witnesses, I don't think that's going to fly very well. Again, he's a very experienced and skilled attorney. He's done this a lot. He may have a lot of different gears that he's able to get into and just dig into that aggressive, that ultra aggressive side when it's really necessary to do that. Otherwise, play the, sugar attracts more flies kind of role. So we'll see. I'm going to give him a chance to overcome my initial bad impression of him from the pretrial hearing. But yeah, we are very slowly getting through these motions here. The first argument, make the prosecutor behave. I'm so glad that the judge called that out, because they're just the dumbest motions. They really are. They really are. The rules are the rules. And your job is to object if you think that there's a problem. The judge is not going to issue a blanket ruling saying everybody needs to follow the rules. Like, that's a given. So if you have a problem, call it out, and the problem will be dealt with. Let's see where we're at. So we're like about halfway through, maybe slightly less than halfway through. The motions that are still outstanding for the defense, they want to basically keep the state from being able to argue things that would be factually inconsistent from the arguments that they made in Hannah Gutierrez's trial. This is one of these situations that kind of makes sense, I think, intuitively. It definitely makes sense to lay people, right? You go convict somebody on one version of events, and then you go, convict another person on a different version of events. It doesn't seem fair. And in many ways, no, it's not fair. And yet it does happen. It does happen quite frequently. But the main reason is because the limits there are very broad. The prosecutors are not barred from taking inconsistent positions, from being able to argue different things from the evidence at different trials. And one of the issues is always going to be there's conflicts in the evidence. Sometimes you get different witnesses with different version of events in one case. And so you might be arguing under the circumstances of that case, here's why you might think this person is more credible than the other person. But that's ultimately a jury determination to make. Well, that doesn't necessarily prevent you from coming into another case and then saying, for different reasons, we still have this conflict in the testimony, but for these reasons, in this case, you might think this other person is more credible. Because again, it comes down to the jury and their ultimate determination of credibility. So a prosecutor's arguments aren't evidence. What they're really not allowed to do is to basically cherry pick what they present in order to, create a completely different factual picture of what transpired. Because that's basically going to be, you're not being fair to the first person if your evidence that you convicted them on, you are like implicitly suggesting in the second trial that evidence was bad or that evidence, wasn't correct. So it's a pretty limited restriction on them. I don't know that there is going to be, much that's at issue here, but we'll have to see. Maybe they'll spell it out more specifically what exactly they're concerned about. So limit evidence of the victim's character, pain and suffering, and autopsy photos. This is a fairly standard motion just because you don't want the prosecution over egging the pudding with things like she was such a wonderful person. They get to have some evidence of who the victim was and the fact that her loss is meaningful. But that's really about it. That's about all that you get to say, because it doesn't matter. It doesn't matter if somebody who died as a result of something like this. It doesn't matter if they're loved by everybody or loved by nobody. It doesn't matter. So the state will be allowed to present autopsy photos. They'll need to be typically tied into whatever the evidence from the medical examiner is going to be. Don't gratuitously display things, but yeah, it's very common for the medical examiner to rely on autopsy photos while they're explaining what their findings were, and so typically that's going to be okay. Defense argument motion to preclude argument about basically what happened to Brandon Lee on the set of The Crow. Unless it's relevant for one of the experts' testimony or something like that, then I tend to agree with that one. Yes, what happened to Brandon Lee is not relevant to what happened on this particular set. other than just the extent that it put people on knowledge that that accidents can happen, and that's why they have these standards in the first place. So in and of itself, is it relevant? No. But did Alec Baldwin know that that had happened and know that therefore there's reasons why you need to follow safety standards regarding firearm handling on set? I would think so. So that's the general parameters I'd expect around that one. They've started addressing the cumulative expert testimony. The state, according to the defense, has listed 13 experts, and many of them are overlapping. It's generally up to the state to decide how they want to present their case and who they want to get in certain facts from. And so if there are areas of expertise that they want to divide between a whole bunch of different people, they're allowed to do that. What they don't get to do is to bring on 13 people to say the same thing over and over and over again. This might be news to you if you were watching Karen Reed with all of the repetition that we had in that case. But this judge seems to have a little bit more of a tight leash on the courtroom. I think she's making that very clear that she intends to be the one in charge. So if things are not progressing and are getting unduly duplicative, then I would expect she would put the brakes on that. The defense wants to preclude what they're calling opinion testimony from Alessandro Pieta. This is the guy who manufactured the gun, the one that was involved. And so my understanding, this all goes back to the FBI testing when they were trying to recreate what Alec Baldwin said happened, which is that he cocked the hammer, but did not pull the trigger. And it fired, just fired inadvertently. So the FBI was testing this to try to see if they could recreate that circumstance. They could not. And in the course of their testing, they tried so hard that they basically broke some of the internal components of the gun that basically control the cocking, the hammer mechanism. And so in the course of evaluating all of this, the state had hired these additional experts to look at, okay, well, what is the condition of the gun now? What can we infer about the condition of the gun at the time of the shooting? Should have been documented by the FBI what the condition of the gun was at the time of the shooting, but it appears for whatever reason they didn't. So they went and got the replacement parts from the original manufacturer, and based on that, then they were able to essentially repair the gun and bring it back into operating condition. Okay, guess court is back.
Opinion testimony would raise questions of relevance. And it'd be helpful to get Your Honor's guidance on that, because we anticipate the medic testifying, the camera grip testifying about issues that, for example, were not reported to Mr. Baldwin, so don't go to his state of mind, or certain witnesses testifying about what a few of the other actors did on the set with respect to checking their guns, when those actors themselves said, but it's not an actor's duty. And so we want to make sure that those issues are not introduced, for example, in an opening statement, when ultimately it will be proven, in our view, to be irrelevant to Mr. Baldwin's state of mind, what another actor may or may not have done under the safety guidelines, or what the medic thought about the set but kept in her head and didn't report to anybody. Obviously, that wouldn't relate to Mr. Baldwin's state of mind without the reporting, or at least there's a question about prejudice outweighing the probative value of that when it goes to state of mind. And so it'd be helpful to get Your Honor's guidance on that with respect to these issues before opening, at least. And we can submit more papers if you'd like, or
No, I don't want that.
I assume not, Your Honor, but that's why I'm raising it here orally versus submitting something to you.
Okay, all right, thank you. Does the state wish to reply?
Just briefly, Your Honor. So part of the defense here is this was Hannah Gutierrez's job. This is Hannah Gutierrez's fault. The truth is, Hannah Gutierrez wasn't doing her job properly, and everybody seemed to notice it except for the defendant. So it's true. We do intend to have witnesses say, I had concerns about the way that firearm safety was being conducted on set. In terms of whether or not it's relevant that other actors perform their own safety checks, I think probably just depends on how the evidence develops. I think my very first meeting with Mr. Nickus, one of the things that he explained to me is that there's a scene in the movie where the actor Travis Fimmel holds his gun to the back of the neck of the child actor. He's got his finger on the trigger and he's got the gun cocked. And Mr. Nickus said, Travis Fimmel would never have done that unless he felt safe with these firearms, unless he thought that these firearms were completely safe. Well, cut to reality now. The truth of the matter is that Travis Fimmel was one of the guys who every single time Hannah Gutierrez handed him a gun, took the gun and dry fired it into the ground more than 6 times to ensure that he tested every single chamber in the gun. So certainly, if part of the defense becomes these other people pointed guns at each other and it wasn't a big deal, then obviously it becomes highly relevant that these other actors felt free to do it, because whether it was their obligation under the safety bulletins or not, they understood that that was a smart thing to do, especially when you've got this armorer who doesn't seem to know what she's doing.
All right, thank you. Oh, go ahead, reply. Yeah.
Just some clarity, Your Honor, because what, I think it would be helpful, both so we can get the court's guidance and so we can understand what kind of case they're putting on, if they give an offer of proof of these issues. Because, for example, if the medic comes in and says, I had safety concerns about on set, that's an opinion about the set that wasn't communicated. It's not to say she can't say, I saw Ms. Gutierrez running around, I saw her doing this, she was moving quickly. Those are facts. We're not trying to get out facts unless they turn out to be more prejudicial than probative, unconnected to state of mind. But her opinion about the safety of the set, that should not be included. That's irrelevant.
She doesn't get to do opinion, I already ruled out.
Exactly, Your Honor. And so what we just heard from Ms. Morrissey is, well, maybe it's relevant that an actor checked the gun on set in a different way for Mr. Baldwin, or he checked the gun at all. Maybe it's not. And so to actually get guidance from Your Honor, so we know what this case looks like when we're going into opening statement, having an offer of proof on these issues, I think will make sure that we don't end up having irrelevant testimony included, that we don't end up in the middle of opening talking about something that the state is or is not going to do with respect to these important evidentiary issues.
All right, so to the extent, looking, I don't think, I can't remember the people that testified in Hannah Gutierrez, but one was somebody that walked off the job, okay? And I think he has a pending...
Lane Looper, Your Honor, yes.
He did not testify during Gutierrez, Mr. Nickus.
Lane Looper walked off the job,
Well,
but he didn't testify.
somebody that was like the head camera guy walked out and looked at Ms. Morrissey because we were in the case. But, so, if he were to testify that I left the job because of safety concerns, that cannot just, it has to be related to what you're trying to prove. So it would have to be related to Hannah Gutierrez. I'm not sure where I see, that's off the top of my head that it would have to be related to Hannah Gutierrez and them observing that this armor was doing a sloppy job, and when they observed other armors, just pretty much what they testified to before. But if they're going to say things like, nothing that would speak to him as a producer cannot come in.
Understood.
So if you're going to say, look, this person was sloppily handling the weapon and it doesn't relate to Hannah Gutierrez, then that's producer, that's not actor. Am I being clear on that?
I'm a little confused.
Well, I don't know, I don't remember the scene that you used, but let me just say this. So you're saying, that this actor had to check because he didn't trust Hannah Gutierrez. Okay, that's Hannah Gutierrez, okay? But let's say the shooting, Sarah Zachary, okay? When she shot, there were 2, and Sarah Zachary shot on the ground or something like that. You would have to tie that to Hannah Gutierrez because that's producer issue.
So let me see if I can help out a little bit in terms of narrowing this down. I do not intend to put witnesses on the witness stand and have them say, generally, I felt unsafe on this movie set. I intend to have witnesses say, these are the things that I saw with regard to the handling of firearms that caused me to feel concerned. And in terms of an offer of proof, all Mr. Nickus has to do is just go read the transcripts from the Gutierrez trial that he's been shoving down my throat for the last 5 months, because that's what I'm intending to have the witnesses testify to. This is what I saw, and this made me feel uncomfortable, and it goes directly to the defendant's defense of not my job, she was great. I had no reason to doubt.
Yes, but it has to be related to Hannah Gutierrez's
Agreed.
job as an armorer. You can't just say, I felt unsafe because people were screwing around with guns, because that might not be related to Hannah Gutierrez.
I agree with you. It has to be related to Hannah Gutierrez, or it has to be related to Mr. Baldwin's handling of firearms, which is directly relevant. I agree with you, absolutely.
In one clarification there, Your Honor, October 8th, 9th, for example, Mr. Baldwin's not there. If someone testifies on the 8th, I saw Hannah do X and Y and Z, and I felt very unsafe based on what she did, they not only have to connect it to Hannah respectfully, but they also have to connect that to Mr. Baldwin. Because if Mr. Baldwin didn't see it, then this comes back to the imputed producer theory. He must have known safety issues on the set on the 8th, but they haven't demonstrated that, and they have to demonstrate that to have any relevance to his state of mind.
Well, I'd have to hear what it was.
Of course, Your Honor,
You
but
wanna tell me?
that's an example.
Oh.
If a witness comes in and says, on the 8th, when Mr. Baldwin was not there, I saw Hannah Reed do something quickly or act unsafe, that relates to Hannah, but it's not relevant to Mr. Baldwin's state of mind or his knowledge of Hannah. If they say on the 20th, I saw Hannah acting carelessly, here's what she did, she moved real quickly, Mr. Baldwin was there, he saw that, then that's fair game. That's my point.
Well, what you're saying is that the state can only introduce evidence that Mr. Baldwin was aware of, and I'm not sure that's correct.
If they're going to show that there was a safety issue on set with respect to Hannah Gutierrez on October 8th that Mr. Baldwin did not see or know about?
I don't know.
Okay.
Because the other way you could do this is that he was, with respect to, for example, David Halls, and how, you know, he said, well, he periodically checked the gun, and I'm not sure whether there was some kind of, I don't know how to put this, some understanding about how she was doing things that could be cumulative. I don't know. I would have to figure that out when it's offered. And I'm sorry.
No, the context is going to matter here, Your Honor. I just wanted to flag this issue because seeing the transcript in the Gutierrez trial, we did see the state try to introduce some of this, and we want to make sure it's connected to Mr. Baldwin.
We do not want a trial within a trial. That's for
Precisely.
sure.
Yes, Your Honor.
But we also want the state to be able to address that, you know, their theory that he should have checked the gun.
Understood, Your Honor.
Okay.
Thank you.
I hope that was helpful.
It was.
Okay.
And it'll come up, and we'll ask
Yes,
for more guidance
absolutely.
when it comes up.
Theory
more
that he should have
precisely.
checked the
I think I
gun.
probably stand here, Your Honor, right? We've got the next in limine
Yes, we do.
on
Okay.
inconsistent statements. Is that right?
No? Oh, yes, no. We already did the lay witnesses. This is
Yes.
motion in limine 5, previous contradict the state's, let me use my list.
I think that's right, Your Honor.
Okay, we've done their 6, got to their 6, and
And there's 7, I believe. Sorry.
No.
Or 5 and 6, I'm sorry. So
okay,
we're back
that's all
at
right,
5.
let's see, so we're on 5, okay. Defendant Alec Baldwin's motion in limine to preclude argument and testimony that contradict the state's previous factual assertions. Go ahead.
Thank you, Your Honor. So I'll make this brief. In the Gutierrez trial, the state made a handful of important statements that relate to what Mr. Baldwin did or did not have an obligation to do, or the cause of the underlying harm. For example, said Hannah Gutierrez Reed is the autonomous decision maker, or if Hannah Gutierrez Reed had checked the gun again, it wouldn't have made a difference. Or the training or not of Mr. Baldwin with respect to the gun is not why Ms. Hutchins died. It's because of Hannah Gutierrez Reed, and so forth and so on. We put them in the brief, Your Honor. Those statements
Well, there can be multiple
contradict
but-for causes.
a number of different elements of how the state has argued this case in the past. And we expect that those will contradict how the state intends to present its case this time. Two things. Number one, the case law is clear that the obligation of the prosecutor is to pursue the truth and not convictions, if there's a difference between them. And so the case law recognizes that it violates due process for a prosecutor to present contradictory theories across two trials that relate to the same matter. Now, they're not bound by the precise theory or the precise factual underlying theory, legal or otherwise. The cases they cite are cases like Fry, where there are two defendants, the government doesn't know who actually shot the gun and killed the victim, and so it puts on a trial saying this one did and then this one did, because the government doesn't know. Those aren't internally contradictory.
Can I interrupt for a second? Aren't you rehashing what has already been done?
We're not, Your Honor, because the case law is clear. We can use those statements as party admissions. For example, look at the Bradshaw case
Okay,
that the state.
Just a minute. First of all, that's not in your brief.
It is, Your Honor.
No, just a minute. You're not going to be able to argue what Ms. Morrissey said
Yeah,
as a
it's not
statement
evidence.
of what the prosecutor said in that case. There's a case, I thought this might come up, and I should have pulled that case, but Justice Chavez did it, and it's contrary to U.S. Court case or federal court, because it doesn't allow that in.
There are two different issues here. One is, does it violate due process to do it? And the other is, are we allowed to present the state's contradictory
Okay,
statements?
so I already ruled it didn't violate due process.
Right, and so on the second, and that's what the cases say. That's what Your Honor is referring to. In the Bradshaw case that the state cites in its brief, it says, look at Justice Thomas's concurrence. Justice Thomas said the Supreme Court has not ruled on, and he wouldn't support a due process violation.
Mm-hmm.
But then you have to continue reading that concurrence that the state cites. Justice Thomas says, if the prosecutor makes inconsistent statements, that risks undermining his case because the defense counsel can present those contradictions to the fact finder, quote unquote, or close enough, to the Thomas concurrence. And in that concurrence, Justice Thomas says, involving two different defendants, agrees
Okay.
with Justice Souter,
You're
says
arguing a
the defendant in the
concurrence?
second trial can present those contradictory statements that were made by the state in the first trial to the fact finder, and the fact finder can weigh those inconsistencies as
dicta.
it will. The state does not cite, and that's directly from the Thomas concurrence that the state cites. We're not saying due process. We do argue that. We want to preserve that. But we should be able to present. In
I don't know
fact,
how
their
they
own
think
case
the
says we're
facts-
allowed to present
the
those
prosecutor's
inconsistencies.
arguments are facts.
On top of that, the state does not cite a single case, not one, that says we're not allowed to present those contradictions in this case. Not a single case. They say it'd be prejudicial. But their statements, clear as day, what they
Let me
said.
find this case, because it went to this. But, okay, I'm listening, all right.
And they say 403. But, Your Honor, they don't cite a single case that actually allows them to say X in one trial and then show up in a related trial and say not X or contradicts the X. And we're allowed to present that. That's their own Thomas concurrence. In the U.S.
It's a
versus Small
Thomas
case, for
concurrence.
example, that
It's
talks
not
about
binding.
403 and
Present a
prejudice,
case
says
where it was offered.
extraordinary remedy.
And allowed or not
They don't cite a
allowed.
single case for it, and they're asking for an extraordinary remedy, and all we're asking
Because
for
nobody
is that
would
the
do
statements
that.
that this own prosecution made in this court, as an officer of this court, as Justice Thomas says we're allowed to do, present them to the fact finder here. Thank you, Your Honor.
All right, thank you.
This is a real reach for me. I don't see Justice Thomas dicta in a concurrence being the winning argument here. The prosecutor's arguments are argument. They're not evidence.
Your Honor, with respect to the introduction of what are they're calling inconsistent theories, the U.S. versus Ganado Negro case addressed that specifically. That some courts recognize that while due process may prevent the prosecution from presenting inherently factually contradictory theories in different trials, there are those circumstances where there are evidentiary disputes about responsibility for a crime, for example, among several defendants. And in the Ganado Negro case, the court specifically recognized where there are cases where there are multiple defendants, as long as the prosecution doesn't present false evidence or factually, or facts that are inconsistent, they can present theories that are different. And that's essentially where what the Ganado Negro case held. With regard to the admission of Ms. Morrissey's statements, Your Honor, we would be creating a trial within a trial. We would respectfully ask, now, while the court is correct, federal case law has noted that statements by a prosecutor in previous trials may be admissible as admissions by a party opponent. The state, I would submit to this court, is different, and this court can exclude those statements. This would be essentially Ms. Morrissey having to defend her previous statements. We're going to be doing essentially a trial within a trial.
Yeah,
and
you're
we'd
trying to make
ask
her a
that the court
witness?
exclude
It's not
any
gonna work.
statements made by Ms. Morrissey. And if I may just have a moment, Your Honor, I think I can pull that case that the court was referencing. But under Ganado Negro, the state should not be bound to the exact same theory of prosecution that it followed in the Gutierrez trial. This is a different trial. The facts are slightly different as they relates to this defendant's culpability. Unless the court has any questions, Your Honor.
No, I want to find that. It's not, it can be dispositive on other issues, but I want to find that case. I should have just pulled it.
So a concurrence is an opinion that agrees with the
Yes.
outcome, but not the reasoning. It is not binding because
Two
that
things.
reasoning
As a
didn't capture
precaution,
the
if Your Honor
majority.
would like to reserve on the issue, we can take a look at the case. You can hear a few minutes of additional argument after we've read it. That might be prudent, respectfully. Number two, you heard Ms. Johnson say, it's going to be a trial within a trial. It's 3 statements, 4 statements. The state made them. You just heard her say that the case law allows us to introduce the contradiction. She didn't cite a single case saying otherwise. She said it allows that. They've admitted that. Due process aside, that's the Gardenegro case that she cites. If they want to present an inconsistent theory, then obviously we reserve and preserve the due process issue. But if they want to raise an inconsistent theory, then by all means, Justice Thomas says they can do that in his view. But you're allowed to show that it's a contradiction from what they said before.
All right, thank you. Well, that doesn't mean the court has to, so we'll take a look at that.
Just a very strange argument to me.
If you could find that, it was Justice Chavez. All right. Okay, we're on.
Like you can bring out what the witness said in the other case when the witness says something different in this case, if that's the issue. But being able to argue the prosecutor's argument, it's just, no, I'm not buying this one.
Where is it? Oh, over there, yeah.
Okay, state's motion in limine 7 to prohibit use or testimony of OHSB summary of investigation.
We have attached as an exhibit the summary of investigation that it seems clear that the defense would like to have admitted as an exhibit. So I want to address 2 issues. One, should the summary of investigation be admitted as an exhibit? And 2, should the findings, which I would argue are legal conclusions, be allowed in as testimony? So we've got the summary of investigation is hearsay. The public records exception to hearsay it was never intended to permit something like the summary of investigation to be admitted as an exhibit because it contains legal conclusions. It's actually findings and conclusions. That's what they call it. It contains legal conclusions. It is based on a law enforcement investigation. That's all OSHA does. OSHA enforces the Occupational Health and Safety Act. And in addition to that, the summary of investigation, as you can see, has numerous instances of hearsay within hearsay. And while the defense responded and said Ms. Morrissey hasn't pointed any of those things out to the court, well, they're all highlighted in the attachment. So yes, it's true, I didn't cut and paste everything from the attachment into my motion in limine, understanding that we do have page limits that the court has been concerned with.
Just make the point.
I can pull up
It's
the
highlighted.
exhibit,
It's
and I
fine.
can certainly go through all of the different quotes.
Don't play victim.
Where
so off-putting.
OSHA investigators say, they actually put people's statements in quotes during the investigation. So that's hearsay within hearsay, so those quotes don't come in. The findings and conclusions are legal conclusions, so those don't come in because we can't have the jury hearing that Mr. Montoya and Mr. Genoway came to these conclusions because it's going to cause the jury to think that they now have to come to the same conclusion.
Invades the province of the jury.
The problem with the OSHA report generally is that, one, they didn't do a very complete investigation, and I outlined very specific instances of where their investigation fails. And in addition to that, every time I read the OSHA summary of investigation, I say to myself, what is the relevance of this? What does this have to do with the case against Mr. Baldwin? And I want to put kind of in perspective.
Well, it's their opinion of the safety of the set.
Not only the report,
relevant.
but testimony about the report is like let's say we're having a DWI trial, and it's a jury trial, and the jury gets to hear about the MVD revocation hearing. That's kind of what this is, only the MVD revocation hearing would actually be arguably more relevant and possibly more admissible than the OSHA.
I don't understand
because OSHA is
this
not
argument at all.
concerned largely with the conduct of individuals. As you can see, Judge, the OSHA report basically says Hannah Gutierrez didn't do anything wrong. Well, we know Hannah Gutierrez did something wrong. We did an entire trial about it, and a jury convicted her in 2 hours. So it has nothing to do with the charges against Mr. Baldwin. Now, having said that, can the state or the defense call these witnesses, witnesses that were interviewed
That's your
by
point.
OSHA, put them up on the witness stand? Mr. Halls
That's your
was
point.
interviewed, Mr. Baldwin was interviewed, Ms. Gutierrez was interviewed, numerous
It's
witnesses
just the
were interviewed.
report that's the
Can we
problem.
call them and put them up on the witness stand and then refresh or impeach them with the statements that they gave to OSHA? Absolutely, as long as the testimony that they're giving in the witness stand is relevant to the issues in this case. And I'll tell you, on its face, I don't disagree with the findings of OSHA. OSHA found that Rust Productions was responsible under the New Mexico Health and Safety Act for allowing this hazard to be happening on this workplace. I completely agree with them. That doesn't have anything to do with whether or not Mr. Baldwin is guilty of manslaughter. The other thing that I want to point out is the defense wants to do this thing where they don't want you to allow us to bring in anything about Mr. Baldwin being a producer. But what's critical about the OSHA report is the OSHA report says it was the fault of the bosses. It was the fault of the producers. So if the OSHA report gets to be discussed, and we get to hear testimony from Mr. Genoway and Mr. Montoya about the fact that this death was the fault of the producers, then we absolutely at that point get to point out that he's one of them. And he was in a position where he got to do whatever he wanted because he was a producer. So if the court is going to prevent us from raising the issue of Mr. Baldwin being a producer, and I respect the court's ruling, absolutely, then the OSHA decisions can't be discussed because they go directly to the fact that he's a producer, and that will open up this issue that I've had with Mr. Montoya in the past, where Mr. Montoya came up with this kind of fake notion of Mr. Baldwin's a producer, but he's not really responsible for anything other than creative. And Mr. Montoya came to that conclusion because he never looked at the contract and he just talked to Mr. Baldwin. When you look at the contract, and I put the language in our response, or I'm sorry, in my motion, he's absolutely a full producer. There are no limitations on his role as a producer. The language in the producer contract says he is expected to fulfill all of the duties traditionally known by movie producers. It doesn't say there's any restriction at all. So we've got some difficulty here because if they want it in, then producer comes in. If it stays out, producer stays out. So I would ask the court to look at it in that way. If OSHA comes in, the fact that he's a producer becomes highly relevant at that point in time. Thank you.
It's the only real point I kind of understood her making. Yeah, it's hearsay,
Quick
and you can
points,
just
Your
call the
Honor.
witnesses.
Number one, we've cited cases saying it's admissible. 8038C says if it's a criminal case, there's a factual finding, and it's a legally authorized report, it comes in under the hearsay exception. We've cited cases on that. Number two, Jorgensen, their expert witness who's going to testify under Your Honor's ruling as to the safety.
Not an expert witness.
Jorgensen?
No, he's going to just testify about the guidelines. He doesn't get to
Yeah.
provide an opinion.
Your Honor, Jorgensen has no factual knowledge of the rest set. What he,
Wait a second. Jorgensen is the guy with the SAG guidelines, right?
That's right. He,
So I rule that he gets to testify about the SAG guidelines, but he doesn't get to provide an opinion about the safety.
correct, Your Honor. And one of the issues is that, and we may use it or we may not, but when he was asked at his pretrial interview, what did you do to prepare for giving your opinion? He said, well, I didn't talk to anybody, some hearsay. I read the OSHA report a lot because he's an OSHA guy. That's his background. And so to the extent we think it's necessary to raise that, then that would be the limited context. And so ultimately, because it's admissible and because it may relate to their witness, we may have to raise it. And so that's the context in which it could come up. Number three, just for clarity, the report didn't say the producers are responsible. It said Rest Productions LLC, that's one person's company, is the employer, and the employer, not Alec Baldwin, the employer is the one that is being fined under that report. And so there's a very big difference between saying Rust Productions is responsible for violating these OSHA rules and saying that Alec Baldwin is a producer and he had a contract with Rust Productions and therefore he's responsible. That's not all what the report said. So these are not linked in the way that Ms. Morrissey described. Nothing further, Your Honor.
No, Your Honor.
Okay, court makes the following ruling. I already ruled that producer liability or whatever does not come in. So this OSHA report is specifically prepared by OSHA to go in and investigate whether the employer had any responsibility, and they were in fact fined. If that testimony comes in by oral and including written, then you have opened the door to producer. And with
bought it.
respect to you saying that the only reason why we may bring it up is because Jorgensen may mention it. Jorgensen's not going to mention it because I already said only safety guidelines. Okay? All right.
That seems fair.
Okay, so that's granted. I want to keep track of my omnibus order.
Don't get to have that one both ways. That was the best argument that Morrissey made there. Took her forever to get to it. But yeah, you don't get to have it both ways. He's only an actor, even though the source OSHA report found the production company to be liable.
Defendant Alec Baldwin's motion in limine to preclude argument, evidence, and testimony regarding the victim.
Thank you, Your Honor.
Please
We
make this
addressed
take like 5 minutes.
Briefly earlier when I withdrew our request to admit medical records. It's axiomatic and not disputed that a victim's good character and all the wonderful things about them is not relevant to a criminal trial. They don't really dispute that. What they do is they try to sort of come up with ways to backdoor that evidence by giving other reasons. Like they say, well, we need to explain why Mr. Souza hired Ms. Hutchins. And so Mr. Souza needs to explain all the background about Ms. Hutchins in order to explain his hiring process, which is, of course, completely irrelevant in the first place and an obvious backdoor and not particularly intellectually honest. Then they say, well, the reason we have to explain where she was born and how she grew up is because there's one moment in this case in thousands of pages in which one witness mentions that she speaks Russian to another witness. So in order to understand that, you have to understand where she grew up in Ukraine and all of that, and her childhood and all of that, to understand that. And of course, that's also intellectually dishonest. And all you have to say, if you care about making sure this court is, and this jury does not, decide this based on emotion and sympathy and the wrong reasons, is you have to say, did she speak Russian? Yes. Did you understand she understood Russian? Yes. You don't have to go into the 30 years of history here. So that's the way to deal with that. In terms of exhibits, it's also very, very simple. They talk about the lapels. I agree with them. The lapels at the scene are relevant. You don't show the positions of the bodies on the ground. It's not relevant. It's not in dispute. It's not a fact in dispute. It doesn't tend to prove anything. I agree with them. The autopsy is relevant. Not the photos. The photos don't help anything. The person who's doing the autopsy is more than sufficient. And let me say something else, and this is why I wanted to quickly withdraw the application for the medical records, which is we don't dispute anything about any of this. This is not an issue in this case. You will not hear us cross-examining or questioning the fact that she passed away or the cause. In the other trial in which you presided off, there was at least some testimony, some indicia that they intended to proceed that way, and maybe that had something to do with why so much of that evidence came in. That is not an issue in this trial. It's just not. And so every single time that evidence comes in, it's wholly irrelevant because I've just told the court we're not making an issue of it, and it's extremely prejudicial. It is the most extreme possible weighing of the scales that one could ever have, because it is completely irrelevant. Because I'm saying, I agree, she passed away because of this.
It's not completely irrelevant.
So,
they still get to prove
and their
it. They
real
don't have to accept your
reasons for doing this is
stipulation.
obviously exposed.
Okay, so you're sort of combining everything. Why don't you go through each one that you identified?
Sure. The character of the deceased victims I just did. The moment of death and subsequent pain is obviously completely irrelevant. The emotion, they say in here.
Did you say completely relevant?
Irrelevant. They say that the reason that they're eliciting it is to bolster witness credibility. That is a per se improper reason. They say that in their, they say
Well, I feel
evidence
like
is relevant
that's
and
not what they
explains the witness's
said.
conduct and bolsters. They're using emotional sympathy, drama of something to bolster a witness's credibility. The fact that she suffered might be irrelevant or admissible in a wrongful death case. It's not in a homicide case. It's nothing to do with it. Nothing. And to
Well,
the
it
idea that
explains
they're
their
going to use it
conduct.
so that the witness is upset on a witness stand and saying, and
Because
this is
wasn't
how
there
she fell, and her
stuff
face
in the
was pale,
Gutierrez
and this,
Reed trial
and now
that, like,
everybody's upset. And
the
trust
medics
me, I
should have
saw what I
saved her?
saw about something relevant is exactly what a court can't allow. It's exactly what a court can't allow. And they did this the entire trial with, and I mentioned this before with the, where is she now? Is she in the medical vac? They ask all of these, why is even one time, the tone of her skin as she falls, why is that possibly relevant to this trial? And they do it with every single witness. Every single witness they did it with. So then you get to the lapel cameras and the autopsy photos. And so I was trying to track this precisely. Again, we agree that the lapels of the scene are relevant, right? You just don't need to show a body on the ground. It's just not necessary. And the autopsy photos are particularly problematic. They don't show, how are they relevant? We could stay here for days and no one could explain to me how the autopsy photos are relevant. They're not. If the court
Well,
wants to voir dire the
because they assist the medical examiner.
and say, is it possible for you to explain this without presenting these graphic, vivid depictions of a tragically killed person? They're going to say, of course I can't. Autopsy photos get ruled out all the time, especially in cases like this. This is not, a whodunit, where it's like, okay, let's look at this, but I'm saying
how
I didn't
did
do
it
it. This is a
happen?
tragic accident.
How did it happen?
Where two
It's big
people
here.
who are known to each other and no animosity towards each other, this occurred. And so it doesn't have anything to do with the case or anything relevant. And I'm telling the court that we're not making an issue of this. So if the court knows that, unlike in the Hannah Gutierrez retrial, that this is not in dispute, I really don't understand the basis to allow a single witness to do any of that. A single witness, let alone the cumulative every single witness, which is just being done to taint the jury and to try to get the jury to do something on sympathy. Thank you.
State.
Little over the top and hyperbolic for my taste. You got to acknowledge it's relevant. Of course it's relevant. You're just saying it's
The
more
state has no
prejudicial than
intention of
probative.
presenting evidence related to Ms. Hutchins' childhood. So we can eliminate that right off the bat.
What do you plan on?
Well, we believe that there is limited testimony from Mr. Souza that's appropriate because jurors don't know how the film industry works. He should be able to take the witness stand and say, as the director, I got to pick my director of photography. Here's what the director of photography does. These are the reasons I picked this person. We're not going to have him talk about, she's an honest person. She's an amazing mother. She's an amazing wife. None of that's coming in. But he gets to tell, we get to put the story in context for the jury. And I think that we can do that without doing all of these things that the defense is claiming are so highly prejudicial. I have no problem limiting that testimony with regard to Ms. Hutchins, but certainly the jury gets to hear what she did, how she was hired, how does this come together? How do all of these people come together on this movie set? That's absolutely relevant. Now, with regard to the lapel videos, the defense says, we think the lapel videos are relevant, but we just don't want the jury to see the human part of it. And that's kind of hard for the state because we kind of have to prove that a human being was killed. That's part of what we have to do here. So the other thing that you have to understand is that the defense
Not a good
probably
counterpoint.
is going to take a similar tactic in this regard that we saw in Gutierrez, and they're going to question all of the law enforcement officers about why didn't you do better? Why couldn't you have done
This is
and
the
why
point.
couldn't you have done that?
The
And the answer
circumstances.
is, this was extremely chaotic. We've never shown up to a crime scene where there were 150 witnesses there. There were people mulling around everywhere. There were things that we had to do. Those lapel videos show how difficult and chaotic that scene was, and it goes directly to their defense. And listen, I mean, they act like these lapel videos are like a horror movie. You see Ms. Hutchins on the ground, you don't even see blood. You don't even see blood coming out of her. You see Mr. Souza's yelling.
You don't
because he
even
got
see
shot in the
blood
shoulder.
coming out of her.
That's not overly prejudicial. Absolutely not. There is tons of case law where, and the lapel video of them laying on the ground is very, very similar in terms of the analysis as the autopsy photos. Autopsy photos come in. They do. They come in every single case. I have never had a case where autopsy photos were excluded, and I even cite to a case in my response where the court actually says, basically, we've never heard of a case where there was a reason to exclude these. They just come in. Now listen, I want this court to know that during Gutierrez and during this trial, there are autopsy photos in this case that are shocking to the conscience, that we could argue successfully are relevant. Because when you crack open somebody's body, you can see how the bullet traveled.
The transection.
And autopsy photos actually show that. We're not asking to get those in. We are doing exactly what we did in Gutierrez. We have just 2 to 4 very benign autopsy photos. We have been more than reasonable in terms of trying to turn down the volume on emotional response with regard to these autopsy photos. I was actually stunned to see this motion after we exercised so much restraint during the Gutierrez trial, and those are the same pictures. We haven't upped the ante here. We're not trying to show anything other than, look, this is where the bullet entered. This is where the bullet came out. Those are relevant. Those are relevant to Dr. Gerald's testimony. Those come in. They come in every single trial. There's just a reality associated with the fact that someone died. I am more than surprised to hear Mr. Spiro come up here and say, we are not disputing the cause of death. The whole reason that we have probably 4 or 5 witnesses on our witness list is because the defendant put Dr. Bianca Alvarez on their witness list. They called her, talked to her on the phone without inviting us. And the whole point to doing that has to do with this farce defense of she didn't die of a gunshot wound, she died because she wasn't intubated properly. So I want to say right now, because we're short on time in this trial, if the defense is not intending to make any arguments that she died because of a faulty intubation, let me know, because I can shave a lot of witnesses off my witness list that way.
Thank you.
Well, she really felt like she landed that one there.
State did not address even slightly in either their motion papers, in the Hannah Gutierrez retrial, or in that response, anything about how ashen she is or how the moments happen after matter. They don't. They didn't address it in their papers. They didn't just address it now, right? So I just want to make sure that the court, as the court was well to point out to me, demark these issues. They have not addressed that. There is no dispute that that's not possibly relevant to talk about how the person was dying and what their skin looked like and their breathing. It's just not relevant. They then go into this, how Mr. Souza selected her to understand the film industry working. I mean, Your Honor, it's like they don't ask a single other witness, right? Well, how did you get hired, and why did you get hired, right? I mean, so I'm sure that the court sees through this. If somebody were to say to me, this is the one question and answer, and there was an offer to proof, I'm sure we could work this out. But how can I possibly trust this process if we don't hear that exactly because of what I've seen? And then I'll just deal with the autopsy photos. Again, we're stipulating to identity and that she's deceased, and that we're not saying that some other causal factor killed her. So this makes the balancing test very, very easy. That doesn't happen
So
in
if
every
that's
homicide
clear,
case,
you're not
right?
doing that.
And also,
But
you know,
I have a
wasn't,
feeling
you know,
he's not gonna get pinned down
I don't say
there.
these things in front of juries, but I actually prosecuted homicide cases. No, and often there is a discussion over, they don't always come in, and often there is this thing where sometimes prosecutors want to put them in to gin up the jury, and judges make calls all the time that it's just not necessary. We don't need to remember her that way. We don't need to do that in this case. I don't need to do that in this case. And this court can very well, like the court said to me when this hearing opened, take order of the court and has the discretion to say, no, pictures of this tragic dead body is not necessary here. I'm telling the court again, I'll say it now, I think a second time, which is we are not making an issue out of the cause of death, period. They want to take these people off the witness list, they can. But if that's what we're doing, and I've withdrawn our seeking the medical records, then I've left the court with a very simple, in my judgment, balancing test. And I'd ask the court to really think about when this verdict comes down, having faith that this was a fair trial and the verdict was based on the right reasons. You can't have, I mean, it's hours of testimony, hours in the Hannah Gutierrez Street trial about it, and it's different here because the gun was in his hand. The gun was in his hand. So to allow hours and hours of testimony, when we have, the state has 5 days to present this case, and we need the opportunity to rigorously cross-examine, it doesn't make any sense. I don't think it's fair, and I don't think the court should allow it. Thank you.
All right, the court makes the following ruling. All right, with respect to the character of deceased, of the deceased, certainly if Mr. Baldwin was going to get up, you'd want to go, how did you come about getting this, this job, so to speak? And I think it's just an introductory way to tell the story. Now, I do remember Mr. Souza going into, we met, I liked her, we had things in common, you know, et cetera, et cetera. I think all that needs to be said is that she was one of some choices. He felt that she was a good fit and that she was the director of photography. That's it. Okay. Now, with respect to the moment of death and subsequent pain, I think that does go to the death. That's one of the elements, and the death and the injury, well, the death, and where am I? And I do think that that makes a fact more probative, and that is the death, and that I don't think that is its probative value substantially outweighed by unfair prejudice. Having said that, I'm trying to recall everything that occurred regarding that, and I do think that the video is appropriate. Now, I think there were some people that got up, and this may be what both of you have referred to, where they talked about being upset, they talked about, how upsetting it was and things like that. We don't need that. We just need the lapels videos as to what happened with respect to her being shot and Mr. Souza being shot as well. So that's the lapel camera depicting the crime scene. Am I misunderstanding anything else on that?
From the defense's perspective, a lot of this also goes to 403 and cumulativeness, right? So
Could you just answer my question? Okay?
Yeah, well, I think
I don't want you to argue again. You already had your chance.
I think
Yes.
the answer is yes, Your Honor. I'm not, if I understood the court's ruling, I think the answer is that yes, if the lapel videos are the way that they're going to show where the bodies were or the
This is
man.
when Lieutenant Benavides is in there and he says, everybody clear out? Is that the video?
And primarily also Officer LaFleur, who's the first officer on scene, that video
Right,
also.
where people are rendering aid?
Right.
Yeah, all right, so that comes in. Autopsy photos, again, you can stipulate, that's fine, but they're allowed to tell their story, and they're allowed to demonstrate the death. I do remember there was an autopsy photo that was pretty much agreed it was prejudicial, or maybe it was somewhere else where her shirt, I think. Which part of the autopsy photos? I don't know. But the autopsy photos in my mind are the body.
So just to iron it out right now, we've got pretty much the same photos of the body that we showed during Gutierrez, nothing overly dramatic. And there is a photo of the bloody clothing, and part of the reason that's relevant is because her cause of death was exsanguination, so she bled to death. So the photos of that amount of blood go directly to her cause of death.
I will allow that. All right. You can revisit that defense, but I do anticipate you may bring up some information about the tubing.
Just to say that and I know the court has one more argument, but the court's looking at me for guidance on this. That we're not going to do that. We're not maybe going to do that. We're not going to do that. So when we say that we're not going to do that, the court can count on that, and that makes those.
Well, you didn't say that. That's not.
Oh, I thought that's what I was going to address.
You could ask the doctor. You said you didn't care about the UNM records, but that you didn't say you weren't going to ask the doctor.
If I wasn't clear, I'll make it more clear, which is we are not going to ask the doctor about that. So if we're not going to ask, we're not going to seek to introduce the medical records, and we're not asking the doctor about that. There isn't a basis of relevancy anymore. There just isn't. And so I'm asking the court.
They still get to prove
They now
it.
have several ways the court has just allowed for them to present that this was a death, which we concede. So, right?
All right, that's fine, but they still get to do it. I'm saying
Yep.
no to you.
Correct.
All right, so
I'm
let's not do
saying
the
no
shirt
to
if you're
you.
not, well, no, I'm going to allow the shirt. You said that she bled to death. There's nothing wrong with that. All right.
I'm gonna start calling off witnesses then to testify that she was correctly intubated. Are we clear that the defense is not gonna raise that issue?
We are not raising that issue as to the cause of death, and we maintain our objections to the exhibits, and we understand the court's ruling.
So, just to be clear, the video, and all I'm remembering is the video, okay? So if there's something else that comes in about in the church, then we need to revisit this, because I am making a ruling about the video. I don't remember if there were any photos. I don't think there were photos, but I remember the video, okay? They get to put on what the church looked like. Secondly, and also that gives an understanding of where Mr. Souza was for various reasons. Then, with respect to the autopsy photos, I'm not sure whether that shirt is more prejudicial than probative. You can get out that she bled to death in different ways. I'm not sure that that's necessary. I'll revisit that.
Okay, and what I can do, Judge, if it helps, I can email copies of the photos to you so you can look at them. I mean, Dr. Gerald isn't scheduled, the photos come in through Dr. Gerald, but she's not scheduled to testify until the end of our case.
I don't want to revisit the autopsy body photos.
No, I hear you. I can send you, and I apologize, I understand why I just got my wires crossed. Some of the photos of the bloody clothes were taken by OMI. So what I can do is I can email to you, and of course CC the defense, those photos of bloody clothing so that you can look at them and you can make a determination long before the witness ever takes the witness stand, what's appropriate and what isn't. Understanding autopsy is something different, you've already ruled on that.
All right, thank you for that.
Your Honor, if we may go back to the state's motion, defendant's motion on limine number 5, I found the case that the court was referencing.
Okay, what is it?
It's State versus Montoya. It's 2016 Westlaw 36-39984. It
That's
is
an
a Justice
unpublished.
Chavez opinion, and the issue begins in at paragraph 42 and 44, where the court did not allow the defense to introduce the prosecution's opening statements or statements during opening in a previous trial.
It's an unpublished
There's two State
decision.
versus Montoya's.
Yes, Your Honor, this one is, it's a Westlaw site.
Oh, I see, okay.
It's 2016 36399. Oh, sorry, I just lost that. Let me go back. So it's 2016 Westlaw 36-39984, and it's Justice Chavez opinion.
And
Your Honor, we can take a look at that in the break as well and give you our views, if we may. Thank you.
Just wanted to see if it was the one I remember. Okay.
So unpublished means it's technically not precedential. They're not supposed to rely on it.
Is this opening statements?
I don't know if that was the reference to opening statements.
No, it's the next one up.
All right, state's motion in limine 8 to allow use of exhibits during opening statement.
Your Honor, we don't have I think there's a way to shortcut this, which is that as long as the defense can also put in exhibits and the court will, if there's any issue between the two sides, address those one or two issues. I'm hoping that there's not. We would not, as long as it's equal to both sides, we would not have an issue.
Are they going to be admitted?
Yes, Your Honor. In fact, I provided defense counsel this morning a copy of the exhibits. I have a copy for the court if you'd like to look at them. What I would request is that they provide us today with a copy of the exhibits that they intend to introduce in
All
case
right,
there are
but do
any
you
issues.
think there's going to be an issue on admission at trial?
No, Your Honor.
I don't believe there's, of the exhibits that we're putting forth basically the same set, a little bit more of a videotape or a little less, and the 911 call. That's it. So there's very few exhibits that we're using in opening, and I don't think any of them are an issue.
All right, well, I want you all to agree because I do not want us to stop in opening statement. Okay?
Yes, Your Honor.
So if you don't agree, let me know.
Yes, Your Honor.
All right, defendant Alec Baldwin's motion limited to preclude argument, testimony, and evidence related to the incident from the Crow.
The Crow.
Thank you, Your Honor. We move to exclude the state presenting evidence of what happened on the Crow as evidence of Mr. Baldwin's state of mind here. The state has said it will not present evidence of what happened on the Crow, but what the state did say is it intends to address and present the theory essentially from the Crow that blanks can kill. Mr. Baldwin knew that, and therefore he's responsible for having the criminal state of mind necessary to prove involuntary manslaughter here. There are 4 problems with that, Your Honor. The first is, let's go back to the indictment. The indictment says that Mr. Baldwin is being charged because it was foreseeable to him that if he didn't check the gun for live ammunition, it says nothing about blanks, not a single word, then his use of the gun by pointing it and pulling the trigger, they allege, could cause significant risk of harm to human life. That was the theory of the indictment. Live ammunition, nothing about blanks. A few witnesses mentioned here and there blanks in the context of an accidental discharge. They get loud, you have to put your goggles on, your earmuffs on, people get mad. There is no testimony in this case about that blanks kill in this particular
relates to the safety
situation. The
standards.
case theory has always
Well,
been.
you don't get
they've said it
complacent just
over and
because
over
it's
and over in the
blanks.
papers they've submitted to you. Mr. Baldwin didn't check for live ammunition. He pointed the gun, he pulled it, and then Miss Hutchins died. So they're trying to vary significantly from the theory of the indictment. Problem number 2, causation. Mr. Baldwin not checking for blanks and then pointing the gun did not kill Miss Hutchins. She was not killed by a blank. She was killed by a live round. And all the testimony shows that blanks are very different from live bullets. If Mr. Baldwin checked for a
Check,
blank, there would
period.
have been no blanks there. And so they have a major causation issue as a matter of law in presenting this brand new theory that was not in the indictment. Number 3, there's
not
a
buying this.
foreseeability problem as a matter of law with their intention to present the blanks theory. The Henley case, as Your Honor knows, we've briefed it for you, says the requisite criminal state of mind needs to match or converge, is what the case says, with the criminal act. And what the state's doing here is they're playing apples and oranges. They're saying Mr. Baldwin had the reckless criminal state of mind because he knew that blanks can kill. That was foreseeable to him. He didn't check for blanks, and then Miss Hutchins died. But the act that he's been charged with is not, he didn't check for blanks and Miss Hutchins died as a result of a blank. It's that she died as a result of a live bullet. So they're mixing apples and oranges here. They're trying to take what they say is a foreseeable risk and match it with an act that didn't cause the death. So that violates the very clear requirement of Henley that the state of mind and the act converge. That's not what they're saying here. And then
The act
last but
is
not
checking
least,
the gun.
there is zero evidence in this case, zero, that Miss Hutchins would have died, or it was expected that she would have died, if you look at the foreseeability cases, if there were a blank in that gun. The foreseeability cases say it's not what can conceivably occur. Blanks can kill. It's not what can conceivably occur. It's what's expected, what's objectively and reasonably expected. There's zero evidence in this case. They don't have an expert. They don't have a fact witness that can testify. And certainly a fact witness wouldn't be allowed to testify about this, that if Mr. Baldwin had a blank in that gun, in that moment, it would have killed Miss Hutchins. Zero. There was no obstruction in the barrel. They keep on saying obstruction in the barrel. There was no obstruction in the barrel. He was
But
feet
this is
away,
the point.
2 feet, 3 feet.
He did nothing
4 feet away from
to
Miss
make
Hutchins.
sure
It was pointed at her
any
armpit.
of that was the case.
There's nothing in that gun that could have
Even
pierced
if
her
they
body.
believed it was loaded
There
with
is
blanks.
zero evidence. If you look back at the Crow, if
It's
you
still
look back
unsafe.
at the history of motion pictures, there are 2 incidents where a blank was involved in a death on a movie set. In 1984, an actor put the gun directly against his head, and the pressure pulled the trigger, and the pressure from that directly against his head killed him. In The Crow, so very different from what happened here, miles and years apart. Number 2, in The Crow, what happened was the crew was making dummies out of live bullets. And when the dummy was put in to the gun, it still had residual gunpowder. And the primer got hit, it knocked the bullet tip off, it discharged, and then there was a blank loaded behind that live bullet tip from a live bullet that people on the set were making improperly. Still no criminal prosecution there. Said it was civil negligence, not criminal, but that's not the point. The point is, if you look at what happened in both of those cases in the history of motion pictures, they are entirely distinct facts. The state cannot come in at the last minute and say, blanks can kill, Mr. Baldwin knew that, and therefore he had the requisite state of mind, and they match it up with an act that killed Miss Hutchins. Zero evidence that that would have happened here, and therefore they cannot present it as a theory when there's no causation for it, there's no foreseeability for it, there's no evidence for it, and it's not in the indictment.
I think the argument is it's bad enough you didn't check it thinking it was a blank. Then lo and behold, it's not even a blank.
I'm looking at the indictment that was filed in this case. I don't see anything that says live round. I have it right in front of me. So.
God, she's so annoying.
I'm not
It's so
exactly sure what
irritating.
Mr. Nickus means when he says if you look at the indictment, he was indicted for that. I'm looking at the indictment, it doesn't say anything about that. So I want to try on occasion to agree with the defense. I want to try to come together. The issue of do we want to have witnesses testify about what happened on the set of The Crow? No, of course not. I intend to present absolutely no testimony with regard to, I expect no witness to say The Crow. But here's why this is relevant. The entire defense is Mr. Baldwin had no reason to believe that there was a live round on set. Well,
Is it on set or in the gun?
I think they've argued both. They've argued that he had no reason to believe that there was a live round on set, that he had no reason to believe that there was a live round in the gun. And here's what they're going to argue. They're going to say this gun is completely inert. He should be able to treat it like a toy because everything is completely safe. Yeah, but the problem is that these safety bulletins and these rules that the defendant failed to follow were created because real guns on movie sets are dangerous. That's the whole reason they were created. And one of the ways that we know that they're dangerous is because if you combine a blank
Say it like
with a
Alec
barrel
Baldwin
obstruction,
is 8 years
you can
old.
kill someone. It's not
Because
what Mr. Nickus said,
you
that there's no
can
reason to
kill
think that it would have
someone.
killed anyone. It would have killed her if there was a blank and a barrel obstruction. I agree with him that that's not what happened in this case. But the point is, real guns are dangerous The SAG safety bulletin from the Screen Actors Guild says blanks can kill, underlined, bold, exclamation marks. Mr. Baldwin's state of mind is what's critical in this case, and Mr. Baldwin understood real guns on movie sets. Even best case scenario for him, we imagine that there's no chance that there could be a live round on set. He still knows they're dangerous, and he understands that the rules exist because they're dangerous. The rules that say, don't point it at anyone, keep your finger off the trigger. Those are all the things that were designed because real guns on movie sets, even if there's not a live round, can kill people. Mr. Nickus can stand up here and say blanks don't kill people. They certainly do kill people. And the Screen Actors Guild Safety Bulletin says blanks can kill. So the problem is that the defense theory is this was a completely inert gun. And the only thing that made it a problem was the fact that there was a live round in it. And that's simply not true. And it goes to Mr. Baldwin's state of mind. It goes to exactly what the state has to prove, which is that he knew or should have known of the risk when he pointed the gun at someone, cocked it, and pulled the trigger. Live round or not, he understood that risk. That's what we have to prove, and that's what we're going to prove.
Well, it was in the grand jury hearing that the indictment doesn't say it, but
Sure.
you did to get the true bill. You talked about live ammunition in a gun.
Sure, absolutely, and that's certainly a part of this case, and I don't want to pretend that it isn't. Because the other thing that we know, and we put this in some of our responses, is that when Mr. Baldwin was being interviewed by Corporal Hancock, he actually said to Corporal Hancock, I'm wondering if Hannah commingled live rounds with her dummy rounds. He knew that there was a possibility that a live round could find its way on set. He didn't even know that Ms. Hutchins had died yet, and he told Corporal Hancock, I wonder if they were commingled. He knows that these guns are dangerous. And listen, the state isn't, I've had countless cases where the prosecutor has a slightly different theory at trial than they did in front of the grand jury. There's nothing improper about that. We're not amending, we're not trying to add charges.
I see it as
at
a
the last
variance
minute.
from the indictment.
I don't understand exactly what the issue is. If there's case law that says that I'm married to absolutely every single theory that was put in front of the grand jury, it's news to me, because I've had courts amend grand jury indictments in the middle of trial based on the evidence. And the evidence in this case is that this gentleman knew that you can't point a gun at someone and pull the trigger, because even if there's not a live round, it might kill somebody. He knew that, and I agree, we don't have to get into what happened on the Crow, but at the same time, the safety bulletins are made because of that. They exist because of that.
Thank you.
A few issues, Your Honor. In terms of the indictment, it was in the grand jury instructions on which the indictment was based, to be clear. There's nothing in the grand jury instructions, in the indictment, in this case, where the actual allegation of the charge is that Alec Baldwin didn't check for blanks, and therefore he's committed involuntary manslaughter. This, in terms of time, Your Honor, and sensitivity to cumulative witnesses and cases within cases, this is a case within a case. It's a hypothetical case about an act that didn't happen, that didn't cause the death at all, with, on top of that, significant questions about whether it's even possible when we know from the history of motion picture, it's never happened in this way. Who are they going to testify? Who are they going to have testify, the state, that Ms. Hutchins would have died if there were a blank in that gun? What expert witness is going to say that? They don't have a single expert witness. They don't have a single fact witness who's allowed to testify about that. They don't have any evidence that there was an obstruction in the gun. There's literally no evidence of this. And if they want to put on a theory that merges different state of mind with this hypothetical act that didn't cause a death, then we're going to have a very confusing trial with multiple different witnesses being asked, have you ever been on a movie set where a blank killed someone? Have you ever been on a movie set where a blank shot and pierced someone's body in a way that was really dangerous? Have you ever had someone on a movie set shoot a blank in a way that did anything other than cause a little rash or hurt someone's ears or make their eyes have stars in them? We're going to have a trial within a trial about a hypothetical that was not raised until the very last minute. It wasn't the basis for the charge in the first place. They have foreseeability issues, they have causation issues, they have evidentiary issues, and there are major notice issues. And in terms of cumulative testimony and wasting of time in cases within cases, that's what this theory is going to become. Thank you, Your Honor.
All right, thank you. All right, the court makes the following ruling weighing whether it has any tendency to make a fact more probable or less probable than it would be without it, and whether its probative value substantially is outweighed by unfair prejudice. I think it's difficult to deal with what I read in the grand jury transcripts about, the theory about the negligent use of a deadly weapon is just his manner of handling, that he shouldn't have cocked the gun, et cetera, et cetera. And then with respect to the alternative, it is that he failed to check the gun. He failed to confirm that the gun, I remember the word confirm, about live ammunition before he pointed it at someone. I think that I will not allow any testimony other than one sentence statement, probably by your expert, Ms. Morrissey, that says that blanks can also kill. But to consider that he failed somehow, that's just going to be up to the trier of fact. I think everybody knows guns can kill. It depends on what's in there, but I think that you can mention it. But that's it. We're not going to go through 5 different questions on tell me how and how serious this is, and he, if he's a gun owner and he's done all these westerns, or not westerns, but all this gun experience, and he should have known it. Just say that, and if you can tie that up, great.
Understood.
All right, let's take our lunch break.
I'm taking that to mean
All right.
not talking
What
about
else
the
are you going to
crow.
surprise me with? Exhibits? What are you going to do? I mean, because maybe we can have an hour lunch.
I want a real exhibit list from the defense that doesn't list every
don't-
piece of evidence.
They probably feel the same way.
Well, we were pretty specific.
I do think that given the court's guidance today, that there could be, I'm hoping that the opening exhibits all work out, and I'm hoping that this slowly streamlines it.
The board here is 50 minutes max a piece.
You said 50?
50.
Okay.
50.
Yeah.
And
Oh, let me just be clear on board here, so as you're getting ready for it. Questions. I know I'm looking at you, but he's standing. Questions, not just keep standing. All right, no, okay, you can sit down. Okay, questions, not your theory, your hi, how are you, questions, okay? And the issue is fair and impartial, okay? Not maybe this isn't the case for you. We're not shopping. It's fair and impartial, okay?
Yes, sir.
And questions.
I'm
emphasizing questions. You ask questions. You don't
Chit chat.
talk to them. Do you understand what I mean? I mean, I'll give you latitude, but I'll have to pull you in if you're not trying to get fair and impartial.
I'm just wondering, in terms of what sent us into individual voir dire during the
I'm not going to do individual voir dire.
Okay.
I think this is different.
And I'm just,
Well, I'll hear you out. Okay, I'm sorry to interrupt you.
no, and listen, it may not turn out to be an issue, but my only concern is if we start to have potential jurors who say, I don't think that I've seen in the press that he didn't know that the gun was loaded, and I don't think that he should be prosecuted. I think that there was a concern in Gutierrez that if we have all of these jurors just giving their opinions because they've seen things in the press, it kind of poisons the well.
Right.
So
Well,
that's my only concern.
first of all, my intent is, and I'm open to hearing from you all, but when that happens, I'm just gonna call you up and agree that this person should be stricken for cause and he can leave. What do you think?
Sure.
Yeah, it would have to depend on the, how extreme it was, but I think we'll be able to make eye contact, frankly, and figure out some of this. I'm hopeful.
You
Yeah,
want
I
to
don't know how
decide
the
things
court-
by
I
eye
wasn't there at the first
contact?
trial, and I don't know how the court is planning
I don't think the record will
design this.
reflect that.
There is, of course, in both directions, a risk of pollution of the jury pool, right?
Right.
You know,
Yes,
so,
absolutely.
so I think that if anybody has, extreme views on anything, maybe that's a way to sort of say that you're going to hear questions, and if you think that you have a view that should not be spoken publicly, and you would
sure.
like to speak to me
Right.
and the lawyer separately,
Right.
you can so indicate when
Right.
you raise your hand.
Right,
And
but
that-
that's part of my instruction.
Right.
Okay, that you can speak in private, and most people start saying, well, I want to speak in private, or you say, do you feel like you should speak in private? And they'll say yes. I'm less inclined to do private voir dire because it just took so long. And the other thing is that, think about it, I think we're going to have 79 on the panel, and we will be able to know immediately, you're going to get five and 3, is that right? Yes,
Yeah.
5 and 3, and for causes, and we'll know whether we need a second jury panel by then.
I just want to throw this out there. One of the things that may speed up the process, if we do have a juror and we think that they may have some potentially prejudicial things to say, rather than kicking everybody out of the room, maybe we can just invite that person up
Yes,
to
so
the
that, I've
bench.
done that, yes, I've done that.
Okay.
I agree, that makes sense.
Okay, was anybody thinking private?
I just wasn't sure.
I think it's easier to do the subset of private when necessary and not invite it at the start. The judges that I try cases in front of always think that if you invite it too early, then it becomes a domino effect. I'm just repeating what other
No,
jurors have said.
I expect a lot of folks will want to speak in private about this, but I just, I think this is different, a little different from Hannah Gutierrez.
And will we be addressing the entire group or just?
Yes, 79.
You'll do the whole group in our questioning?
Yes,
Right.
and then if you can't pick a jury out of 79 folks, which I find highly doubtful, then we'll call in the next panel, okay?
Thank you, Your Honor.
And does the next panel come in that same?
Staggered, yes, it's staggered. That's why when we're finished with the 79, I want to know if I have a jury. So,
Okay.
yes, I want to know how many, and we'll know probably by the 4 causes,
Understood.
okay? All right, well, and so do you want an hour for lunch, or do you,
So yeah, the only thing that I would say about the exhibits, and I mentioned this before, but perhaps we're getting even further, which is, I've just told them about one part of their case that's not going to be necessary, and they disclosed when that witness would be testifying. If the state can even provide some shell, okay, right now we have still at 44 witnesses and 13 experts, any guidance, I'm not holding them to the guidance, the court need not, I'm not going to ask the court to hold them to the guidance, of the gist of the case. The gist of the case and their
Okay.
expected witness, we are going to be able to very, very quickly say, okay, then those lapels, that issue, it becomes irrelevant, and I'm going to be able to deliver to the state what they're going to ask the court for.
okay, very good. So what we're going to do is we're going to take an hour lunch because we're almost finished with these. And then the court is going to instruct you all to meet and confer about what you all think about your cases and streamlining.
Okay,
Okay? All right.
thank you.
All right, we're in recess.
He didn't like that answer. I'm going to instruct you to meet and confer, work it out for yourselves like grown-ups. That is a very difficult directive in a lot of cases, and these guys really clearly don't like each other. Don't trust each other. All the personal stuff going back and forth is going to make that very difficult for them to be able to get on the same page. Well, we're slowly working our way through all these motions here. I think there's about 8 left. Let me look at my little cheat sheet here, see what we're going to have to deal with after lunch. I think we got to get back to the rest of the cumulative expert testimony. The manufacturer of the gun I was talking about before we came back into session. As far as I can tell, the guy's opinion is just that with these replacement parts, the gun is the way it would have been when it came out of his shop. So I don't know that that's a problem. I mean, I don't think he's saying that that means that's the condition it was in at the time of the shooting, but we'll just have to see what the parameters of that ends up being. They want to preclude testimony from Paul Jordan, who was the production safety guy who was hired on Rust after this incident when they started filming again in Montana. And apparently he does not have nice things to say about the conditions on set in Montana either. But the defense says he wasn't involved in New Mexico, so he doesn't have personal knowledge of New Mexico. Therefore, it's not relevant. The state is basically saying that it's part of the same thing, like the prior bad acts that we already heard about, the handling of the firearms on set and things like that. It's not just limited to things that happened before. You can also look at things that happened after the fact. So they're basically just wanting to say, look, he didn't learn. Didn't learn his lesson. He's still doing the same bad stuff. Honestly, I don't know if that helps the state. I don't know if it helps him. He's doubling down on nothing he did was a problem in his mind. So, normally if somebody thinks what they did was reckless, they'd adjust their activity, they'd adjust their behavior. But I don't know. I guess we'll see. And then they want to exclude Lucien and Michael Hogg. Those are the firearm experts that the state has hired to basically say what Alec Baldwin claims happened with this firearm. Cocked the trigger, or cocked the hammer, didn't pull the trigger. And then it inadvertently fired. They say that did not happen, cannot happen with this gun, didn't happen with the gun in the condition that it was in. But there was an issue with the timing of their disclosures because they had prepared several reports, but some of them didn't get produced until April or May. But here it is July, and the defense has interviewed them, and they had a whole big hearing about this, just like I said, last week, maybe the week before. So, not a strong one, I think, for the defense, but they certainly do have to try. Got to try to get every advantage. So then the state's motions that we still have left, there's apparently information in the CAD records, the computer-aided dispatch, that they do not want included, which is fairly standard because people call 911 and say all kinds of things, and that is hearsay. It's often an exception to hearsay because it's a present sense impression. They're describing, this is what I'm seeing, this is what is happening. It's an excited utterance. They're freaked out because something, crazy just happened, and they're, running over their words, trying to get it out to the 911 operator. So I don't know exactly what it is that the prosecution wants to keep out here, and what the state's or what the defense's basis would be to offer it, but it's just going to depend on those details. The state wants to exclude hearsay from Helena Hutchins. The defense claims, and apparently have several witnesses to support the claim, that she was telling him to point the gun in her direction. And so that would, of course, go to his state of mind and it not being reckless or something like that, not going off script. Although the whole cocking the hammer, pulling the trigger would still be an issue. The defense is arguing this isn't hearsay, it's a directive. She's not saying something that we're introducing for the proof of the matter asserted. It's part of the context of what happened. It's a directive. So it's there to basically explain Alec Baldwin's conduct and state of mind at the time. And I think from my perspective, the defense has a valid point there. I think that's likely going to come in. The state wants to exclude a letter that came from apparently about 25 out of 150 members of the crew that said that the rust set was not unsafe. I don't see really any basis for that letter to come in at all. So I think that's unlikely. So that's what we still have on the table once we get back from lunch. Just a few details. So far, I don't really see any of these rulings being particularly problematic to one side or the other. Like I don't see anybody's argument or case being particularly impeded by these rulings. As far as the gun handling, the prior bad acts kind of stuff is concerned, what they're not going to be allowed to talk about, from what I can tell, is that he rushed people. He was generally erratic and aggressive during filming. But that seems to be it. The other things that were specifically the subject of that motion, he used the gun as a pointer. He pointed it at people. He would put his finger on the trigger when he wasn't supposed to. He was inattentive during the safety training. He would engage in horseplay with the guns. And then afterwards in Montana, he demanded not to follow the safety recommendations. They haven't really gotten into this, what happened after in Montana yet. And so I'm guessing that's going to perhaps be fleshed out a little bit more. But I mean, to the extent that it involves gun handling, it seems to me that falls within the parameters of her ruling that, gun handling stuff is okay. You were a general jerk on set is not. So it's really not much of a limitation in terms of what's contemplated for the evidence and what the state intends to do with it anyway. As far as the defense side, they're going to get to go into the civil lawsuits for bias. So the fact that people have a monetary incentive to see things a certain way is valid. They're not going to use her medical records. The guy who has knowledge of the state's investigation is going to be able to testify about his knowledge of the state's investigation. Not clear to me that his letter about how terrible the investigation was is coming in, but really not clear that it's offered. Her ruling was basically what he saw and what he learned is relevant. So his opinion about it really isn't, and that's fairly typical. You never get to bring up sentencing, that's not really an issue. Not using examples of proof beyond a reasonable doubt. You get to argue under the facts of this case whether the jury should have reasonable doubt or not. So that's perfectly fine. The occupational safety report. This one, they clearly want it because they think that it basically absolves Alec Baldwin. But if Alec Baldwin is one of the people in charge of the conditions on set, if he is functionally the employer there on the set, then that would impute to him. So this to me seems like a perfectly fair splitting the baby on that one. If you want to open the door to he's not liable because of this OSHA report, then you have to accept the potential consequences that, given his role, his actual role on the set and what the OSHA report actually found, that does tend to establish he's potentially liable. So you get to pick your poison. What do you want? You can bring it in, and then his producer role is on the table. If you don't bring it in, then it's not. I don't think they're going to bring it in because there's just nothing in there that's, from my perspective, really that helpful to them. It's not exonerating. I mean, OSHA did find, violations and fined the production company for them. So not something that is really a big limitation on the defense either. So all in all, everything that I've seen here, this is like refinement around the edges and kind of forcing people to pick a lane on certain arguments. Don't really have a problem with that. Honestly, of everything I've heard so far, the only thing that slightly alarms me from the judge is the limitations she wants to put on voir dire. If I am representing Alec Baldwin, okay, Alec Baldwin, let's be clear, he's no Johnny Depp. He's no Johnny Depp. But he's been in the public eye for decades. I mean, he's obviously extremely well known. A lot of press about him. Once again, you just have to assume, I would have to assume in this particular neck of the woods, that something like this happening is big news. Just the fact that a film crew is coming to your area is going to be exciting. It's going to get attention. It's going to be covered in the media, let alone then when there's a situation like this, that just, it's reported all over the world. You're going to have a special interest in that in your little small community where this happened. So I do not like this limitation. It seems, first, the parameters of it were really not clear to me. Was she saying that if people say they're familiar with the press about the case, she's just going to automatically exclude them? I didn't really get that clarity because I have a hard time imagining in a panel of 79 people, they're going to get 12, 13, 14, whatever they need for a jury that haven't heard or read about it. Maybe they can. I don't know. I guess we'll see. Maybe they can. And of course, they technically need more than that to deal with peremptories and other cause challenges, hardships, and things like that. So that to me seems extremely ambitious. But also how she's saying the issue is simply, can they be fair and impartial? Well, yes, that is the issue, but that issue is always taking place in a context. And so the context in this particular case is going to involve things like firearm handling. Do you have feelings about that? Are you going to be able to be fair and impartial to somebody based on your own experiences and your own feelings about firearms? You don't go in and argue your theory of the case, but you obviously have to be able to tie it into why we're here in court in the first place. So I hope that she is not being overly restrictive on that stuff, because you do need to flesh out some of those opinions and perspectives in order to be able to evaluate somebody's claim, whether they can be fair or impartial. This to me is just a little too close to the line where the judge is kind of expecting that whatever a person self-reports about their impartiality is the end of the story. And it very much is not. People are often misguided or just, may have the best intentions, but just don't appreciate their own perspective on a situation. So I just hope that's not the case, and that there is going to be plenty of opportunity for both sides here. It needs to be fair. It needs to be fair to everybody to be able to evaluate. You're going to hold it against them that they're from out of town, not doing things. This is a movie set. Firearms involved, all that type of thing. Yeah, they need to be able to explore that. So voir dire isn't going to be televised; it never is. But there will be people in the courtroom reporting on that. So I suspect we'll probably get to see some reports, on kind of how all that unfolded. But hopefully it's not a train wreck. Hopefully they get their jury. I guess we'll just see what we get. So I will go ahead and address the major elephant in the room right now, which is, yes, I know there's a new pleading in Karen Reed's case. It is blown up. I've seen it in my notifications. Of course, it happens like the moment I go live, so I don't have a chance to read through it yet, get a sense of what the problem is. But I do understand that the broad outline of it is that apparently some jurors have reported to Mr. Jackson and Mr. Yannetti that the jury had unanimously acquitted Karen Reed of counts 1 and 3 and had only hung on count 2. Here is the initial problem that I see with this argument. That's not how they filled out the jury forms. Forms 1 and Forms 3 gave the jury an opportunity to be able to acquit on those counts. And they did not apparently fill out that form and send it back as an acquittal. That being the case, what jurors have to say about the substance of what happens in the jury room cannot be used to impeach the outcome. Typically means it can't be used to impeach the verdict. There is no verdict here, but you don't get to litigate what the jury decided based on inside information about what was happening in the deliberation room. That is one of these just areas that is pretty clear black letter law. Not aware of a single jurisdiction where you get to do that. And that's because it would create problems. It kind of undermines the whole process of reaching a verdict in the deliberation room. Sometimes it's a process of negotiation. Sometimes you don't agree with everything. Sometimes you don't necessarily like the outcome. Sometimes you have to compromise on some things in order to reach agreement on others. So there's a lot of the sausage being made process in the jury room that we're not supposed to see. Like, we understand, yeah, that's how it happens. But the verdict, the verdict or the outcome that's reported by the jury, that's it. Anything else that you open the door to is basically just undoing that decision and reopening the whole deliberation process. So I don't know how any of that's going to be able to be considered to impeach the verdict. I really don't. I really don't. Now, that said, I'm going to need to take a look at the motion itself and see exactly, what they said, and just kind of, what the issue is. But my initial reaction upon hearing that is, well, that's really unfortunate, because I don't think they're going to be able to rely on jurors' statements about what happened during deliberations. That's pretty black letter law there. So, but a big problem if that's the case. They're gonna, like, my first reaction to, although this always gets to be tricky too, but you go back into the jury instructions, you look very, very carefully at exactly how they were instructed to go through each of the charges, each of the lesser included offenses on count 2, and you see if there is something ambiguous, something incorrect in all of that. I don't remember that off the top of my head. I remember, of course, that supplemental instruction that Judge Bev gave just specifically on count 2, where she talked about kind of how you walk through, and if you are unable to agree unanimously on this one, then you go ahead and move on to the next one, and so on and so forth. But each of the 3 primary verdict forms for count 1, count 2, and count 3, they did have options to mark guilty or not guilty if the jury unanimously agreed. So unless there's like a big problem in the instructions about how to do that, I don't think this is going to go anywhere, which is very unfortunate. Yeah, don't know what else to say about that. So, guys, we got just a few super chats to go ahead and get through here. If you followed us with the Karen Reed trial, you know what the routine is going to be here pretty quick. In fact, It's already 92 degrees outside. We're having a heat wave here. I don't know where you guys are at. I'm sure you're all over. But yeah, it's not a good season for the bonsai trees. They need a lot of checking. So I will be running out to take an eye on everything here briefly. But then I will be back in time for them to pick back up after lunch. So Desert Cat says, this is a thank you for being the only one to get my high top table reference when you were on Broken Baker panel the other day discussing the aftermath of the Karen Reed trial, LOL. The high tops, I mean, it's just one of those details that was so completely irrelevant, unnecessary, and yet everybody had to hit that over and over and over again. Why? I don't know. Imagine this judge on that trial. I'm not getting the sense here that she is particularly favorable to the prosecution. But I'm also not really getting the impression that she's like bending over backwards for the defense. I think she is doing what, in my view, is appropriate, which is in a close situation, you should err on the defense's side. You should give them the benefit of the doubt. Basically, if for no other reason than because it's just efficient to do it that way, the prosecutor can't appeal if he goes to trial and gets acquitted. So it's only rulings against the defense that contribute to him being convicted that can be the subject of appeal. So for purposes of keeping it clean, even if it's just a pragmatic consideration, it is better to err on the side of the defense. So I really haven't seen anything here that's, unduly out of line, given that posture kind of being the better one in the first place. But boy, imagine her in that trial. You think we would have gotten 12 witnesses telling us about shoveling the fire department apron? Yeah, I don't think so. Mary Malarkey with the news on Karen Reed on TMZ. AJ filed docs today. Yep. I will take a look at that once we get done today and see exactly what I think. But yeah, my knee-jerk reaction, I just don't know that they're going to be able to do anything with that. Jonathan Montgomery, defense tactic, bury the two prosecutors in paper. Well, this is a typical tactic. Actually, in this particular case, I think the state has more motions pending than the defense does, although the defenses have, sub-parts, sub-motions and things like that. So it's not like overwhelmingly one-sided in terms of who's presenting these arguments and who isn't. But this is a fairly standard tactic, especially if you have a big, well-funded defense team like Alec Baldwin seems to have. Yeah, you can win a fight on volume. You throw more punches than the other guy, you got a better chance that some of them are going to land. So it's kind of a good defense is a good offense sort of strategy. You can keep the prosecution on their back foot, then they have a hard time getting adjusted and taking their case to you. So yeah, it kind of is a defense tactic, but that's pretty normal. Alyssa Ramirez, is there a difference between prop guns and other guns legally? If the prop gun, all a prop means is it's being used on a set. That's all it means, is just that it's being used on a set. It doesn't mean it's a fake gun. It doesn't mean anything about like the quality of the item itself. So from a legal standpoint, in that sense, no, a gun is a gun. A gun is a deadly weapon. It doesn't matter whether it is being used as a prop or whether it's being used for defensive purposes or for hunting, anything like that. A gun is a gun. If it's a real gun, it's a gun. The issue here with it being used as a prop has to do with the mental state. And basically because there are these different rules and procedures that have been adopted around the handling of firearms on film sets, would a person on a film set handling a gun in accordance with those rules and regulations have reason to think that they were being reckless? Probably not. So it's going to come down to those rules and regulations. Were they followed? And the state in this case has already kind of highlighted that from their perspective, it doesn't really matter what the set rules say. It matters what the state law is. And so I think they're probably, wanting to go a little bit more down the road of like, well, it's common sense that you don't point a gun at somebody and pull the trigger, kind of thing. But it's just, there's so many competing versions of events about what happened here. It's like if he pointed the gun and pulled the trigger because he was told to, that's one whole, set of circumstances. If he says he didn't pull the trigger, but he did, that's a different set of circumstances. If he didn't, in fact, pull the trigger and the gun accidentally fired, that's a different set of circumstances. So it's part of what they're doing here is they're trying to make sense out of how these general rules are going to apply, given all of these different possible ways that the jury could be looking at the situation, given what all of the different people are claiming about what happened. So it's really ultimately going to come down to mental state. Nobody is really disputing, as far as I know, that this was a real gun and it was a live round, and that the combination of those things are critical parts in the causation chain that led to Helena Hutchins being killed. It's just then the question of what was well. I can't say that. There is some dispute about what was the actual actions, the actual circumstances that took place that led to her death. But then also, related to that, his mental state. And that one I think is really the main issue. But we'll just have to see, I guess. Jonathan Montgomery, these prosecutors argue the facts better than the law. They argue the law in this very, I'm trying to think of how to describe it, where it's just an argument to authority. It's not a meaningful recitation of what the legal principles are. They just like to say case names and that in this case, this thing happened. And so it comes off as just more like, there are cases on my side, therefore you should rule for me, and not, here's what the cases say the law is, and that's why the law is on my side, which to me is what tends to be a far more persuasive argument. I don't particularly like how they argue the facts because they can't help coloring them. They just can't help coloring them. And this annoys me because the facts are the facts. They speak for themselves. They don't need you to come in and explain what they are and what the significance is. That's what you have an opening statement for, to tell us what you expect the facts are going to mean to us. And then similarly in your closing argument, why the facts that we've seen tend to show he's guilty or not guilty of this crime. But for purposes of these types of motions and just general kind of how you phrase your questions and things like that, I just find it so unhelpful to load these kinds of things up and just use this colorful language, waving the gun around like a toy. I don't know. There's a fine line there. There's a balance. I don't love how either of these lawyers tend to just go to a little bit of the hyperbole, a little bit of the exaggeration, and just the coloring everything's up. Like this is not a movie, guys. You don't have to describe what happened like it's a movie of a movie. It's a trial. We can just stick with the facts and the evidence. Track worker says, I don't understand why Karen Reed jury had to agree on all charges. So this is where I'm gonna have to go back and read what is in that motion and potentially check what's in the jury instructions as well. They don't have to agree on all three charges. They can return a verdict on anything they could agree unanimously on. And so if they did in fact agree unanimously, she's not guilty of count 1, she's not guilty of count 3. Legally, they're allowed to do that and then just hang on the one remaining charge. The problem is they didn't mark out the verdict form indicating that they were doing that. And given that, I don't know that their testimony is going to be allowed to be able to establish that that is in fact what happened. Ever aged, feel biased against the bald guy because of Karen Reed. I hadn't even thought about that. The whole parade of bald people there. Also interesting how bias works. Have not seen the evidence, but feel that Baldwin is liable. Yeah, it is. I mean, I think it's normal to have some kind of knee-jerk reactions to situations like this. I don't know all the evidence either. I've seen some of what he says, and I don't really like that. You know, the Stephanopoulos interview, from my perspective, this was a really, really bad call. Really bad call. It's the same reason Karen shouldn't have done the Dateline interview. Defend yourself in court. Don't try to defend yourself in the press. It's just a bad idea. And I think I just feel like this is so likely to be against the recommendation of your attorney to do something like that. No defense lawyer is going to say, yeah, it's a great idea for you to go on Stephanopoulos when you're potentially under investigation for homicide crimes. Like, nobody is ever going to say that. They're going to tell you no. And so you're going to decide, I'm going to do it anyway. This, to me, just speaks to the sort of potential bad judgment that you don't necessarily want to demonstrate when you're on trial for the quality of your judgment. But either way, he didn't come off very well to me. He came off as really pointing the finger at everybody but himself, not taking responsibility for his own role. To me, at a bare minimum, if you pull, the gun is in your hand that kills somebody, that should haunt you. Like, even if you really and truly believe you didn't do anything, I just feel like it would be normal for people to think maybe I did. Kind of like, you know, if you find your boyfriend dead in the snow near where you dropped him off, I feel like it's normal to think maybe I had something to do with it, even if you didn't. That's kind of my instinctive reaction to this shooting, that your first instinct should be like, I'm horrified, I feel so guilty about it, even if I wasn't in fact responsible. Not like within a couple weeks going out in public and insisting how you weren't at fault, you weren't responsible. It was other people's responsibility. It was just, from my perspective, a really, really terrible look. So, yeah, I don't particularly like Alec Baldwin. I don't particularly like him, you know, as a person, from what I've seen, how he talks to his daughter, how he, you know, interacts with the paparazzi. He comes across as rather arrogant and high on himself. He's an actor. I mean, I guess that's kind of to be expected for a lot of people. But it doesn't mean he's guilty. It doesn't mean he's guilty. He's guilty if he was reckless. And where I think this comes in for me in terms of why I would lean towards, you know, bias in favor of him being liable here is because, yeah, pointing guns around at people is kind of inherently reckless in my eyes. And I think that's going to be the issue he has with the jury. Is that a lot of people, especially if they have experience with firearms, they're going to know rule number one, you treat every single gun like it is loaded. You don't get a special exemption from that just because you're on a movie set. It's still a gun. Safety is still safety. You still have to follow the basic guidelines to make sure nobody gets hurt, because look what happens when you don't. This is exactly why you always treat every gun like it's loaded, because mistakes can happen. And that's foreseeable. So, you know, that's my bias coming at it. I mean, I'll be frank. I'll be very frank about that. But that is going to depend a lot about the details of what actually happened. You know, if she told him, point the gun at me, well, that might change my calculation a little bit. That could change my calculation a little bit. So, yeah, I'm waiting to see how all of the evidence comes out. But this is one of those situations where I think the outcome just kind of speaks a little bit for itself. If this was a situation where literally the gun just accidentally fired, then Alec Baldwin's liability comes down to him, whether he should have been on notice that there could be a live round in that gun. I wouldn't get there. I wouldn't get there because, yeah, I do think that, it's just too many layers of unpredictability. You already wouldn't expect the gun to malfunction, but then, you know, you weren't expecting the gun to like be loaded at all. It's just, this is a little bit too far for me, I think, to attribute any kind of responsibility to him. If he's pointing the gun at her because he's told to, and the gun accidentally discharged, then no, I don't think he's liable. I wouldn't vote to convict there. I'm just not sure that's what the evidence is going to show us, but we'll see. All right, guys, I'm going to go ahead and take a quick pause here so that I can go ahead and check on those trees. I'm going to go ahead and put us on notice of the break. I will be back in probably about 15 minutes, so hang tight. Okay, guys, I am back. Beat the court, hopefully just barely, but we'll see. They should be picking back up pretty quickly. So I got a chance to get slightly updated over the break here. And I saw we got a little bit of good news for the state of Massachusetts. Trooper Proctor had his status hearing today and has now been suspended without pay. So this is a good news for anybody who wanted to see Trooper Proctor suffer some consequences for what he has done beyond simply getting a paid vacation at the taxpayer expense. So definitely not the end of the road by any means, but something. We'll take it, a step in the right direction. What I really don't want to see, but what I feel pretty confident we're going to see, regardless of my feelings about it, is that he's just going to be a scapegoat. The whole cultural problem that seems to be pretty evident throughout this department is just going to be brushed under the table. It's going to be just presented as though he's the only bad apple there. So he'll get all the consequences, and therefore everybody else is fine. And oh, by the way, the investigation itself too is just fine because his use of bad words, which is how they're minimizing the texts, his inappropriate language doesn't otherwise undermine the investigation. So you gotta throw him under the bus to be able to get that. But that is kind of an unfortunate conclusion to take from it, from my perspective. I think the rot was pretty evident. So anyway, we'll have to see how else that develops. Also got a chance to read through, not the entire motion and everything, but at least I saw Alan Jackson's declaration about how he was contacted by Juror A and received the information about the jury's decision-making process. Gotta say, doesn't change my thoughts about what's likely to happen here. Very possible response by the Commonwealth is going to be to move to strike. If not the entire declarations, at least the portions of the declarations that are addressing substance of the deliberations. What according to these jurors, they had agreed with respect to certain charges. I don't see a way around it. I really don't. I know that's not the answer anybody wants, but they didn't fill out the verdict form that way. They didn't fill out the verdict form that way. And so whatever they talked about, whatever they thought, whatever they understood in the deliberations, doesn't trump what they do with the forms. So not having indicated on the forms that they were voting to acquit her, I don't think they get to open the door with that, with the conversations with the jurors. So I think there's a decent possibility the Commonwealth will move to strike those parts of the declarations, because you can't rely on that. You cannot. One of the pretty black and white rules that they have in the law, not a whole lot of them, but this is one of them. Don't get to use the substance of deliberations to impeach the outcome. But otherwise, even if they don't move to strike, they're simply going to oppose it on those grounds. And I think that even though factually I don't always like it, legally I think that is the correct outcome. Unfortunately, given what the law is. Now, again, I'd want to go back over, just make 100% sure those jury instructions are clear about how the separate charges can be handled. But I just think the problem is that the bottom line, if they had reached a final a final determination to acquit her, they would have filled out the verdict form, and they didn't. So I think that is unfortunate. And this ties in, guys, there's a reason why. There's a reason why the judge and the attorneys didn't pull the jury when they came back hung. This is why. Because they don't get to, they're not supposed to really even be able to ask about what is going on in the deliberation room, only if it's producing a verdict or not. So I just don't see a way. I don't really see a way around this problem for the defense. Just don't see a way around it. So, very unfortunate situation. I'm kind of hung up a little bit on this last ruling that we got from the judge. The whole basis of the motion was about the crow, right? Not mentioning the crow, what happened on the crow, whether or not Alec Baldwin knew about what happened on the crow, whether the safety standards evolved because of what happened on the crow. It seems to me that what they're anticipating is an argument that Alec Baldwin knew that there were blanks in the gun, right? I think this is a permissible inference from some of the statements that were already made. I think Dave Halls talked about how he said Hannah Gutierrez Reed originally checked the gun when it was empty, gave it to Mr. Baldwin, and then subsequently took it back, loaded it with blanks or with dummies, and then gave it back to him to complete this kind of staging of the shot. So I guess there's an anticipation here that perhaps the evidence is going to show that Alec Baldwin knew that there were blanks in the gun. And so then the question would be, if that's what he thought, would he have a duty to act differently in any way under the circumstances? I mean, the whole point of the crow was that, yeah, pointing a gun at somebody and pulling the trigger, even when it's loaded with a blank, that can be lethal. Even when you think there's no live ammunition in there, that can still be lethal. And that's why these safety standards evolved. So I guess, she's said she's going to allow a one-sentence statement that blanks can also kill. Are they going to be able to ask if Alec Baldwin, say he testifies, are they going to be able to ask if he knew that blanks can kill? Because that's theoretically beyond the scope of what she just said. It's going to be allowed. But that's also kind of directly the issue. The issue in this case is not whether blanks can kill. It's Alec Baldwin's state of mind. So I'm not loving this ruling and kind of how she characterized it. I feel like this is a situation where she's got a thought process for why she said that, but she didn't explain it really what it was. She just said everybody knows guns can kill. Yeah, we all know guns can kill. You don't necessarily need to elicit testimony about that. Not everybody is going to know that blanks can kill. Not everybody is going to know that. That is a somewhat specialized thing, I think, to be aware of, either because you know guns and you know what blanks are, or you have familiarity with movie sets because you've been on them, or you heard about what happened to Brandon Lee on the set of The Crow. It's why I would tend to think most people would probably know that. So she's got some kind of rationale for making this ruling, but it's not helpful when the judge doesn't tell us that. If she had told us what she was thinking for why she's going to allow a one-sentence statement that blanks can also kill, that would help me understand so much better what the parameters are for all of my other questions and all of the other things relating to these issues with state of mind that are going to come up in the course of this trial. But since she didn't give me that, I don't know. I'm going to be stuck guessing, even to the extent that if Alec Baldwin himself gets on the stand and is saying, I had no idea there could have been anything wrong with this gun, any danger, I only knew there were blanks in it. Under this ruling, I don't get to follow up on that. Maybe that would be opening the door. I don't know. This is just what happens, I think, sometimes when the judge is already very familiar with this case because she already sat through one trial. The prosecution has already been through one trial. So they know this case really well. They don't know the defense's case, though. They knew Hannah Gutierrez. They knew her defense. But, got the impression that Mr. Baldwin is presenting a pretty substantially different defense here. And that is, that's reasonable because they're in a very different situation. Very different situation. But what happens, unfortunately, when you get so familiar with the case like that, you forget that not everybody else is as familiar with it as you are. And I'm not just like, poor pity me, the public here who's watching. I'm not saying like they have a duty to cater to me, the uninformed public, about their thought process. But it would be helpful to the defense, I have to think, who was not. They've read the transcript. They've read the transcript of Hannah Gutierrez's trial, but they weren't participants in it. They didn't, take part in any of those arguments, help develop them, or anything like that. So they're not necessarily on the same page as the prosecutor and the judge who've already been through these events in a previous trial. So I do wish I don't know why it is. It's almost like judges are afraid they're giving away too much if they're too transparent with their reasoning sometimes, but it's just helpful. It's just helpful. Because I'm going to have such a better idea of where the judge is going to fall down on other gray areas that might come up in the case, where I'm not really sure if this is relevant, but if I understood your thought process here, I'd be able to predict that a little bit better. And then it just minimizes the risk that you say something, you guess wrong, and the other party gets all upset, objection, you got to run up to sidebar, and the jury is now fully attentive to what you just said because of the flurry of activity that results from it. It would be nice if judges would just go ahead and be like really super transparent. I really think that would be helpful. So the state is now saying they're going to be able to streamline their case. That's good to know. So we've been anticipating for the trial schedule. They had set aside 9 days. So that would mean starting tomorrow with jury selection. It was anticipated that they would do that in a day and then start with opening statements on Wednesday. And then the trial would go through next week, ending on Friday. That's been the anticipated timeline. But so if the defense is not going to be making these causation arguments that apparently I didn't watch all of Hannah Gutierrez Reed's trial, so I don't know all of the ins and outs of what came up there. But apparently criticisms of the medical treatment, that was like a contributing factor to Helena Hutchinson's death. And so if this defense team isn't going to follow that strategy, which frankly to me is wise, that's not a good strategy. It's not a good defense. It's not a good defense. The doctors killed her is not, not a good defense for the person who was in charge of keeping live ammunition out of the firearm. Wouldn't have recommended that one myself. But so this team is apparently not gonna go down that road, and then that's going to enable the state to take a number of witnesses off their list. I hope they give us a little bit of an update when we get back into session about what that means in terms of the time frame that we can expect. It may be it doesn't change anything, and we just have a little bit more luxury of time to get through, you know, the rest of the witnesses that we still have to get through. Maybe the defense will have a little bit more luxury of time to be able to present their case. There always is a little bit up in the air with the defense anyway, because you don't have to you don't even have to decide whether the defendant is going to testify at this point. And so that always is just something that can potentially throw a huge wrench in the scheduling. Let alone now when it's Alec Baldwin, you know, that is not something that you can expect to just be done in a few minutes or whatever. I mean, that would take a lot of time. So possibly just open up more doors for them to be able to do that. I have the sound on, but it looks like the court does not yet have the sound on, so they're getting ready here, but not quite back in session.
All right. Defendant Alec Baldwin's motion limine to preclude inadmissible cumulative expert testimony. Go ahead.
This is the 13 experts all saying related things.
Thank you, Your Honor. And if you'd like, I can also address the Montoya case that you said you'd like to revisit. If you'd like to do that first or later.
Probably.
Okay.
Thank you.
You're welcome, Your Honor. Your Honor, we've moved to exclude cumulative experts and witnesses that the state has intended to call and put on their witness list. 44 fact witnesses, 13 expert witnesses. We have an 8-day trial, 5 or 6 days for the state, many of them duplicative for medical experts, multiple gun experts, multiple experts on multiple issues. And we're in this impossible situation, Judge, where we're a day and a half away from the start of this trial, and we have no idea the order of witnesses they intend to call, which of the
That's
witnesses
normal.
they intend to call.
That's normal.
It's severely challenging our ability to present a fair defense, to
No, it's
present
not.
and prepare for
That's
the
routine.
witnesses that they intend to call.
If they want to waste their time, they can waste their
for the
time.
state to say, this is the case they intend to put on, these are the witnesses they intend to call, and give us some transparency into how this trial is going to be conducted, so that can be conducted in an orderly way with witnesses that we're prepared for and on notice of. Thank you, Your Honor.
This is not a strong argument to me. That's routine. They don't have to tell you the order and who.
I'm not quite
normal
sure how
not
to
to
respond
know.
to that. So Brian Carpenter is a necessary witness. Kent Jorgensen is a necessary witness. Paul Jordan, I'm going to decide whether or not I think I can cut him. I can't make that decision at this moment. The Haigs are necessary witnesses. Pietta's a necessary witness. Ziegler's a necessary witness. Let me tell you why. Even though Mr. Baldwin told OSHA investigators there wasn't anything wrong with this gun, it worked fine. The problem with it was a live round. The defense is centered around the gun was modified, the gun didn't function properly. I've got, how many video exhibits have I disclosed to the court? 40? The reason that you've got so many is because that's how I prove to you that the gun was working fine, is because they're filming him and the gun works fine. He cocks it, it stays cocked. He decocks it, it decocks the way it should. He fires it, it fires. So my witness list and my experts are designed to deal with their defense. And that's what I'm supposed to do. That's what I'm allowed to do. So if they don't want to hear from the Haigs and Ziegler and Mr. Pieta, who's coming all the way from Italy, then they can give up on the silly notion that the gun was modified and that it malfunctioned. But until they do that, there's nothing I can do. I did reach out to Mr. Spiro with a thought about whether or not we could stipulate to the testimony of Mr. Gillette. Mr. Spiro, understandably, was not able to give me a quick answer because it was something that he needed to discuss with his client. And because Mr. Gillette lives in Virginia and is the explosives expert for the FBI, I couldn't just sit on my hands. But hope springs eternal. If we can come to a stipulation with regard to Gillette's testimony, I can strike Gillette. We may not call Dr. Carrillo now that we've heard from them. Finally, let's talk about transparency.
Good Lord.
That they're not
Stop with
pursuing
the
the
whining.
she died because she wasn't properly intubated theory. So we're going to hold Dr. Carrillo in abeyance. And assuming that this issue is never raised, as Mr. Spiro has indicated that it will not be, then she will not be called. But we certainly reserve the right to handle that however we see fit. It's entirely possible that we are not calling Shannon Prince. We will have to call Geraldine Conway because of the defendant's obvious public defense that he didn't pull the trigger. And I don't believe that we're calling Mr. Primo. So that's the transparency that you get from me now.
God, she's just annoying. So unnecessary.
Just briefly, Your Honor. We've got Jorgensen testifying about set safety. We have Carpenter testifying about set safety. We have other people testifying about set safety. They want Mr. Jordan to come and testify about set safety in Montana. We'll deal with that separately. When you look at this witness list, 44 fact witnesses, 13 experts, four medical experts testifying. When you heard Mr. Spiro say we are not challenging the quality of the intubation or the cause of death, this is a witness list that is ballooned far beyond what's even remotely possible in a trial of this length. And so we're asking for, it's a good start of the transparency, appreciate what Ms. Morrissey said, but we need a whole lot more of that in order to put on a fair and efficient trial and to be properly prepared for the witnesses that they intend to call, or else we're going to have witnesses testifying over and over and over again about the same exact subject matter, which is exactly what we're allowed to move
So
to
move to
exclude on the
exclude it when
basis
it
that it's
happens.
cumulative and it wastes time. Thank you.
All right, first of all, I have not looked at the witness lists, so I know the number because you all keep telling me the number, but I'm certainly not in a position to start telling the state which is a better witness for this testimony and which is a duplicative witness. This is their case, and they know how much time they have. You said you'd use 1 to 2 days what is it, 8 days? 8 days? And so the state knows what they need to do. With respect to the roles and responsibilities of producers, that's already out. Brian Carpenter and Ken Jorgensen are not going to, Ken Jorgensen's going to be talking about the safety, but he's not going to be getting into producers, and since producer is out, Mr. Carpenter's going to be left to do firearm safety. So I'm not noted, and I'm sure it's noted by the
I love that. Noted.
state. They're well aware of the time frame. They asked, and I said no for more time. So denied. All right, next up
Good ruling there.
is State's motion eliminate to prohibit double hearsay contained in CAD reports.
So I'd like to, hopefully she tells us
I
what
have
the
the CAD
actual
report in front of me.
statements are.
The narrative statements that I believe are double hearsay that should not be admitted
Thank
are
you.
on page 14. Everything else, I think, is perfectly appropriate as long as the proper foundation is laid for the hearsay exception. So my complaints are just the narrative in 14, and because it's just inadmissible hearsay, I don't think I don't see anything that's terribly prejudicial in those statements. But at the same time, they're hearsay, and they're hearsay within hearsay. So that's all I'm trying to get rid of is page 14. Thanks.
Short and to the point. That's how to do it. Appreciate that. Best argument from Carrie Morrissey
I'll
today.
be similarly brief. Part of what we were going to argue was that we couldn't really do a meaningful analysis since we didn't know what exactly the state was attempting to exclude. We now have that information. Based on the court's directive, we are going to be engaging in a meet and confer after this. I think that would be an appropriate time for us to review what the state has just indicated they believe is objectionable. We will determine whether or not we believe that there are exceptions, see if we can reach agreement. If not, then we can bring this before the court. This should be a very brief analysis based on the number of things they're saying they object to, and I think we can present it to the court before we get started, either tomorrow or the next day.
Okay, thank you.
Yes, Your Honor.
So it is on page 14.
So they'll reserve on that one.
So, Judge, when you've seen these CADs in trial before, what it is police officers call in and they say such and such, and then it gets typed down, or a witness calls in and then it gets typed down. So that's all it is. And one of the reasons that I want to exclude it is because some of the information is just incorrect, and I see that in CADs all the time. For example, they're talking about who's been shot. One 1041 shot in the chest and one male shot in the stomach. He wasn't shot in the stomach. I don't know how they got that idea. But those narrative comments are frequently incorrect, and they are in this case as they are in many cases. So that's it.
All right. Well, typically this information will come in under hearsay, so we'll see how that goes.
All right.
All right. So as long as it meets a hearsay exception, I'll let it in. You all can talk about it, okay?
All right.
Makes sense. See if it's offered and take it
Defendant
case
Alec
by
Baldwin's
case.
motion limited to preclude improper opinion. Oh, we already did that one. Okay. Jorgensen. Defendant Alec Baldwin's motion limited to preclude improper opinion and testimony from Paul Jordan.
Now this is who she said she might be able to not call him. So they're still chit-chatting, I guess.
Thank you, Judge. We've moved to exclude the testimony of Paul Jordan. Paul Jordan was not on the set in New Mexico in October of 2021. He knows nothing about what happened on the set in October of 2021. He said he read about what happened there, a little bit on the internet, heard some hearsay from some witnesses, but has absolutely no knowledge whatsoever. And so what does the state want him to testify about? They want him to testify about what happened 2 years later in Montana. They want him to say Mr. Baldwin had difficulty getting on and off a horse, and therefore apparently defies safety guidelines because a man with a hip replacement gets off a horse in such and such a way, and therefore the crew's unsafe.
If it's about a
They want
horse
to
and not a
testify that Mr.
gun,
Baldwin,
it
he wants
shouldn't
to
come in.
testify that Mr. Baldwin had an attitude. We asked him anything else. He said, I don't think so. Mr. Baldwin had an attitude. Trying to introduce evidence from what happened in Montana, completely different circumstances, different people, different reasons for the movie, different facts, entirely distinct 2 years later, has absolutely no bearing on whether Mr. Baldwin should be convicted of involuntary manslaughter 2 years before.
if this is a fair
Thank you.
characterization, I am totally with the defense on this one. So state better tell me something more handgun related.
Having already indicated I may cut Mr. Jordan off of the witness list, I will indicate that that's not what we would call him for. None of what Mr. Nick has said really is why we would call Mr. Jordan. Mr. Jordan was the safety consultant on the continuation filming of Rust in Montana. The unions required that the continuation of the filming have safety consultants who had complete autonomy, who could not be overruled because of the obvious issue that took place in New Mexico. What Mr. Jordan indicated is that Mr. Baldwin insisted, and that was his word, that he, Mr. Baldwin, not have to follow the safety consultant's safety recommendations. Stunningly. 2 years later. And we've given the court the law that says that subsequent bad acts are admissible. This goes directly to this ongoing willful and wanton conduct. It is just additional information of willful and wanton conduct. Thank you.
They're a lot tighter with their arguments this afternoon. I'm very much preferring this to the morning session.
You know, this is the same 404B other acts evidence that you excluded with respect to what happened before. Now they're trying to do it after. There were no live guns on the set in Montana. They were not real guns. There's no possibility of harm with what they were doing. We asked Mr. Jorgensen, what did Mr. Baldwin do? He didn't say he was unsafe with guns. He said getting on and off a horse and attitude. Has no bearing on Mr. Baldwin's use of guns on the set in New Mexico. In the case that Ms. Morrissey's alluding to is the Riggio case that we talked about with the 404B evidence, where the individual lied about his commercial trucking license application before, and that was the predicate act for the crime, and then lied about it after, which showed that A, he committed the predicate act, and B, he was aware his physical condition didn't allow him to drive because it was dangerous. That's not even close to what they're using it for here. They're trying to show that Mr. Baldwin had an attitude and didn't comply with horse riding regulations or safety guidance, and therefore was reckless with a gun 2 years before. There's no connection. It's highly prejudicial. There's no basis for admitting that evidence here, Your Honor. And certainly not from someone like Mr. Jordan as an expert.
Thank you. The court makes the following ruling. This falls under Rule 11404, prohibited character evidence. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with a character or trait. So it's not coming in. Thank you. All right.
Propensity. She just said that's propensity.
State's motion to eliminate to prohibit hearsay statements allegedly made by the victim.
This is one the state, I think, is going to lose.
To try to cut to the chase here, I agree with the defense position that the statements that Ms. Hutchins is alleged to have made, and I indicated to the court that the vast majority of the witnesses do not support that she made these statements. Mr. Baldwin did not tell Corporal Hancock that she made these statements. In
Save it
fact,
for
he
the trial.
indicated
It
to
doesn't
Corporal
matter for
Hancock,
this motion.
that it was a male who was telling him where to point the gun.
It doesn't
Mr.
matter.
Baldwin referred to that
Make your
person as a
point.
he. In the context of that interview, it would appear that Mr. Baldwin was referring to Mr. Souza. So it isn't until later that Mr. Baldwin begins to create this narrative that it was Ms. Hutchins who was telling him where to point the gun, and that's how she ended up getting shot. So
Bring it out at trial.
if Mr. Baldwin takes the witness stand to testify, I believe that it comes in for the effect on the listener. I agree with them there. The other witnesses, the other 2 or 3,
It can come in if he doesn't
disagree. I don't
testify.
believe that it has an effect on them as the listener. So these statements are highly unreliable. They are so unreliable that Mr. Baldwin himself
That's for
indicated
the
that the
jury to
person who was telling
decide.
him where to point the gun was Mr. Souza. So I don't want these statements that have absolutely no indicia of trustworthiness to be admitted by the 2 or 3 witnesses who seem to say that she said something. And as I indicated in the motion,
That's
those
admissible.
witnesses can't even agree with
It's
each other
their personal observations.
about what she said and
And it's offered for
how that could have directed
his mental state.
Mr. Baldwin's conduct. All of them agree that Ms. Hutchins did not say, "Point the gun at me." There is only one witness who says that Ms. Hutchins told Mr. Baldwin to cock the gun. The other 2 witnesses who support that she said anything at all agree that she did not tell him to cock the gun. So I just want to get this ironed out before we find ourselves in trial, and we have all of these completely unreliable statements coming in from witnesses. who don't.
Reliability is for the jury. This is annoying. She's going to lose this one, and she should lose this one.
So, Your Honor, first I want to start with the fact that we seem to have skipped a step in the analysis with the state. The state has, kind of initially, at least in their motion, jumped to whether or not Ms. Hutchins' statements would have fallen under the hearsay exception 8033. But there's another analysis that has to happen first, and that is whether or not the utterances or the words that were spoken actually even meet the definition of hearsay, period. First, it has to meet the definition of hearsay before you have to get into the analysis of whether or not there is an exception that applies. Because if it doesn't meet the definition of hearsay, the analysis ends there. It's not hearsay, so we don't have to get to the exceptions. So what we do is we look at the words that were uttered, and then we see whether or not it falls under 11801. And 11801A defines a statement, which it must be, as a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. And so what's central to that is that the words that were uttered have to have been intended and have been an assertion. And the case law is clear about what that means, and we'll get to that in just a moment. The second paragraph, paragraph B, has to do with the fact that the declarant is the person who made the statement. And then C is where we get again into what happens with the statement. And C says, hearsay means a statement that the declarant does not make while testifying at the current trial or hearing, so it's an out-of-court statement. And 2, that a party offers an evidence to prove the truth of the matter asserted in the statement. So again, central to all of the definitional pieces of 11801 is that the words that were uttered have to be intended as an assertion. And there is case law on that, which we have cited in our motion. And the case law very clearly indicates that non-assertive statements are not hearsay, and that means a statement that cannot be proven true or false.
Wow.
So an assertive statement
not
would
hearsay.
be, the car was blue, the light was green. That is something that can be either true or false. It's true if the car went through the light and the light was green. It is false if the car went through and it was actually red. Other words or utterances, like commands or directives, are not assertions and therefore not statements under the definition of hearsay. So, for example, point the gun here, or let the gate down, or don't jump in the puddle. Don't jump in the puddle is a directive or a command, and it is not true or false. It's just a statement. It's a directive, rather. And so by definition, it is not hearsay. It does not fit the definition of hearsay, so you don't even have to go into whether or not there is an exception that would apply. It doesn't fit the definition, and the analysis ends there. And so in this case, what we're talking about is the statements by Ms. Hutchins, which would have been directives. Point it this way. Show me the action. Show me the action is not a statement that can be either true or false. It's a command to do something. And so therefore, under the case law, which we've cited to the court, it's clear that that is non-assertive utterances that therefore are not hearsay. So the analysis should end there. Because the state addressed these other issues, I will address them as well, although it's not necessary for the purpose of this analysis. So the state tries to say, state of mind, and I believe they just conceded to some degree that they said if Mr. Baldwin testifies, then his state of mind becomes relevant.
Yeah.
The state misunderstands what the rule is with respect to the effect on the listener.
I agree with her on that.
There's no rule. Again, that's an instance where you say, okay, we're not offering it for the truth of the matter asserted, again, because there has to be an assertion, but rather for the effect that the utterances would have had on the listener. It doesn't say the effect on the declarant, it says the effect on the listener.
And there can be
And if Mr.
multiple
Baldwin
listeners.
is being given directions by
Yeah.
Ms. Hutchins, then it would explain why he did what he did, and that would be the effect on the listener. And we can look at the circumstances, the surrounding circumstances, to give us an indication that he did then rely on those statements. Now, lastly, the state also talks about that this would be potentially inadmissible because they're concerned that there's this disagreement between the witnesses as to whether or not she
That's
said
normal.
anything or what she said or didn't say.
Witnesses disagree all the time.
The
But a lot
jurors,
of the
though,
prosecution's
are the finders
witnesses
of
are going to
fact, Your
disagree.
Honor. The jurors get to hear all of the testimony, and
Yep.
they get to make the determination about whether or not they think she said anything. If she did say something, what they think she said. That's literally their role. They are the finders of fact. And they get to make a determination as to credibility of the witnesses. And we actually have an instruction in New Mexico. There's an instruction, it's 14-5020. And that one says that, among other things, the witnesses can determine and consider the witness's ability to observe, the witness's truthfulness or untruthfulness, the witness's motivation or bias to testify a certain way, among other things. So the jurors are going to be instructed as to how to consider credibility and what weight to give the different witness testimony is going to be up to them. But I want to add that I think it's a little bit difficult for the state to argue that the admission of these statements is just unreliable, because we actually have in the statement of probable cause, which I have a copy here for the court's convenience if I may approach. And if the court will turn to the second page under the statement of probable cause, I've highlighted a sentence there, which states, and again, this is the prosecution's statement of probable cause, which was signed under oath. And we have, Baldwin was practicing drawing and pointing the weapon for the scene with guidance and instruction from Helena Hutchins and Joel Souza. That's in their own statement of probable cause. And so I think it's a bit difficult for the state to argue that there's not enough indicia of reliability or relevance or import for this to go to the jury when it made it into their statement of probable cause.
Now she's just playing tit for
And so
tat
for
with
those
the
reasons, we would ask that the court deny the state's motion.
litigating for the audience. All right, Morrissey, what do you got with this loser argument?
Cause number D101CR 2023-00039. That case is no longer pending. Because when I took this case over, I had to make a lot of changes. And one of the changes that I had to make was getting rid of the person who wrote this for his inability to fully understand.
We know
the
you don't
facts
like
of the
Mr.
case.
Schilling.
So here's the issue. I have a transcript of Mr. Baldwin's statement to Corporal Hancock in front of me. This is Mr. Baldwin's statement. I believe, my recollection is, she was there, turned a bit, like talking to him. He's saying Ms. Hutchins was talking to someone else, obviously not Mr. Baldwin, not the speaker. So I think she was hit in the right armpit, but this is all I know. And that is that I take the gun out in rehearsal where he wants it, very dramatic and very slow, trying to sneak up on them. I take the gun out, and as I take it out, it clears, the barrel clears, the hole, turn and cock the gun over here, I turn and cock the gun goes off. That's just one of his numerous statements where he indicates
We know.
that it was a male who was telling him where to point the gun.
That's fine. The jury gets to
so-
decide.
Part of the problem is that, sure, the defense can come up here and say, this isn't an assertion, this is a directive. Their own client didn't say that it happened. Never at any point in time during this interview does he say that it happened. And the vast majority of the witnesses who were in the room don't say that it happened. Now, is Mr. Baldwin allowed to forget a detail, obviously a very important detail, and then testify different when he's on the witness stand to what he said to Corporal Hancock? Absolutely. But he's got to take the witness stand to do that. That's my position with the court. Thank you.
That's a terrible position.
All right, the court makes the following ruling. First of all, assertions can be, or directives can be assertions. So I certainly researched that. But what I'm ruling is that the statements are not being offered for the truth of the matter asserted. That the statements were said in defendant's presence, and had effect upon the listener demonstrated by his actions. I have done a lot of research on the case law to make this ruling as to whether the defendant has to testify to be able to get that
No, he does not.
exception in, and I have read many cases where another person testified that the defendant was there and that he heard these words. So I'm going to let it in on that exception. And then that will obviously be an issue for the jury. Thank you.
Obviously an issue for the jury.
All right, next up.
Not exactly a smackdown from the bench, but come on, Morrissey. Way to waste all our time.
I'm not totally sure where we are. Is it my motion in limine 11?
Well, just a second, we did the crew letter. I don't know how that happened.
I don't think we did do the through letter. We didn't.
Oh, we didn't do, just a minute, all right.
We have P other as well.
Right, yes, okay, thank you. D1. All right, let's do the crew letter.
The crew letter. This one should be out, in my opinion. Not relevant. The defense can call these witnesses if they want to combat the evidence of the unsafe set.
Well, signed. I think Therese Davis wrote it, but I'm not 100% sure. I'm not 100% sure who wrote it, but there is a letter. There was.
Yeah, okay, sorry, I'm fine. In my mind, I was thinking the crow, but yes, I'm ready to do the crew.
Okay, great. So I don't know exactly who wrote this letter, but I think maybe 24 or 25 of the crew members signed it. Only 2 of the crew members who signed it were in the church at the time of the shooting, and the letter basically says this was a safe movie set. Let's forget about the fact that a human being died and another one got shot. So they get about 1/6 of the crew to sign this letter. The other 5/6 of the crew apparently declined to sign this letter. It isn't something that I recall being signed by Mr. Baldwin, and there are only, off of memory, I think 2 witnesses who signed the letter who may testify in the trial. So what I don't want to get into is we've got a witness on the witness stand who's giving testimony about what they saw, what they heard, all of the relevant testimony, and then all of a sudden they get asked, and isn't it true that you and 25 others signed this letter saying that the set was safe? That obviously doesn't come in. That's hearsay all day long. And I'm looking at the defendant's response. The state's assertion fails to note that Baldwin's prior statements can be introduced by the defense to rebut a charge of recent fabrication.
Doesn't have anything to do with the letter.
I don't know, I have struggled, this is in the last paragraph of the defense response. I don't really know what they mean, because Baldwin, I don't think, wrote the letter, and he didn't sign the letter, so I'm not sure what this letter would have to do with his prior statements to rebut a charge of recent fabrication.
I don't see that link either.
The defense has also indicated if a witness testifies in a manner that is inconsistent with the letter's contents, or if a witness raises the crew's position about issues raised in the letter, then the letter may be admissible. I disagree. It's a letter that is completely irrelevant. Not only is it completely irrelevant, it's absurd. As the defense has indicated.
God, so annoying.
People hardly ever get
Why does
killed
she
on
have to
movie
do
sets.
that?
So for a person to get killed on a movie set kind of inherently means it was a pretty unsafe set. So I filed this out of an abundance of caution.
Not necessarily.
I was actually kind of anticipating when I filed it that the defense would say, we agree, we're not intending to introduce the crew letter, but apparently they'd like to try to get into it somehow, and I just want the court to be aware we've got major hearsay problems here. Thank you.
Thank you.
Absurd.
You know, this is one of those evidentiary issues that should really wait for the context in which it comes up or not. And the reason is this. You already heard the state say, we're going to put on the medic to say, I believe the set was safe, or the camera grip to say this was a safe set or not a safe set. To the extent any witness they put up says, the whole crew thought this set was unsafe, or they signed the crew letter and they get up and testify that it was an unsafe set, contrary to what they signed in the letter. We're not offering the letter to prove the set was safe. That would be the use that would not qualify under any hearsay exception, because we'd be using it to prove the truth of what's said in it. To the extent it comes up and we use it, it's only to demonstrate that a witness testifies inconsistently with what they signed, or their statement that the whole crew thought this was an unsafe set is inconsistent with what other crew members said in that letter. Not for the truth, but for inconsistency, for example, for impeachment, for example. And so the circumstances in which this come up could make it inadmissible, in which case we wouldn't use it to prove the truth, or it could be highly relevant to what the crew member who signed it is now saying on the stand, and to be denied the opportunity to confront somebody who signed that statement, for example, who says something directly contrary to it, to not be able to put that in front of them to say, well, what you're saying conflicts with what's in this document. That's not hearsay, that's admissible, it goes directly to the testimony they are given. Second point, the Baldwin statements issue, the state said in its brief, and by the way, in this brief, Baldwin's statements shouldn't be offered by the defense. Now, we have no idea what that means in the state's brief. Our point was, if we're going to offer his statements, or if they are, you have to wait and see the context in which that arises. We were just trying to preserve any right we have to argue that in one situation or another, the statements should come in or not come in, but I don't think there's a ripe issue for Your Honor to rule upon. We were just reacting to the state's one sentence in its brief, which we didn't understand, so out of an abundance of caution, we wanted to make the point that we're not waiving any rights on that. But I don't think there's a ripe issue for Your Honor to rule upon with respect to Mr. Baldwin's statements.
Thank you.
Thank you.
I apologize, I was confused, I get it now. So I think we're agreeing generally, absent something unforeseen, that the crew letter doesn't come in as substantive evidence. So we'll deal with any outlying issues should they arise. The defendant's statements, if offered by the defendant, are inadmissible hearsay under 11801 as the party opponent. He is not his own party opponent.
Yes.
So I can introduce his statements because he's my party opponent. He doesn't get to introduce his own statements because they're hearsay. So I just wanted to have some record generally that the defense doesn't get to start bringing in the defendant's statements through other witnesses. That's all it is. And I'll make my objections appropriately during trial.
That's it, we're done. Thank you.
That's
All right, the
it.
court
No
rules
more
and
from
re-
you.
As follows. The Crew letter is an out-of-court statement expected to be offered for the truth of the matter asserted, and as such will be excluded based on hearsay. It could not be used as a prior and consistent statement unless the testifying witness participated in the letter and the foundation is laid. It cannot be used for impeachment otherwise because what the witness testifies to about the conditions on the set is his or her testimony. The defendant would have to bring in a witness to state otherwise, not use this out-of-court statement to impeach the testifying witness. To do so would be an end round against the prohibition against hearsay. I think we're all in agreement. It just seems like we all said the same thing. Okay? Thank you. So that's granted today. All right, let's get back to the Crow.
We're going back to the Crow.
No, it wasn't the Crow letter. It was inconsistent factual assertions.
Oh, yes. I don't want to go back to the Crow.
As Your Honor knows, we cited multiple cases in our briefs saying that the government, as a party opponent, are allowed to introduce statements that they've made if they're inconsistent. It's black letter law in a number of cases. In fact, the state's brief acknowledges that it's black letter law. Your Honor mentioned the Montoya decision. I've read that, and this is consistent with our position. Your Honor, in that case, the prosecutor said an opening statement to the jury, you are going to hear a witness testify that that witness heard another person say X. The second trial, the defendant said, I want to introduce the prosecutor's statement in the opening as an inconsistent statement in this trial. And the court said, well, you're not allowed to do that because it's not an inconsistent statement. It's the prosecutor saying what the jury should expect to hear from someone say about what someone else said, double hearsay. And the court said, and this is really important, the prosecutor's opening statement to the jury was not an obvious admission of fact that might have constituted an admission of a party opponent. In other words, if it were, we'd admit it, because that's black letter law, but it's not. It's a prosecutor giving a sort of preview, not making an assertion factually,
Which
and
is
therefore it's not a
kinda
party opponent admission. It doesn't come in.
What all prosecutor
Here,
statements
the statements that we are intending to use are not comments on what the jury might hear from a witness who talks about another witness's statements. These are statements that are clear, direct. Ms. Gutierrez-Reed's training of Mr. Baldwin would not have made a difference. Now they want to come in, potentially in this trial, and say, if Mr. Baldwin just did the gun training, it would have made a big difference. That is a direct inconsistency. It's not a comment about what a witness might testify about another witness's statement. The same thing is true about Ms. Morrissey's statement that Hannah Gutierrez-Reed is the autonomous decision maker, and so forth and so on. We've listed a number of these statements in the brief. These are direct factual assertions by the state in the prior case. The black letter law is that that's a party admission, party opponent admission, and therefore it
I
comes
don't
in.
agree. These are arguments for how to
Montoya
interpret
case
the
is
evidence.
consistent with that, and therefore believe it supports our position that we should be able to introduce this at this trial. And that's, again, consistent with what the state told Your Honor to rely upon in Justice Thomas's concurrence. If the prosecutor wants to make those statements, that's fine, but there's a risk of undermining the prosecution's case because the second defendant has every right to present them to the fact finder as contradictions. That's from their own case, and that's exactly what we're asking the court to allow us to do here. Thank you, Your Honor. And unless you have questions about the Montoya case, thank you.
Is this a defense or a state?
It's a defense.
Which number is it?
I believe it was defendant's motion on limiting number 5.
Number 5?
I believe so.
Okay, all right, go ahead.
Your Honor, I would respectfully submit that the defense is narrowly reading Montoya. So you have two different trials of two different defendants. So the prosecution can say X in trial of defendant one with the facts that are available and still present a different argument with the same set of facts, but as to defendant number two.
Yeah.
And so the statements made by Ms. Morrissey during her arguments to the jury in Gutierrez applied to Gutierrez, applied to her culpability. That doesn't mean that the state should be bound or that the defense gets to introduce her statements to the jury in Gutierrez because they pertain to Gutierrez. This is a different defendant, and so the facts are they're still the same well of facts, but the facts that we're drawing upon for this defendant are slightly different than the facts on Gutierrez. And more importantly, even if the court were to find that, well, okay, statements by a prosecutor are admissions by a party opponent, the court still has to subject that decision to a Rule 403 analysis. And under Rule 403, allowing the defense to introduce the statements Ms. Morrissey made out of context, so they're picking and choosing specific statements they want to introduce, would create confusion to the jury. It would be misleading to the jury. So the statement that counsel indicated that Ms. Morrissey made about Ms. Gutierrez being the autonomous individual, that pertained to Ms. Morrissey's argument as it related to ammunition. With regard to another statement that Ms. Gutierrez was not rushed, but yet in this trial, one of the issues is the defendant rushed Ms. Gutierrez.
They're not going to be able to bring that out.
That particular day on October 21st, but rushed on other days to reload the firearm. So these would be completely taken out of context, Your Honor, and the court has the discretion to not allow these statements to be introduced as admissions by a party opponent. And I think that Montoya does apply because these are arguments by counsel that the court should exclude at a minimum under Rule 403. Thank you.
Just a couple minor points, Your Honor. The case law is not distinguishable because that was a defendant in one case, and then there's a defendant in a second case. That's the only situation in which the party opponent admission rule comes up. Every single time a defendant in the second case says, I want to have the fact finder consider the contradictions that were said in the first trial, and the court said, yes, you're allowed to do that, that's a party admission. Every single one of those cases involved two different defendants. And so trying to distinguish this case by saying, well, that's Hannah Gutierrez and this is Mr. Baldwin, there's not a single case where a party admission was allowed in this context where that wasn't the case, two different defendants. That's what the case law stands for. The element of confusion that the state is relying upon, they're saying, well, you have to balance 403. Every single case, black letter law, party opponent admission comes in, as long as it's not, hearsay upon hearsay upon hearsay, where a prosecutor saying, this is what to expect, that's not an admission, it's admissible. And so these 403 balancing was in play every single one of these black letter law cases where the court said it gets admitted. And as Your Honor knows, 403 is an extraordinary remedy. So to apply 403 balancing and say it'd be too prejudicial when the black letter law says, as a matter of law, it's not because you're allowed to introduce it, there's no case to support that, Your Honor. The statement should be allowed.
Thank you. The court denies the defendant's motion. This is an issue that the court has discretion on. I'm not mandated to put it in. I have the discretion on whether to put it in. First of all, I don't think that what the prosecutor said in Hannah Gutierrez's case is relevant to a relevant fact. And even if it is a relevant fact, its probative value is substantially outweighed by unfair prejudice and confusion to the jury. In addition, I don't think the theories are inconsistent, but a continuum. Hannah Gutierrez loaded the weapon with live ammunition. Defendant Baldwin took that weapon with live ammunition and, according to the state, failing to follow firearm safety as an actor on the set of Russ, which continued into October 21, committed involuntary manslaughter as well. So I don't see it as inconsistent theories or inconsistent fact assertions. maybe separately, hanging out there in one sentence, but I'm denying the motion. All right, next up is the Pieta. Defendant Alec Baldwin's motion in limine to preclude improper opinion and testimony from Alessandro Pieta.
Thank you, Your Honor. The state intends to offer Mr. Pieta for 2 general opinions, maybe many subcategories, but to sum it up, 2. One, according to the state's brief, that the gun appeared to have been broken when it was in full cock position. And number 2, the quality control standards that Pieta applies, the strength of the steel of the gun, and the overall condition of the gun when it left the Pieta factory. And they intend to do that because, according to their opening of the brief, to show the functionality of the gun on October 21st. But if you look at the actual trip this gun took after it left Pieta's factory, it went through a show, it went to a distributor, it went to Seth Kenny, and it went to this set. Mr. Pieta hadn't seen the gun leading up to his PTI for 7 years. He had no idea what happened to it. He had no idea if it was modified or not. He didn't inspect the gun. He didn't review the gun reports. He barely knew what happened in this case other than there was an accident with the gun. And so to allow him to testify about the circumstances under which the gun appears to be broken when he hasn't inspected the gun
Well, they get to
itself,
bring that out.
or looked at the reports, or done any testing,
gets to establish
is
that it
improper
wasn't a
testimony
manufacturer's
as someone who has
defect.
not relied upon any information that an expert would need to rely upon to give that kind of opinion, first off. Second of all, the quality of the gun when it left, the steel strength when it left, has no bearing on 7 years later, or 4 years later when the accident occurred, what the condition of the gun was. The testimony that Mr. Pieta might offer on that could be wildly misconstrued by a jury, highly prejudicial, because it was hard steel and it was made with quality on December of 2017. Therefore, the gun was in perfectly working condition in 2021. There's an enormous gap there, Your Honor. And to offer that testimony from 2017, after so many things happened to that gun, as to the condition in 2021, is more prejudicial than probative. Thank you, Your Honor.
They can bring in all of those external circumstances. I don't see that. I don't see that being a basis to exclude.
We have a made-up defense of the gun was modified, the gun wasn't functioning properly. There's not a single witness who is going to support that. Not a single witness, including the defendant himself. Yet, the defense is going to be put forth. If I don't call Mr. Pieta, we're going to find ourselves in closing arguments, and the defense is going to say to the jury, you don't know how this gun was manufactured. Maybe there was a mistake. You don't have any idea what condition it was when it left Italy. It could have left Italy in this condition, and then it made it to EMF, and then it made it to Mr. Kinney, and then it made it into poor Mr. Baldwin's hands, and it malfunctioned. That's what they're going to do. I can't let them, so I am bringing the man who owns the manufacturing company to testify. Moreover, if the court recalls from our response, this is a conversation that Mr. Nickus and I had back right around the time that I initially dismissed against Mr. Baldwin, where Mr. Nickus said, this shiny hammer, the color of the metal doesn't match the metal on the rest of the gun. We think this is a modification. So then we get Mr. Pieta to come in because we want to know, is this a modification? Mr. Pieta says, heavens no. He says, I picked out that shiny hammer because we decided that we were going to make this gun look more like a Colt so that it could be used in gun shows. That's the purpose of his testimony, and it goes directly to their defense.
I have a question.
Sure.
It says, Mr. Pieta, you've talked about the parts did not leave Italy in their current condition and will testify to what... Mr. Pieta can testify that the broken parts of the gun are Pieta parts. The parts did not leave Italy in that condition and will testify to what parts are broken. Mr. Pieta can also testify based on his knowledge of the parts and the internal working mechanism of the gun that the hammer, sear, and bolt appeared to be damaged when the gun was in the full cock position.
He said that during his pretrial interview.
I didn't see that.
He said it in his, I think he said it in his pretrial interview under questioning from the defense. Let me look for it in his transcript if you want me to. I can do a quick word search on his transcript. Under questioning, he indicated that from looking at it, he could tell that it was, because he's Italian, I don't know that he used necessarily, I think he said it was in the firing position. I don't think he used full cock, and I think that was part of the language barrier. Do you want me to see if he said it in his, I can pull it up for you.
That's all right.
Okay.
Two things, Your Honor. That's exactly the concern we have about Mr. Pieta. He hasn't inspected the gun, hasn't reviewed the gun reports. To look at a picture of a gun he saw 7 years ago and to say, I think the damage occurred this way, that is not reliable expert testimony. He hasn't inspected it. He has no idea the conditions under which it was used, the conditions of the FBI testing. He hadn't even heard the FBI tested it, didn't know what was done. And so for him to give an opinion on what caused the damage, highly unreliable.
He didn't say
no
what
basis
caused the
whatsoever
damage.
Demonstrated. He has no facts about
What position
that,
it would have to
and
be
it would
in
be hugely prejudicial to admit it.
for that
number
damage
one.
to result.
Number two, there's no evidence in this case that the gun left the factory broken, that it was modified with the hammer at the factory. The testimony that you heard from the Haigs, for example, about the FBI testing is whether the FBI broke it or not, whether it was modified beforehand by Seth Kenney. No one thinks that it left the Pieta factory with a hammer ground down or sideways marks on the sear. That's not at all an issue in
If you're
this
saying
case.
it might have been
And
modified,
again, since it's not
his
an
testimony is
issue in this
relevant.
case, it would be prejudicial for Mr. Pieta to come in and say, we make very strong guns, we make guns that are quality guns, to give the impression to the jury that, well, this must have been a functioning gun in 2021 because in 2017, after long before many, many things happened to it, it was a strong functioning gun. That's unreliable, that's prejudicial, it's far too far away from the circumstances of 2021 to be admissible.
The court makes the following ruling. The court finds that Mr. Pieta is properly a fact witness. He's not an expert witness. He can testify to his knowledge of the gun before it left the factory. He can say it was a functioning gun if he tested it at that time. I think that you want the court to follow down the meander of strong functioning gun. He's not going to say strong. He's going to say that it was functioning, and I think that the creation or origination of that gun, for purposes of what Ms. Morrissey said, that so that in closing it's quelled with respect to where's, in so many words, how do we know it was looking good when it got manufactured? So he comes in, but his testimony is going to end to his knowledge of when it left the factory. He can't testify. He just learned that it was broken by somebody told him the FBI broke it, and all he can say is, yeah, it's broken.
Understood. And just so that I can structure his testimony within the court's ruling, I won't have Mr. Pieta give any opinion on whether or not what position the gun was in when it was broken or anything like that. I would like to have him, if he can, because we're going to have the gun and the parts here in the courtroom, prior to his testimony, I would like to show them to him and see if he can identify, yes, these are the original parts, if he can.
If he can.
And in addition to that, part of his testimony that the gun left his plant in good working condition has to do with the quality control measures that they institute within his manufacturing plant, so they don't have guns that leave that then go malfunction. So a little bit of testimony about quality control, I would ask the court for a little leeway there, but I understand the ruling. We won't have him talk about his thoughts on how the gun got damaged.
All right. Thank you. All right, is there anything else? State? Did I cover everything so that we're ready for jury selection and trial?
I believe we are, if the court wants to take a few moments
Well, he
to
don't look
address my
happy.
concern with the exhibits.
I thought you all were going to work on the exhibits.
Well, I've got some concerns based on the looks of their exhibit list that a meet and confer isn't going to resolve this issue.
We have a couple concerns of our own with some exhibits that were just disclosed yesterday.
Well, give me a copy if you want, because this will be the first time I'm seeing them, so.
There is also a defense motion to compel that was fully briefed over the weekend. If the court is willing to consider that today, we can address it.
No, I'm not. Why are you writing documents and then not giving to me and then we're her? What do you mean? The motion to compel? Oh, you mean the big motion to compel?
Yes, there is the motion to compel that was just finally.
You can make arguments on that, but I'm not going to rule from the bench if you want to do that. Do you want to do that?
It's their motion, sure. Ms. Johnson's responding to it.
Okay. You didn't do a notice of completion of briefing, but okay.
We did submit it, Your Honor, but I can
Okay,
resend it.
that's fine.
Yes. So, Your Honor, I know that this is unfortunately something that we've brought to the court on more than one occasion, and I know that this is not the time that the court would prefer to hear these issues. However, precisely because we are at the eve of trial is why we have to bring this up to the court again. As the court knows, under the laws of New Mexico, the state has an affirmative duty of production, both under the rules being 5501 and also under Brady, Giglio, and all of those. So it's been apparent from early on in the case that we were not receiving all of the productive documents and discovery that we should have been receiving. We've detailed in our motion the numerous attempts that we've made to try to address those concerns. They were not addressed at any point. And I'm going to focus on the reply that we did submit to the court because the circumstances have now changed to some degree in a fairly material way. And that is that initially we had been corresponding largely with Ms. Morrissey, who had been the prosecutor on this case for quite some time before Ms. Johnson came on. Our requests for production and our concerns about it looking like we had incomplete discovery, like it looked like we had incomplete disclosures, were constantly met with, you have everything, there's nothing else to give you, or if you tell me specifically what you're looking for out of these, IPRA productions that are redacted, tell me specifically what it is that you want unredacted, and then I'll take a look. The problem with that approach, Your Honor, is that the state, again, has an affirmative duty. It's not a reactive duty. It's not
Okay.
that the defense has to first
What have they not
try to
disclosed?
guess at where there might be additional discovery that we're entitled to, what Brady information might be out there. The state has a duty to take it upon themselves to review the documents and the discovery in their possession and to turn over anything that falls under 5501 or their other affirmative disclosure obligations under Brady, Giglio, and their progeny. So what we did was, realizing that we were getting nowhere, again, after all of these months, we had dealt with IPRA to try to take it upon ourselves, even though it's not our obligation, to try to get more documents. Those came in over the course of about 7 months, again, heavily redacted. And we could tell that there were some documents that certainly appeared to have the type of content that we would be entitled to. But many of them had entire sections that were just completely blocked out, so we don't know what the content was at all. We could only see, who the sender and recipient were, and everything was blocked out. So we were left to guess, whereas the state has the affirmative duty of disclosure. And so what we did was then we, for the first time, I believe it was on the 27th of June, reached out, and instead of emailing both prosecutors or just Ms. Morrissey, we reached out directly to Ms. Johnson and only to Ms. Johnson. and basically under her obligations as a
Ooh,
prosecutor now on this
trying
case,
to divide and
asked her,
conquer.
to fulfill those obligations and do an affirmative review of everything and to turn over anything that needed to be turned over. The same day, in accordance with her responsibilities, she did then respond and said that she was requesting a full unredacted copy of the thousands of documents that we received under IPRA that were still redacted, and that she would undertake an affirmative review of those items, as well as checking for an audit with the law enforcement agency. That same day, after she responded to us with the request that we had just sent her, again earlier in the same day, we started to already get disclosures, where Ms. Johnson was saying, I found documents that are subject to disclosure under Rule 5501, contrary to what we had been told from the inception of this case, which was that we had everything that fit under 5501. It was repeatedly told to us, you have everything, you have everything. Yet we received production after production after production, totaling over 1,100 pages from Ms. Johnson over the course of June 27th to June 29th. And in each of these multiple disclosures with numerous Dropbox links, we received disclosures from Ms. Johnson where she indicated, here are documents that are subject to our obligations under Rule 5501. Documents that we had never seen before, despite the fact that these documents were not just in existence as soon as June, they had been in existence for months, over a year even sometimes. And we have a number of them, Your Honor, that I will go over. And so these are the types of documents that were withheld. So we have, for example, there were documents that were created on January 23rd, 2023. They were not disclosed until June 28th, 2024. The topic of those documents, and I have them under
All
an
the judge
exhibit, which
cares
actually
about
I
is
believe is attached
prejudice
to our
here. She doesn't
reply.
care about your
That would
whining.
be Exhibit N, is
They gave it to
comments
you
on
in
whether or not
June.
it's customary for actors to be shown what was
Then
in the
tell
gun.
us why it's
Again,
still a
a central
problem.
theory of the state's case, that actors are supposed to be shown the contents of the gun so that they can check whether or not there's a live bullet or a blank or a dummy. And so those were comments with witnesses to this case, and that's Exhibit N that the court can look at. And I do have an extra copy if the court needs an additional copy. Okay, yes, Your Honor.
I'm not hearing anything here that's like an actual request for relief. Like, what's the problem? What specifically did you not get, and how did it prejudice you? Or are you just complaining that you don't like how the prosecutor dragged their feet? We know that he feels like a victim here, but that's not a basis to bring a motion in court. I am glad he took off those
And so
hipster
we've
glasses,
tabbed them,
though. The
Your Honor, so
hipster
that
glasses
court can
mess
look
up
at,
the whole
exhibits that we
business
have,
suit thing.
There. And so, so Exhibit N is what I was just referring to. And again, the date of that statement that had been withheld was January 23rd, 2023, almost a year and a half ago. We also have another statement that was withheld November 17th, 2022. That was just disclosed June 28th, 2024. This is Exhibit O. And the topic of this is the benefits and requirements of New Mexico tax incentives. That's the production that was at issue in that one. And again, it's Exhibit O. Another date of withheld statements, December 11th, 2022. Date of disclosure, June 28th, 2024. In this one, these are opinions from the state's own expert, Brian Carpenter, about statements that were made by Hannah Gutierrez-Reed, and this is Exhibit P. So they had these statements and opinions from their expert, Brian Carpenter, since December 11th, 2022, and we did not receive it until June 28th, 2024.
So what's the prejudice?
Additionally, Your Honor, again, December 11th, 2022, statements from Brian Carpenter, the state's expert, understanding of what happened on the set of Rust and including in the church. That's his own understanding based on what he had looked over. Clearly a statement by their expert. The date of disclosure was not until June 28th of this year. August 21st, 2023 was the date of another statement that had to do with, the topic was whether or not shooting lots of blanks might impact the fire control components of a firearm. This is Exhibit L and was with the state's firearms expert being Lucian Haig. And so this is again another statement by yet another state's expert. We did not receive that until June 29th, 2024, despite the fact that they had it since August of 2023. Then we have additional statements from November 10th of 2023 and April 19th of 2023. And these were more state's expert witnesses, the Haigs, opinions related to Mr. Baldwin's handling of the firearm. This is Exhibit L at 2 and 3. The list could go on, Your Honor, but again, we just received these disclosures as we're in the middle of trial preparation on the eve of trial. But we have received, again, over 1,100 documents. And we are doing our best to comb through these, to pick out what we have. These are just some of the ones that we've been able to pull out thus far. And these are just the ones that we've received within the last
Would you like a
week.
continuance? That's
As
your
the court
remedy.
knows, this is not the first time that we've been made aware that we were not
You wanna
getting
continue the
disclosures
trial?
timely. We had the Hague report that was initially disclosed on August 20, or that was written on August 26, 2023. We didn't written on August 26, 2023. We didn't get it to April 29th, 2024. And again, the prejudice for these is we got that after the pretrial interview was already conducted, 1 week before the dispositive motion deadline, and a week before the witness deadline. The third Hague report for August 31st, 2023 was not turned over until May 21st of 2024. And again, this is after the pretrial interview was conducted with the expert, after the dispositive motion deadline, and after the witness list deadline. And the list goes on and on and on and on. We have so many of these, Your Honor. And the problem with this is, the state talked in the beginning, one of the first motions that they referenced, they were talking about there are rules, there are deadlines that are set in place that the parties are supposed to follow. Absolutely. And these are rules that are very clearly intended to ensure that the defendant has his due process rights fulfilled, that he has the right to a fair trial, that he has the right to present a defense, and that he has the right to confront the witnesses against him and be prepared with any statements that those witnesses have made so that he can explore in discovery, so that he can determine whether or not he would call other witnesses.
Are you
so that he can
asking
ask these
for a
witnesses about the
continuance?
statements and opinions that they have given.
The patience on this judge for this
with it,
right now.
rather than receiving these now
Lot
a
more
week
than
before
mine.
we are set to go to trial.
Like, I get it.
On a case involving
You think they're bad
manslaughter.
guys. What do
And
you
so-
want?
Your Honor, at this
What do you
point,
want?
it is, and I know
What
the
do you
court has heard
want?
us say this before, and the problem is we've had to say it repeatedly because of the continuing violations, is that it's not something that the court can turn a blind eye to. It's egregious. It's been repeated. It's been throughout the duration of this
What
entire
do
case.
you
And all
want?
we've been trying to do is get information that we have been entitled to from day one. Or from day 10, I guess, if we're going 10 days after the date of arraignment. But there was always a continuing duty to disclose that whenever they
Mm-hmm. Indeed.
received something
So
new,
what do you want?
within 7
What do you
days
want her
of
to
that
do about
receipt,
it?
they would turn it over to us. And this has not happened throughout the pendency of this trial. Even now, even though Ms. Johnson has gone through and has reviewed and taken it upon herself to do some of this, there was nothing preventing her from doing it earlier. But it wasn't until we reached out to her directly that she finally waited and wasn't just waiting for Ms. Morrissey to respond. She did take that duty upon herself. She should have done it earlier.
Judge is pulling out
but
her
she did
hair
do it,
for
and we
not having
appreciate
the
that.
10
But
limit,
even now,
10-minute
there
limit
are
on this
still
one.
documents that are redacted that we know contain statements that we are entitled to, that we still don't have the redactions lifted for. And I have examples here for the court that I can show if I may approach.
Yes, it's super annoying when prosecutors play these little games like this. However, your remedy is a continuance. Is that what you are asking for? Do you need more time to prepare? This is all we need to be talking about right now.
So what I've handed the court, Your Honor, are, again, and these are just things that we're having to affirmatively comb through now on the eve of trial. One that I've handed to the court, if the court will look at, is dated Wednesday, January 18th, 2023. It's a communication from Brian Carpenter, the state's expert, and it says, attachments, statement of PC, being probable cause, Baldwin, with BWC markup comments. This is, we assume, again, Brian Carpenter markup comments. So he's reviewed the statement of probable cause, and this is back in 2023, and marked it up with whether or not he felt that the statement of probable cause was appropriate, was whether or not there were any problems with it, and this is just what we have to assume, because he says he marked it up, meaning that there were changes that he made. So these are clearly statements and opinions by this expert, and yet it's entirely redacted still. We can see nothing about it. We see team up at the top and nothing else. So we still don't have his statements as to, and comments as to the probable cause. In addition, number 2, we have the one that starts on March 6th, 2023.
Well, that's
And in this
work
one, it starts
product,
with
I
the
would
big
think,
blocked out
but
section at the top of the page. And it's from Jennifer Paget Macias, and she indicates, good morning. We need to disclose the email below in discovery. But before we do, we need to get subpoenas and certificates of compliance out for specific documents. She then goes on to say a number of different things. This has been identified as something that should have been turned over in discovery, and yet if the court flips through it, and she says, you know, what follows is supposed to be disclosed, it's nothing but blackened pages. We have none of the contents of these communications, despite the acknowledgement by the prosecutor in that case, that was subject to disclosure. We then also have additional documents, another one from Jennifer Paget Macias, dated February 20th, 2023, where there are attachments, and this is an inquiry to Brian Carpenter from Ms. Macias, where she is asking him whether or not he can look through some documents, these safety bulletins, and let her know if their expert, Brian Carpenter, is familiar with the guidelines, if he has experience following the guidelines, and whether those would have been applicable to the rust production in New Mexico. She says, in other words, do you have personal knowledge as to these standards? Certainly his answer to that is relevant to his qualifications and whether or not he is appropriately an expert. If he has no experience or very little experience with these things that are directly at issue in this case, then he certainly doesn't make an appropriate expert. But we do not know the content of these communications. We don't know what Mr. Carpenter said about whether or not he was qualified because it's entirely blacked out. We have nothing that we can see from this. And in addition, Your Honor, the last one, again, is messages between Mr. Carpenter and Ms. Morrissey. These have been blacked out. We have, you know, some just kind of initial back and forth.
Ding, ding,
presumably,
ding.
if that's all it was, there would not be further redactions. and
We
yet
have a
there
winner.
are. So here we are on the eve of trial. We still don't have these documents that we clearly have a right to have. And again, on document number 2, actually, I believe there's a portion on the 3rd page where it's like almost completely blacked out. But if you look at the portion, you can kind of see part of the sentence, like half of the word, and it seems to say something about script supervisor and continuity supervisor. That would presumably be Mamie Mitchell, who is a witness in this case and was in Ms. Gutierrez's case. Something about required her to keep something costume and something details, but we can see that it's about one of the witnesses who actually has testified in Ms. Gutierrez's case and will be a witness in this one, and again, was identified as something that is appropriate for disclosure. So we are here late in the game, and this is not where we want to be. I know this isn't where the court wants to be, but here we are. And it's not through any lack of trying on the part of the defense. It's just that we have been dealing with a
Except that you
situation where
haven't
we
said
cannot
what you
get
want.
appropriate discovery. And this is not how it's supposed to work. And so what we are asking the court to do is to recognize that in this case, there have been significant and substantial violations. And in cases where there are egregious discovery violations, dismissal can be an appropriate remedy.
Oh, for God's sake,
Suppression
they're not
can be
going to
an appropriate
dismiss.
remedy. And while
You
we would
know they're
argue
not going to
for,
dismiss.
for dismissal, we know that the court is not inclined to do that at this stage, but in this type of case, it would be an appropriate remedy, and it is
No,
one
it
that
would
is available
not.
to the court. If the court were not to grant a motion for a dismissal, however, there are other remedies that the court can also entertain.
Yes.
And the court should entertain.
Do you want a
Because
continuance?
when we're looking at the kinds of violations like we've seen in this case, it has materially impacted the defendant's ability to be able to prepare for trial.
So your
to be
remedy is
able to
continuance.
interview the witnesses, to be able to seek out its own experts and do whatever it is that we need to do in the case when there have been so many continual discovery violations. So the more narrowly tailored remedy that the court could fashion, even though it would not put us completely in the position that we would be otherwise, the closest that we could probably get is if the court were to look at these topics for which we still have these disclosure issues, for which they've now just disclosed these things from their expert witnesses, again, the week before trial when they've had some of these for over a year, and say, I see that there is prejudice, I see that there were violations, and there's prejudice to the defense. So we will not allow the state to benefit or to put on these topics of evidence.
You haven't said
Because the
what the
defense
prejudice
is not in the position that they would have been had these documents, had this discovery been disclosed in the timely manner that they were supposed to.
Well,
be.
you don't know that.
And
Your remedy
frankly,
is
while
a
we still want
continuance and
disclosure
follow-up.
now, and we are asking that the court lift the redactions and ask for an in-camera review of the documents that we've provided as the exhibits that we still have that are redacted, that we don't have the ability to see the contents of. We would ask that the court lift those redactions so that we can see what's in there. But there is nothing that can cure the fact that these things have been disclosed so late in the day that there's not much we can do with them. So we are asking that those topics that I've outlined in exhibits N, O, P, and L, that the state not be permitted to introduce evidence or testimony related to those topics, since we are at a disadvantage because of their withholding of this information. And we would also ask that, similar to the other motion that we had done where the court ordered that the jury would be informed of the violation with respect to the Hague report, for example, we're asking that the court allow us to submit a similar instruction with respect to their violations in this instance.
About 30
So that the
minutes.
jury can know and actually draw their own inference that this information would have been helpful to the defense had they been able to see it.
This is so
those
not
are-
appropriate for that
One
instruction.
is to dismiss the case. The second is to eliminate subject matter. The third one is that, which is ongoing, is for them to keep going, keep looking. And then the last one is,
The inference instruction.
well, what you're asking for is a continuance. So why don't you come out and say it? Because
Yes.
you don't want one.
Thank you, Judge.
How are they going
Thank
to
you.
keep looking for things
I love this judge.
without a continuance?
Yes.
What we're asking, Your Honor, for right now is those specific documents that I
You're
provided to
asking
the
for
court.
4 things, okay? And I'm asking you, how is that not going to help if I don't give you a continuance? You are essentially asking for a continuance because you're saying they have to keep looking, we have 8 days of trial, and they have to keep doing this. What does that mean? How does that compute?
So, Your Honor, so what we're asking for is not actually a continuance, and we're not even
Yeah, we know.
asking for those
She
extended
got
things.
that.
What we're asking for is we've identified a discrete number of documents right
You've
now.
got to adjust your request then.
Okay, Your Honor, so let me try to do that then. So what we've handed to the court is a number of documents that still remain redacted. We cannot see the contents, is what we've provided to the court. We're asking that the court lift those redactions, or order that the state lift those redactions, so that we can see what those are, because those are clearly discoverable, and yet we still don't have the contents. That's one request that we're making. The other request is related to exclusion of subject matter, and that's because we don't want a continuance. We don't want a
What is the
continuance.
subject matter you want?
The subject matter, Your Honor, that we're asking the court to not permit are those subjects that are included in those exhibits that I just detailed for the court. And so that would be this. And so, Your Honor, what we would like to do at this point, because we understand, again, this is a difficult position. It's difficult for us, it's not where we want to be, it's difficult for the court, because here we are at the eve of trial. We don't want a continuance. The court has already ordered us to meet and confer. My understanding actually from Mr. Spiro is that the state had indicated to him, I guess a moment ago before we argued this, that they have some additional disclosures that they would be making. I don't know if that includes potentially what we're asking for with respect to lifting of those redactions. I'm not sure what that involves. I wasn't part of the conversation. So we may be able to get something out of a meet and confer where some of the remedies that we're seeking may already be addressed. So if the court would allow us to do that meet and confer.
The judge has made it
then
clear.
perhaps we can bring this again
She
before
will
the court
consider a
once we know what
continuance
situation we're in
request.
currently.
Not another remedy.
State.
If this is more, okay, good. I'm glad it's
Thank
not
you, Your Honor.
Morrissey answering this
Your
one.
Honor, first, as the court knows, I'm somewhat newer to this particular case, but the state has complied. I did receive the request, and Ms. Morrissey didn't have the unredacted IPRA. I requested the unredacted IPRA. We went through all of those documents and made those disclosures. They have the information, and the information that they want is information they're not entitled to. So they received information that was subject to disclosure under 5501A6, 5501G, and these are emails is what we're talking about. They're emails with witnesses. And just to give you an example, Judge, I brought the unredacted, and I'd like to give it to the court for an in-camera inspection, and you will see they're not entitled to it. They're not entitled to that information because it's not statements from witness. For example, the email where Ms. Padgett says, we have to disclose this. Well, it's actually the contents of what the person, it's a paralegal emailing the DA's office. That's not a witness statement, and it's just basically saying, hey, we need to get these things, and they need to be disclosed. So if the court would like to take a look at it, Your Honor, for an in-camera inspection, if I may. Well, no, no, Your Honor, because it's for an in-camera inspection, just for the court. So it's the last page, Your Honor, where it begins after Ms. Padgett signs, "Thanks, Jennifer." It's a very second to the last page. You'll see it's an email from a paralegal at a law firm. They're not entitled to that. What the defense is complaining about is they want communications between the attorneys. They want communications between paralegals and the attorneys. They're not entitled to that. They're not entitled to our strategy. They're entitled to witness
How
statements.
would they know that? Why can't you tell them they're not entitled to this?
I
Because
did, Your Honor. I went through and I disclosed numerous disclosures. And I specifically in those emails stated, and they attached them as exhibits, these are being disclosed because they were found to contain information that is subject to disclosure. So if it's still redacted, it's not subject to disclosure. And so the other documents, Your Honor, I'm happy to submit those to the court for an in-camera inspection.
I'm not going to do an in-camera inspection. I'm ready for trial.
Yes, Your Honor.
Okay.
And I understand. And what I'm telling you as an officer of the court,
She's
as a
annoyed.
representative of the state, I went through these.
Why so late?
Your Honor, I was requested on June 27th to do, because
Well, I'm asking the state in general.
Ms. Morrissey didn't have a copy of the unredacted IPRA, Your Honor. So a lot of these happened
Why did you
before.
give them IPRA?
Well, what happened was the defense requested an IPRA in October of 2023. Mr.
Well, you knew
Baldwin.
what was going to happen with that. Balloon.
Yes, and Mr. Baldwin wasn't charged at the time. So that when they received their production from the state, he was then, at that point, charged. I believe it was in May. They asked Ms. Morrissey, would you please unredact? Well, it was thousands, as you noted. Ms. Morrissey asked tell me which ones you want unredacted and I'll take a look at them. She received no
This is
response.
all about the IPRA. Is this correct?
It said-
This
yes,
is
it
all
is.
about the IPRA.
It is.
This isn't about any other discovery that was disclosed, except what was disclosed in the IPRA.
Yes, and they're witness statements, that's what it is. So a proper remedy, Your Honor, under Harper is a continuance. It's a
Yes.
continuance. They have the information now. As far as the third Hague report, the court addressed that in the Brady motion. As far as this is concerned, they're statements. And the state has gone through, disclosed to what,
Have you already given them the statements?
that's what was unredacted. That's what we went through and unredacted.
What other redactions does she want?
She wants essentially what I just handed to the
You
court.
hammer the ones that you said you can't do.
Exactly. They're,
Well,
what they're,
you'd have to make, if they responded that this is privileged information, I can't do it for you. You're gonna have to make arguments on why the redacted portions of the IPA request that she has kept redacted are fair game. And this is all about IPA, is what I'm understanding.
they're statements that were obtained, yes, Your Honor, emails. There are thousands of pages of emails. And so, Your Honor, the proper remedy, they haven't shown how they're prejudiced.
So obviously you can tell the court is not happy with this. We are in recess, go confer, and I'll see what's going to happen.
confer.
I will give you an hour.
Thank you.
We're in recess.
Wow. Go confer for an hour? Yikes. Yikes. Well, I mean, I think the bottom line here is, yeah, the judge is right, and the prosecutor is right that the remedy is a continuance. That's what you do if your complaint is we couldn't prepare, we didn't have any time to be able to deal with this stuff. That's your remedy. You get more time to deal with it. They're not going to be striking parts of the trial or topics you don't get to talk about or whatever. I mean, this is, I understand that the defense is doing this, but, and I understand why, but just from a strategy standpoint, it's dumb. Your remedy was always going to be a continuance. Like, that's what your expectation needed to be. So if you don't want that, this was not a good motion to bring, because you are just going to annoy the judge that you're complaining about process, but you are not seeking to help yourself with how to get out of it now. So it seems to be what they're talking about. IPRA has to do with the public records disclosure. So there's a lot of ways that as a defense attorney, you go about doing your investigation. You obviously get whatever your straightforward discovery is from the prosecutor. You can go follow up on pretty much anything you want as far as what you're able to subpoena, depositions of witnesses that you're able to take, and things like that. It's not all that common to use public records proceedings to get evidence in a case, mainly because you don't necessarily get the foundation for authenticity that you need, that you would get from something like a subpoena. And so, I mean, the just straightforward example is something like I send a public records request to the Planning Commission because, I don't know, I want all of the information about my neighbor's application to do something to their property. Maybe that's like the source of a dispute or something like that. And so then what happens is I just get a letter back, from the planning agency. Here's all the documents responsive to your request, and it'll be the application and the minutes of the hearing and things like that. Well, these documents are hearsay, out-of-court statements offered for the truth of the matter asserted. So they have to be subject to a hearsay exception. They can be business records. which is the most common way that that records like this get introduced. But there is a foundation you need to be able to establish that. So you always end up having to call a witness from somebody in the government office to be able to say, here's what the documents are, here's how they're kept in the ordinary course of business, here's how they're produced, yada, yada, yada. You don't get that with a public records request. With a subpoena, you send it to the custodian of records for the agency, the company, whoever, and then the person who responds is the person who then is in a position to be able to lay that foundation. So I'm not real clear on the role that public disclosure request played in this investigation, but in and of itself, I'm just not really getting the problem. I'm really not getting the problem, and a big piece of it is because the defense here is really not telling me. They're not giving me any specifics about how they've been impeded. Like, prejudice is a specific thing. You have to show an actual material effect, not just I might have done some things differently. Well, of course you would have done things differently if events unfolded differently. That's not revolutionary. That's just timelines. The issue is that you didn't follow up on a lead that, as it turns out, would have been fruitful because of the late disclosure. You didn't get to cross-examine a witness about something that they said because what they said hadn't previously been disclosed to you. Actual material consequences, not just we're unhappy because we didn't get to close every loophole that we wanted to. And so without that kind of information from the defense, specifics, what's in the stuff, why is it material, how did it affect your investigation and your preparation for trial, and how does that hurt Mr. Baldwin's ability to be able to fairly defend himself? These are the things I need to know if I'm going to grant a remedy in the case. Otherwise, you're just complaining. Like, I get it. Yes, it's really, really annoying when prosecutors are super late with discovery and things come trickling in late in the day. Guess what? Every single freaking case it happens. Okay, every case it happens. This is not special. Heck, you had more than a week's notice of 1,000 pages of stuff. Not an ideal situation by any stretch of the imagination, but you got to show me that this is material. I'm just not. I'm not getting that here. Did I miss it? It was just so wordy that I got lost and didn't get the details of how any of this stuff matters. I don't think so. I think we just got a bunch of timelines about how bad the prosecutor was, and they had this then and then they produced it later. Okay. The prosecutor's been annoying. That's not something that there's a remedy for. Just like there won't be a remedy for them when you guys are annoying. I understand why the judge is upset about this, and I really, really like how she just cut through the noise with all of that. Because, yeah, the bottom line is you get to ask for a continuance. And then you're still going to have to show that this is material, that you actually need to be able to do this for purposes of preparation. You need to see the details of these emails, and that you're going to need to do follow-up investigation, change your strategy, whatever, as a result of this stuff. To justify a continuance, you're still going to have to show that. So I don't blame the judge for being annoyed on this one. They're deliberately avoiding what is clearly the proper remedy here. The proper remedy is continuance. If you haven't had enough time to respond, the remedy is here you have more time. Take some more time if that's necessary. But they clearly don't want that. What they want to do is to throw this Hail Mary about getting some inappropriate remedy that nobody will ever grant them. And it's discretionary with the court what the remedy is anyway. So like this is not an appeal. This is not an appeal issue that is really being set up right here. I mean, lay your foundation, I suppose, make your record. You definitely always want to make your record. But it's mainly, from my perspective, just because if stuff comes out down the road in the course of the trial, here's something I didn't have, here's a question I wasn't able to ask, here's something the witness volunteered that the prosecution knew about and didn't disclose, I mean, whatever, then you have at least made your record. And then we can revisit it, maybe, if it's appropriate at that point in time. But just the way that they're dealing with this right now, no, you're not even asking for the right relief. So it's overkill, and that's why my impression that I'm getting from this is it's really just about this is just about the public perception, the media coverage. It's been a back and forth finger pointing. Now, okay. This case I know has gone through a lot of twists and turns. And I will be the first one to say that when this case was initially charged, there was a lot of media coverage statements from the initial prosecutors and the special prosecutor that got disqualified. Like there's been a few different prosecutors on the case that were, from my perspective, clearly over the line, not appropriate at all. And I understand why the defense would be upset about that. I do. It puts them on the defensive, and now you are kind of in a position of always having to respond to that. And so, my personal inclination is really to give them a fair amount of leeway in being able to respond publicly. If the state is going to open that door and go down that road and start litigating in the press, then you get to defend yourself in the press. I don't have a problem with that principle. But I think this is just way far down the road, and it's not really responsive to anything these particular prosecutors have done in that respect. I don't know what advantage you're trying to get. Is the issue here that you want the press to report that the state has late disclosed things? I mean, that's all I can really get from this is that this is what's going on. This is just kind of PR laundering through the courts because there's no realistic prospect that you're going to get what you're asking for, and what you do have a realistic prospect of getting, you don't want. So there's no real good legal reason to bring this motion. If there's not a good legal reason to bring it, then it's got to be, there's something else going on, and publicity seems like a pretty good candidate in that type of situation. So yeah, I would think the judge would be annoyed about that. If that's what she's thinking is going on here. We just spent, half an hour going through all this stuff, not getting anywhere. Not even asking for the right thing. For what? So that the papers can report it. And then some of the prospective jurors can come in tomorrow and be like, oh my gosh, it's fresh in my mind how the state withheld all this evidence and he's not going to be able to get a fair trial. Is that it? Is that it? Yeah. yeah, the court's not going to be happy about that. So especially now that she has these documents, the in-camera submission that the state gave them, here's what they're asking for. She's going to be able to see, here it is, this is what they would get, and she is going to see clearly how material or not it is. I have a sneaking suspicion the whole reason why the state is here prepared to hand them up is because, no, they're not material. And or, no, they're not entitled to them. That's not going to make her happy. If they're having this whole argument over emails with the paralegal, and just how does that matter? How does that matter? Well, kind of par for the course with how these guys have been acting towards each other. And you know, like I said, I do kind of think the state started this one. You know, way back early on before these particular prosecutors were on the case. Yeah. Yeah, I kind of think they started that. But I just don't think that particularly justifies where we're at here. This is just coming across as really pointless and time wasting. I pulled up this comment because I saw it come through, and it's a very good question, and I wanted to go ahead and take a minute to address it. Because my answer is yes, I do think the prosecution should have been pursued. There have been several situations where, in my view, it's the right thing to try the case and let the jury decide. And that's a big part of that is just because the jury is that voice of the community. This is like our best direct democracy that we have is our ability to decide outcomes in courtrooms around the country. Oh yeah, we can, do ballot initiatives and petition and stuff like that. Kinda, maybe sometimes. Is that super effective? You'd be surprised. A lot of restrictions on like how laws have to be written and things like that can get in the way. If you don't know them, don't know what you're doing, you can get millions of signatures on your ballot, and if you don't follow the technical rules right, it's never going to become law. The jury room is where we get to do justice as a community, and so I personally feel it's a very important part of the process of dealing with something like this happening in a community. And so a lot of times, yeah, I don't always think people should be convicted just because I think they should be tried with something. I think they should be prosecuted for it. But to me, when I look at this scenario, yeah, I see a lot of failures in the safety chain. The armorer, potentially whoever hired the armorer, whoever is supervising the armorer, everybody else that's in the sort of line of supervising, handling, being in charge of the safety stuff, and then the person who is on set with the gun in their hands. Every single one of these people played a role in what happened. So I don't think it would be fair for David Halls to get prosecuted, for Hannah Gutierrez to get prosecuted, and for Alec Baldwin not to be. To me, that's not fair. It doesn't mean that they would necessarily all be convicted. I'm not saying it's not going to be fair if he's not convicted. I don't have an opinion about that at this point. But yeah, I do think it should go to the jury. I think that there is enough to raise the question, did you point a gun at somebody and pull the trigger? To me, that's a pretty inherently reckless thing to do. So yeah, I think it's a situation where the charge needs to be filed so that the community can see everything and weigh in about it. I remember a case where a prosecution was declined. Boy. Sometimes those decisions can be just as problematic as decisions to go after somebody. Decisions to decline can cause a lot of havoc in a community. So this case that I remember was a situation where this store, it was a country store, like boots and apparel and things like that, horse gear, like that type of stuff, a country store. It had been getting, there's always shoplifters and things like that, but apparently like some break-ins and stuff like that. So the owner had taken to sleeping in the building. One night, while he's in the building, somebody breaks into the building and is like in the process of, I think, trying to get into the cash register when the owner awakens, confronts him with a shotgun. The person turned, ran out of the store, was running away across the street, and was about 100 feet away when the shop owner shot him in the back and killed him. And so this case caused a lot of difficult feelings, kind of on all sides of it, because the prosecutor declined to prosecute the man. Felt that it was a self-defense situation. While other people looked at this situation and thought, he's 100 feet away in the street. He's, in the back. He's no longer a lethal threat to you at this point in time. That is not a situation where self-defense is cut and dry, such that there should be no prosecution. And so what ultimately happened is the prosecutor convened a coroner's inquest. And a coroner's inquest is kind of like it is a mini trial. It's when they basically hold a trial on the cause of death that's going to go on the death certificate, because for whatever reason, the coroner is saying, it's not necessarily clear. Is this a homicide? Is this, is this something where charges should be pursued? What do you do with that? So they had a coroner's inquest. They have a jury for that. Present evidence. It's not beyond a reasonable doubt standard. It's a quite a bit lower standard. But ultimately, the coroner's inquest also voted, don't charge him. So they never did. Never charged him with that. And I didn't agree with that decision. I didn't agree with that decision at all. I just think it's important. It's important for the community in those situations to have that direct say through a prosecution and a jury trial. It's just too close a call for one elected official to make, or even for a smaller jury with a lower standard of proof to be able to make. I personally just thought that was not a good call. So similar type of situation here, I think. Yes, I can certainly imagine scenarios where Alec Baldwin is not guilty. He's not guilty of a crime. If the gun accidentally fired and there's like no real volitional act on his part, I'm going to have a hard time convicting him. I'm just going to have a hard time believing that, if it can't be recreated, I'm going to have a hard time believing that. But yes, if that did happen, That would undermine his culpability. He shouldn't be convicted. It doesn't mean he shouldn't be charged. And it doesn't mean that the evidence shouldn't be presented and tested and evaluated by a jury. So that's my thoughts about that. Well, I see we still got some time here, of course, and I see folks are still very, very interested in the Karen Reed motion. So I suppose I could just go ahead and pause here and have us go ahead and take a look at it. I mentioned that I already read the declaration of Alan Jackson, but that was the only one that I saw. So I'm going to go ahead and pull up the motion. Now, can we see this? Let me see here if I can get this bigger. No, I can't get it bigger. It only just gives me the... This is terrible. I'm not gonna, well, I'll just leave it up, but whatever. So I'm just going to go ahead and read through it. Now comes the defendant, Karen Reed, by and through undersigned counsel, hereby moves this honorable court, pursuant to the 5th, 6th, and 14th Amendments to the U.S. Constitution and Article 12 of the Massachusetts Declaration of Rights, to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges, and alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Ms. Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. So now we have a lot of case law and language about the importance of a jury trial. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the 5th and 6th Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Always fun to quote the Federalist. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. Yes, this is all good stuff, but it follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The Double Jeopardy Clause provides that no person shall be subject for the same offense to be put twice. Oh my gosh. This wording always gets me. That no person shall be subject for the same offense to be twice put in jeopardy of life or limb. Thank you, Bluford. I've said that a million times in that language, but just something about the way those words are ordered trips me up every time. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. This is black letter law. The state gets one bite at the apple. If they take you to trial and the jury votes not guilty, they don't get to try again with a different jury. It's not how the system works. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. So yeah, this is why the state doesn't get to appeal an acquittal. They don't get to say she shouldn't have been acquitted because X, Y, and Z. It doesn't matter. The jury did. And so that's the end of the road when it comes to review for the state. So really the only time state gets to appeal, they can appeal a sentence. But otherwise, it's only going to be a situation where typically like the defense has lost and is appealing, and then the state can counter appeal. If there was like a ruling that they thought, should have gone the other way, then often the door can get opened that way. But just, bad ruling led to the acquittal. It's a too bad, so sad type of situation. Here, the very first day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors indicating in no uncertain terms that the jury had a firm 12-0 agreement that Ms. Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Ms. Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. So let's be very clear. Obviously, I think, had the jury checked the not guilty box on count 1, checked the not guilty box on count 3, 4-person signed the verdict form, it would, yes, be absolutely crystal clear. You don't get to retry her on those. Anything that she has been acquitted on, she can't be retried on. So even with a hung jury, a hang doesn't have to be all or nothing. This was the issue that I had with instruction number 2. Just instruction number 2, because it was the only one that had the lesser included offenses, required the jury to be all or nothing on the charge itself and all of the lessers. They had to acquit on all of those. There was no option on the form for them to say, no, I think she's not guilty of voluntary manslaughter. I think she's not guilty of involuntary manslaughter. But then when it comes down to motor vehicle homicide, we can't reach an agreement. There was no way for them to be able to express that on the jury form. But that was just limited to count 2. Count 1 for second-degree murder, it had a not guilty box. Count 3 for leaving the scene, it had a not guilty box. So no question at all, had those not guilty boxes been checked, we wouldn't be having this conversation about can they retry her on counts 1 and 3, or do counts 1 and 3 have to be thrown out? She's been acquitted on them. So it's just the fact that they didn't check those boxes that is potentially creating the problem here. Background. On June 9th, 2022, Ms. Reed was charged via 3 separate indictments with murder in violation of Massachusetts General Law, Chapter 265, Section 1, vehicular manslaughter, I'm not going to read the charges, and leaving the scene of a personal injury or death. A jury trial began on April 6, 2024. On June 25th, 2024, the jury began deliberations. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was presented to counsel was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court and, without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. In short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all of the charges in the indictments. So this is going to be the key to the defense argument here. The argument that the court had a duty to inquire deeper into the deadlock. I don't think they're going to win on this, because the problem is you can see a real alternate situation where the judge is inquiring into the nature of the split with the jury. The reason why they don't get to do that, and there is case law on this dating back to the early part of the 20th century, is because it puts improper pressure on the minority of the jury. It calls them out. It brings them to the attention as kind of being the problem here. And so that is putting undue pressure on them to change their verdict just for, to change their vote just for the purpose of being able to reach a verdict. So the judge is not allowed, she's not allowed to ask about the split. Not allowed to ask the numerical split. So there are cases, all throughout the federal courts, and I'm sure among other states as well, where different inquiries are upheld. And so typically what these inquiries look like is they can go through juror by juror and ask them, is it correct? Is it true that the jury is deadlocked? Get everybody's opinion on that. The judge doesn't necessarily have to take that from the foreperson. And then ask everybody individually, do you believe there's a reasonable likelihood of being able to reach a verdict in a reasonable length of time? Something along those lines. So they can inquire into the jurors' perceptions of whether there is in fact a true deadlock and whether it is irresolvable. But the numeric split, asking the jury how many people are voting for what, or, even just what's the breakdown? I don't need to know. Is it favoring acquittal? Is it favoring conviction? Just asking for the breakdown, going all the way back to earliest part of the 20th century. This is not okay. This is coercive. So that's kind of the problem with this situation and with the position the defense is taking here, is that had she done that, that this would be a problem. This would be an error. And especially if she had done that and the jury had come back and said, oh, actually, we were going to convict her on this one. It's just hard to imagine that wouldn't be a problem for the defense. So this whole argument that the court didn't inquire further, this is really the linchpin for them being able to get relief on this motion. And I don't think they're going to be able to establish that. I just don't. The jury had expressed multiple times that they were divided. They were fundamentally divided. The jury didn't volunteer anything to suggest we're divided only on some charges and not the others. The following day, on July 2nd, 2024, Alan Jackson was contacted by a juror in this matter, quote, Juror A, who stated that he wished to inform him of the true results of the jury's deliberations. This is just, I gotta tell you guys, this is classic off limits. You can't use this stuff. The true results is just a juror's interpretation of the deliberations. You don't get to use that. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury death. Another day later, on July 3rd, 2024, Attorney Yannetti was contacted by two different individuals, hereinafter Informant B and Informant C, who had received information from two distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. Informant B sent attorney Yannetti a screenshot she had received from someone, hereinafter intermediary B, oh my good lord, of text messages that intermediary B had received from juror B. Okay, so juror B sends text to intermediary B, who passes them along to the informant, who passes them along to the defense. Little bit of an attribution issue here, but okay. In that screenshot, juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Informant C had been in contact with another individual, intermediary C, who is a co-worker and friend of juror C, and joined a Zoom meeting during which juror C discussed the trial. Informant C sent attorney Yannetti the below screenshots of her text messages with intermediary C regarding what juror C revealed in the Zoom meeting. Intermediary C, no consideration for murder to manslaughter. I gotta get to the other tweet now. Oh, wait, hang on. Manslaughter started polling at 6-6 and then ended deadlock at 4 no, 8 yes. Informant C, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. Intermediary C, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. So this is our factual basis. The question is going to come down to, can the judge hear evidence from the jurors about what they were saying back in the deliberation room about one or more of the charges in order to shed light on how they handled the verdict forms? And I am not optimistic at all that that's going to be allowed. I would like to see if the defense addresses this, so let's see. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. Okay, well, so this is interesting then. This is a case specifically from Massachusetts that says, this is good language. If they did in fact resolve it, and this is what the defense's characterization of this case is correct. Then the acquittal attaches to their unanimous decision that she's not guilty, not to what they did with the form. Here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Ms. Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. I do see a problem, though, with them being inconsistent, because juror A said count 1 and count 3, they had both taken off the table. This informant C is saying only that it was count 1, that everything else was what they were hung on. So that's not particularly helpful, but at least if we can stick with murder 2, these comments would appear to all be unanimous that the jury had intended to acquit on murder 2. So then those are all just summaries of those statements. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. The Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations and, when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the jurors' statements reflect a final determination that persisted through the end of deliberations. Even assuming arguendo and contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. I definitely don't think Bluford is really going to help them here. Again, the problem is that everything that happens in deliberation is kind of understood to be preliminary until the jury announces what they've decided. And the fact that they didn't announce here that they had reached a decision to acquit her on count one, whether or not that's by checking the verdict form, including it in their statement or something like that, it just suggests they never finalized. They never finalized that. So I don't know that Bluford is going to be particularly helpful on that point, but I definitely agree. If Massachusetts law is more forgiving there, then by all means, apply the local standard. So Part B, re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. So once the jury is sworn in, you're finishing, or you're going to have potentially a double jeopardy problem. Thus, where a mistrial is entered without the defendant's request or consent, this is why defendant can move for a mistrial if this trial has been tainted. I want to start over with a fair one. Because it's their request. That doesn't violate double jeopardy. Retrial is impermissible unless there was a manifest necessity for the mistrial. Judge doesn't just get to say, I don't like how things are going, we're going to declare a mistrial and start it over. There has to be a legitimate problem with the fairness of the process or its ability to reach an outcome for that to be justified. Here, Ms. Reed did not consent to the declaration of a mistrial. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. This rule is noted in the importance to the defendant of being able, once and for all, to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Before a court declares a mistrial for manifest necessity, 1, counsel must have been given a full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial. Let's see where they go with this, because I'm skeptical of this one too. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. I don't think the judge is going to see it that way. I don't think she's going to say you didn't have an opportunity to be heard. She's going to say you didn't have anything to say. You would have indicated if you had something to say. But they had previously asked for the Tui Rodriguez instruction. And the understanding is that's going to resolve the deadlock or not. It came back, apparently, no indication, that the deadlock had been resolved as to any of the charges based on that jury note. So that's how the judge is going to see it. Not, I didn't give you an opportunity, that you had nothing to say. If you had something to say, you would have stood up and signaled and asked for permission, to address the court. You didn't do any of those things. When they're talking about opportunity to address, what they're typically talking about is a situation where, say, the court gets the jury note, reads it in chambers, decides, I know what the answer is, writes it down, sends it back in, and doesn't have a hearing on it, doesn't present it to them, doesn't give them any opportunity to be able to respond to it. So I don't know that the defense has a very good argument here that by not reading the note to them beforehand or disclosing it to them beforehand, that would have changed their approach. Because there's nothing in the note that tends to suggest they were able to reach agreement on some of the counts. It just sounds a lot more like what they said was they have fundamental disagreements about the meaning, the significance of the evidence. And that, I think, understandably is going to color their perspective on guilt or innocence. So there's nothing in the note that I would think would have alerted them that there was something here to inquire into. So I don't see prejudice from you didn't read the note. You did hear the note in open court. Once again, I mean, could have stood up, could have said, Your Honor, I'd like to be heard. Can we sidebar on something? I mean, there's just, this is not going to fly with the judge that I kept you from being able to do anything. She's going to see it as, you chose not to. There was nothing for you to say. The record is independently lacking on the second prong as it reflects. I got to start at the top. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, and neither preceded nor accompanied by discussion with counsel. I kind of feel like this is maybe being hyper-technical with these words. Like, she doesn't have to ask their permission to do stuff. She has to do it in open court where they have an opportunity to address it. But there's no law that says she has to hold their hand or make it easy for them to be able to make their record. I don't know about this, guys. The record is independently lacking on the second prong as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charge, parentheses S, on which it was deadlocked. Had the court done so, and had the jury articulated its verdict consistent with the statement of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. And then this other quote: when the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement. This is some big hindsight bias here, because there was just no reason to think that there was a problem with any of the charges. Was there something that kept the defense when the jury said they're deadlocked? The judge said they're deadlocked, so I'm going to bring them back in to stand up and say, Your Honor, may I be heard on, can we inquire if the juror is deadlocked on everything? Yeah. The problem here that they have to overcome is that the jury is going to be presumed to follow their instructions. That is one of these kind of bedrock principles in the law that if it's in the instructions telling the jurors how to do it, then the jurors are assumed to do that. And so if the instructions make it clear, if you've reached a verdict on this count, check the not guilty box. Then them not doing that is kind of an indication they didn't reach a verdict on it. They may have had even like preliminary discussions, preliminary conversations about it, but if those didn't get finalized as a verdict, I just don't think they're going to get there. The Supreme Judicial Court's holding in Commonwealth v. Roth that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. So more bad law for the defense, it looks like. Where's the rest of the motion here? Oh my gosh, is that all Ted Daniels gave us? That's where it runs out? I guess that's where it runs out. If anybody's got the rest of it and wants to post a link, that would be great. I would take a look. Well, this has given me the outline of what it is that we're dealing with here. And so, based on that, unfortunately, I remain pretty pessimistic on this motion. I don't think this is going to go anywhere. The Commonwealth is going to respond. You don't get to use the jurors' extrinsic comments about the deliberations to impeach the result of the deliberation. The result of the deliberation was a no verdict on any of the charges. There was nothing in the note to suggest, to put anybody on notice that further deliberations or anything like that was going to be fruitful. They'd already gotten the Tui Rodriguez, so it's not like they could be sent back to fix it. And the instructions tell them how to fill out the verdict forms following their deliberations. If all of those things are the case, I don't see this motion going anywhere. It makes a good story. This is very it's going to be a morale booster, definitely, for people that want to see Karen Read acquitted and Karen Read go free, because they're now going to have a stronger sense that, she should have been acquitted the first time around, and so to continue to retry her is unfair. But as far as legally, is this going to go anywhere? No, I don't think so. It's unfortunate and disappointing, but I think that's just the bottom line. I am going to see, because I looked into so many of those jury instructions. Let me see if I can find the general charge that they would have gotten for being able to go through those instructions. So let's see. She tells them about the presumption of innocence, the burden of proof, what the prosecution must prove. Okay, so here is the language on reaching a verdict. For each charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. You may not find the defendant guilty on any charge just because you think that the defendant did something else that was wrong or improper. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each charge. When all 12 jurors agree on the verdict for a particular charge, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of that charge beyond a reasonable doubt, then you should find that the defendant is guilty of that charge. If, on the other hand, you all agree that the Commonwealth did not prove one or more of the elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. So this is the form instruction. If this is what Judge Bev gave, then I don't think there is a very good argument that they didn't follow this, or that if they didn't understand it, that was reasonable. Bearing in mind, yeah, I didn't like these instructions in general just because there's so many of them. There's too many. You made it like far too complicated for people to be able to pay attention while you're giving them. And there's just so much superfluous stuff in it that it's very hard to drill down to what's essential and what's not. But this instruction here is pretty clear. You decide each charge separately on its own merits. Each decision has to be unanimous. And if you reach a unanimous, when you reach a unanimous decision for a particular charge, here's what you do with the verdict form. The fact that they didn't do that is going to be regarded as evidence that it's because they did not, in fact, reach unanimous agreement on those verdicts, and that, statements by jurors after the fact to the contrary are the kinds of things that are not going to be admissible to challenge that decision. So, yeah. That's kind of where I'm at on that. They have started kind of trying to take us back to the courtroom here in Mr. Baldwin, because we're all patiently waiting to see, are they going to ask for a continuance? Is that what's going to happen here anyway? Are we still planning to start this thing like tomorrow? I don't know. But they're getting ready, it looks like, to try to bring us back, but are just not quite there yet. So we'll just continue to hang. So I see there is, oh, here we go. Somebody brought it up. You are the real MVP. I don't want to take the court down now, just in case they do go ahead and get started. But somebody sent the link with the rest of the motion, and there are 2 more pages to it. So I'll go ahead and finish that. The Supreme Judicial Court's holding in Commonwealth v. Roth that courts should not request partial verdicts on lesser included. Oh, now here they go. Okay, here they go. Let's get going. We'll come back to that.
Yes, Your Honor. I believe we've worked out many of the issues that were before the court, if I may quickly. So,
way to make her day.
The state gave us the sense of their witness order,
Okay.
which showed us that the witnesses that involve these IPRA issues are the end of the case.
Okay.
So because of that representation, and they were helpful actually in just laying out the entire witness order, more or less. And so because of that, it gives us a little bit more time to meet and confer between ourselves. And the state's also willing to take a sampling of our IPRA issues. And we keep calling them IPRA, but just so the court understands, they're the normal discovery. They just came in and did rep. So they're going to take them and look at them themselves in camera and give them a second look. And I'm hoping between the witness order and that, we will not burden the court further with this issue. In addition, I had held our opening motion in abeyance to meet and confer about the exhibits. The parties have reached an agreement as to the 8 or 9 exhibits each side is using, so that will not be an issue during opening statements.
Okay.
And finally, we were able to meet and confer about voir dire, and the state can correct me if I'm wrong, but one issue that you voir dired about in the last case that we think, at least I will.
Let me just go
Sure.
back up for a minute. So, for the record, Ms. LeBlanc asked for 4 remedies. And I'm understanding that you have abandoned that request because, and you're satisfied with the compromise of witness order and that the state will take a sampling of IPRA issues in camera.
Yeah, we're holding, obviously, time will tell about the,
Well,
The-
that's
the-
not going to work for the court.
we expect that to resolve the issue. Obviously, we can always bring an issue back. As I said before, we don't intend to bring this back to the court. So I would say that it is mooted or held in abeyance for now. Obviously, they just gave us a Giglio disclosure, which was also helpful.
Well, what I'm trying to avoid
Yes.
is that this continues through the trial. And that's why I think a continuance would be the answer if it continues through the trial. And I want to do it now, obviously, if this is going to continue. So you all have to have
Yeah, she
resolved
wants it
it.
to be done.
Yes, it's my impression, based on the representations from the state, that they don't have any further disclosures, that they're willing to do this in camera in good faith, and that they're going to give us more advanced witness order notice than they would have necessarily been required to do. We believe that that has resolved this issue.
All right. I would like an order regarding the motion.
Yes, Your Honor.
And I would like you to prepare it.
Yes, Your Honor.
Okay.
So can I just turn to that final quick issue?
But if
Yeah.
it's going to say being held in abeyance, I'm not going to sign it.
She's not
Yeah,
going to
I
sign
would
it.
like
She
that
wants
tomorrow.
them to
Yes, Your Honor.
clearly
I won't-
waive
Vote
the
jury's
issue.
form.
Understood, Your Honor.
All right.
The final
Present
issue that
the
Your Honor
order.
raised before our original break today was the voir dire and how to run it and
Yes.
any
Yes.
insight we had. The parties were able to confer on that too. And in the Hannah Gutierrez Reed case, you did the voir dire regarding guns.
I did?
I think so. I think you made that one of your questions to the panel. I could be wrong. I was.
I don't think so. I usually would not do that.
Oh, you would not, okay.
Yeah.
So that's just one topic that I think may be of the sensitivity and the type of topic that we may want the whole panel to hear and be able to approach on as a topic
I don't-
potentially.
I usually do not conduct any particular question other than what the UJI requires the judge to
Understood.
go through. And it usually stops on, is there any reason why you can't serve on this case? And then I turn it over to you for the specifics. So I don't,
Fair enough.
so what do you say?
Now I'm saying very little because you've just explained to me exactly
Oh,
how,
okay.
my understanding had been that you addressed a couple of these issues yourself.
Of course, I
So-
could have, can't remember it too much. Okay.
And then the only other topic that we're going to raise is just the strong views on Mr. Baldwin in both directions that we're going to ask. We're going to be more eager to ask the court to take people individually on. But other than that, what the court had said made sense, and we have nothing further.
Well, so are you going to ask to speak in private? I'm not sure on what you plan to do on that.
Well, I think that if people have very strong views, if somebody indicates very strong views on Mr. Baldwin, that is the type of topic that I think has the potential to taint the jury pool as a whole.
Oh, so you mean come up to the bench?
Sure. Yeah.
Okay, you mean come up to the bench
Yes.
versus what, are you going to speak in private? Because sometimes they don't stick around to speak in private. So you want it up at the bench? I just want to get the visual on this.
Yeah, I think that's what we had envisioned, that just, or frankly, if somebody has a very strong opinion on one of those two sort of, threshold issues, that if they raise their hand, it indicated, thank you, juror number 14, for indicating you have a
Yes.
significant concern on this topic. We're going to come back to that juror then at a break, basically, is how I pictured it happening. And if the state pictured something different when we were discussing it, or if the court doesn't want to do it that way. of
No,
course-
but just so you know, how I've experienced this, when people want to share their views very strongly, they will keep raising their hand. They will meander back to what they really want to let you know, even if the question is not germane to that. And so if we say, do you want to speak in private? Sometimes they do not come back and speak in private, and so you don't, you'll have to decide what to do with that. They come back for the selection, but they don't come back to speak in private. They don't stick around for speaking in private. So I don't know how you want to do that. I just don't want you to think here that people,
Yeah, obviously, if they leave, they're not in the jury. And
no, they just don't speak in private, but then they come back. They don't leave like goodbye and not come back. So we'll take a recess and then we'll say, everybody that wants to speak in private, stay over there and we'll call you one at a time. And they just don't,
So now I realize why we're talking past each other. So the way I've done it, especially in cases that have been heavily followed and there's media involved, is the court clerk or somebody will take, or I can take a roll call, and it'll be 14, 18, 19, 20. They go into the hallway and they say, jurors number 14, 18, 19, 20, please line up at the door during the recess. We speak to them each for 60 seconds during the recess, and then we're done.
okay. Well, I hope that they do that for you.
Okay. We have nothing further, and thank you so much for the court's time today.
Okay, all right. We are in recess, so tomorrow, what you're going to do is you're going to come up here while we're waiting. Is that where we're, is that any, did I get it wrong? Faith, somebody come out? Okay, so you're gonna come up here and you're gonna wait up here, and then when they say that the jury's ready for us, we'll all go downstairs together, okay? Don't sit, in other words, do not go in there and sit. All right, come up here. Yes.
Are you expecting that everyone be prepared to do openings tomorrow?
No, not at all.
Thank you.
We're gonna pick a jury and then here. Okay, we're gonna,
Downstairs,
what?
and we're meeting in Beeching.
We are? Not here? The council, just the council.
I don't know if he's using our courtroom.
Why don't they just meet in here?
Okay. I just don't know if he was going to use our courtroom.
He's not gonna be here.
We're officially switched courtrooms.
I know, but I do not believe, somebody told me he's not here.
Let me see.
Huh?
Let me check.
Who told me that? Court TV said that.
Court TV.
I'm just trying to get them not to have too many, is it okay if you all go to the second floor in a new courtroom tomorrow while we're waiting?
Yes, we will
Okay,
walk in.
all right, it's a much bigger courtroom. All right, so 8:30, and then they'll typically call us around 9 to go downstairs, okay? All right, thank you, we're in recess. You can bring water and coffee with a lid, okay?
Thank you, Judge.
Wow, she is a kind judge. Coffee with a lid? Imagine. We don't get anything like that in my local courts here. Well, I mainly wanted to hang out just to make sure that, like she said, we are not expecting openings tomorrow. So tomorrow off. And we'll find out, I'm sure, by the end of the day, whether they have been able to select a jury or whether they will be continuing that process into Wednesday. Whenever they're done, they'll be done. They'll go to openings, and then we will pick up on the stream at that point in time. So just a heads up about the stream for this trial and what I'm kind of anticipating at this point. We've had, several of us have been having discussions kind of behind the scenes about how we can get together to do this as a panel show. And so we are working on that. I'm not 100% sure yet exactly what the link is going to be, but it is something that I should be able to stream to my own channel. You'll be able to pick it up here and see it. You will just get the panel presentation instead of just me. So we're going to go ahead and give that a shot to this one, because it's always been good, I think, to get all of the different perspectives and the different reactions when the trial was happening. I thought that was very valuable during Det v. Heard. It was one of my favorite parts about it, honestly, is just seeing how some of the different pieces of evidence, different arguments and things like that affected people differently, just different takes on it and stuff. So very much looking forward to that. So all I'm saying is, don't necessarily, if you look for my link on Twitter the day before, don't necessarily do that in this case, because we're going to have to figure out exactly how this all works in terms of getting that set up and shared. But if you do have notifications on for YouTube for when I go live, I will be streaming it to my channel. So that should let you know when we're getting ready to go on all of that. So hope you'll join us. Very excited about it. It should be a lot of fun. Okay, well, I said I was going to go ahead and go back real quickly and finish the rest of this motion so we can wrap up the quick reaction to Karen Reed and see where we're at here. So the Supreme Judicial Court's holding in Commonwealth versus Roth that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. As the Roth court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separately charged carries a significant potential for coercion. Also citing to Bluford, declining to require court to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here the jury was asked to return 3 separate verdicts on 3 separate counts. In this circumstance, where the jury reports a deadlock without specifying the count on which it has reached an impasse, it is a straightforward and, the defense contends, constitutionally required follow-up to ask whether the deadlock relates to some as opposed to all counts. Indeed, the Supreme Judicial Court has explicitly stated, where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts, despite deadlock on the other counts. Well, there's a massive tell here that the defense is also aware of what a big reach this is, and that's this statement. It is a straightforward and, the defense contends, constitutionally required follow-up to ask whether the deadlock relates to some as opposed to all counts. If it's constitutionally required, there's case law on it. You haven't cited any, so it's not constitutionally required. You might want it to be constitutionally required, and you might be able to make an argument as to why it should be constitutionally required. But as we sit here right now, it is not, and just saying it is, I don't think is going to get you any closer to where you want to be there. Let me see. I just pulled it down, and now I'm having a hard time finding it again. Okay. Alternatively, subsection C, alternatively, the defense is at least entitled to conduct post-verdict inquiry. Undersigned counsel did not initiate the communication with jurors A, B, and C, which resulted in the disclosure of information that is memorialized in counsel's affidavits that are appended to this motion. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury and/or an evidentiary hearing to substantiate the existence of an acquittal. Should the court seek the affidavit of each juror, i.e. jurors A, B, C, supra, the defendant asks for the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty of counts 1 and 3. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. Yeah, but this is not juror bias. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime on which she was previously acquitted by a jury, and the defense submits that post-verdict inquiry is equally warranted in the present context. Just as the court in McCallop approved questions as to the existence of racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded that Ms. Reed was not guilty of counts 1 and 3, do not invade the heartland of jury deliberations, but preserve the defendant's precious rights to the favorable outcome of a jury trial and to the protections of the Double Jeopardy Clause and its related state judicial protections. For the foregoing reasons, Ms. Reed respectfully requests that this honorable court issue an order dismissing counts 1 and 3. They're not going to get this. No, they're not going to get this. This isn't bias. The reason why bias is an exception is for 2 reasons. One, because it potentially goes to misconduct, to juror misconduct. You're not allowed to consider extraneous information. You are to decide the case based on the evidence. So your antipathy to people of whatever race is not something you can base a verdict on. And then there are just some kind of specific rules in the context of racial bias that it's kind of intolerable to the jury system. And so if somebody is relying on that improperly, that is something that it's close enough to misconduct that it's going to fit within that exception for why you get to question the jurors about it. This is not that. This is not that. And just trying to say this is attenuated from the content of the deliberations, it's not. This is the content of the deliberations. This is flat out the content of the deliberations. A decision you say, to acquit her on certain counts. So they are implicitly acknowledging in this paragraph that they know that that's what the restriction is. They don't get to go there. And they're trying to avoid that from being applied in this situation. I don't think they're going to be able to. They're going to be prohibited from asking these questions. So I don't see the analogy to juror bias working. And then on the previous situation, it's still the coercion problem. They're saying that maybe there's not a Massachusetts case where it's dealing specifically with polling the jury on all of the charges, but it's still the same situation. The problem is you're implying you should reach a verdict on something here. Can't you reach a verdict on anything? You don't get to put your thumb on the scale like that. So I just don't really I don't really see this one going forward, guys. I know that's going to be disappointing to lots of people, but I just got to call it straight like I see it. And I understand why they'd be bringing it, but it's not going to meet the legal standards. So don't expect it to go anywhere. Just a couple questions that came up. Nathan C., what about asking if the jury is unanimous on any? Yeah, I mean, two problems with it. One, there wasn't any reason to ask that. There was nothing in any of the notes that suggested that they were able to reach agreement on anything. And so when the jury is reporting, we're deadlocked. We can't agree. You kind of, take them for their word on that. Problem is asking, can't you agree on anything? It's getting a little bit too close to the scale of coercive, and it's getting a little bit too close to, what are you guys talking about back there? If you can't agree on anything, it's getting into their process, and we're just not allowed to do that. The jury room is sacrosanct. What they talk about, how they reach their decisions, we're not allowed to second guess them. Britt Cormier, could the judge have asked the jury, is there any charge that you all agree to not guilty? Yeah. Well, clearly the defense is arguing that she should have done that. Not only could she have, that she should have done that. But, first off, the prosecutor, the Commonwealth, certainly would have objected to this, because this is now just being suggestive in the other direction. It's pushing them. It's pushing them towards an acquittal. You don't get to put your thumb on the scale. That this question would potentially be worse coming from the judge, just because this is fairly clearly directing them in a certain way. And that is not being impartial. That's the judge not being impartial here. So no, I just don't think that there is really a viable inquiry under these circumstances. Claude Simeon says, I'd happily watch you solo if ever sick of panel. Well, thank you. I appreciate it. We're going to give it a shot. I think it'll be fun. I've had a lot of fun on the panel chats in the past, and it's an insightful way, I think, for everybody to be able to watch the trial. I'm just one person's perspective, and how other lawyers with other experiences react to stuff. That's going to help me. Like, for example, Nate the lawyer, supposed to be on the panel. Nate the lawyer has a lot more experience with, trial lawyers from New York than I do. So when I have my gut reactions to the defense team, he's going to be able to check me on that. And is that really out of the norm for what's okay in that particular culture and things like that? Mr. Nickus, I kind of like him. I don't mind him at all. It's really Mr. Spyro that grates on me. I just don't like his attitude. He just is very accusatory and aggressive from my perspective. Much better today, much more conciliatory today, but still just, a lot of this needless, from my perspective, like needless flaming of the other side is just not particularly helpful. But he doesn't annoy me as much as Carrie Morrissey does. She annoys me. Yeah, she really annoys me. Boy, I don't know. I don't know what it is about that presentation. It's just the over-the-top drama. The emphasis. Absurd. Ugh. It's not necessary. Let your facts speak. This is the show don't tell. Show don't tell. You don't have to put on a performance to get me to believe you. If you have a good have a good case and the evidence is going to be on your side, then you can just rest on that. You don't have to get all defensive and triggered by the fact that the defense team said something mean about you. It should be pretty clear by now. The judge isn't paying much attention to that, so it's kind of just a her thing. She seems reactive. It kind of bothers me. We'll see. We'll see. But yeah, just generally not an attitude I really enjoy from a prosecutor. I recognize she's not normally a prosecutor. She's normally a defense attorney. I don't think I would enjoy this type of demeanor coming from the defense side either, but definitely coming from a prosecutor, I find it pretty obnoxious. So we'll see if she tones that down for the jury. All right, guys. So I'm just going to be on watch now for when we have a jury selected, and then once we do, we'll plan to go live for the opening statements and whatever else we have lined up at that point. I'm still fingers crossed. I'm anticipating that's going to be Wednesday, but it sounds like we'll know for sure tomorrow. So turn on the notifications for my lives on the channel if you want to get notified of that, since I don't know exactly how to direct you guys to where the panel is going to be at this point in time. But I will stream it to my channel, so if you are getting notifications, you will get it that way. And this is going to be fun. This is going to be a fun trial. I am looking forward to this. It's not, it's never, you know, people's lives obviously have been deeply affected by this. And it's certainly a grave situation that this trial is about. It's not like, you know, this is a party or something like that. But it just is always fascinating to see how these personalities present in a context like this, particularly somebody like Alec Baldwin, who just has such a public persona of being so, frankly, kind of uncontrollable. Like my knee-jerk reaction to Alec Baldwin as a criminal defendant is that he must be a terrible client. I just assume he's probably a terrible client, probably a bit unmanageable. He's just one of the people that is going to do what he wants to do and expects the defense lawyer to fix it for him, not to, you know, give him advice about how to modify his behavior to not have problems. It's totally just, you know, just my perspective on him from having seen, you know, interviews with him and how he presents in the media and stuff like that after all this time. But, so you never really know what's going to happen. It's a situation very much where I could see, you know, he has, he's going to have a perspective on his rights, and he's going to make those decisions himself about his rights, which includes things like testifying. Do we think Alec Baldwin is the kind of person who is going to listen to his lawyers and take their advice about whether he should testify? Gotta tell you guys, I'm kind of skeptical. I kind of think he's going to make those sorts of calls himself. So that type of thing is fun. Seeing how this grudge, this grudge between Carrie Morrissey and Alec Spiro. It's annoying, but it's also, you know, kind of funny. I'm a little bit interested to see how that's going to play out. And are they going to be able to restrain themselves, or are they going to continue to act like children in front of the jury? And how pissed is the judge going to get if that kind of thing happens? So Lots, I think, to look forward to in this case, just from a pure trial drama standpoint, the kinds of things that unfold in the courtroom. But also, this is a very serious legal question to consider, the scope of his responsibility. This is something that I believe, yeah, he deserves a fair shake on that, for the jury to get a full picture of what was going on that set, who was doing what were the conditions. What should he have known? What should he have known, and what did he do? It is important, because I know that there is some concern that what does this mean, that Hollywood's not going to be able to make movies with guns anymore? You know, if he's found liable, what actor is going to sign on to be in a part where you're using a real gun as a prop? I mean, you're just really potentially putting yourself on the line. I recognize that actors and other people involved in the industry, they have kind of relied on these safety protocols as protecting them in the event that something goes wrong. So it's kind of an interesting question about whether they should really be relying on that or not. I don't know. It's a tough one. Claude Simon, does New Mexico allow cross on anything or only redirect? Well, let me see if I can find out. New Mexico Evidence Rule 611, the scope of cross-examination. Here is the rule for you. Cross-examination should not go beyond the subject matter of the direct examination and matters affecting a witness's credibility. The court may allow inquiry into additional matters as if on direct examination. So basically, for cross, they are limited to the scope of direct, but they can, if they were going to call this witness anyway for purposes of asking direct questions, the court has the discretion to allow them to do that while the person is on for the stand for cross, rather than requiring them to come back and then be on direct. So if it's time effective and, you know, not confusing or anything like that, I would fully expect that the judge would allow them to do that. So, yeah, guys, it's this is a big decision for them to look forward to. I know people got a lot of strong opinions. I've got a lean, you know, not hiding that. I've got a lean. I'm skeptical about the ability to delegate your fundamental responsibility to handle firearms safely. I am skeptical about your ability to delegate that to somebody else. But it's going to depend on the facts. I think it'll depend a lot on the facts of the situation. So, looking forward to the evidence, guys. Looking forward to the openings. I will keep you posted. Look forward to seeing you all there. Thank you so much for joining me here today. This was not necessarily the most exciting hearing, but it is, I think, good to get a little bit of a preview of what sorts of constraints might be put on the parties' ability to present their cases. And from what I saw today, I have pretty good confidence that this judge is going to be fair. If I was going to have one critique, it would be that she does seem to have, pardon the expression here, a little bit of a hair trigger temper. She's got a little bit of a tendency to react before she necessarily has the information, which is not ideal. But I do like that she's very definitive in her decision making, and she's not taking any nonsense. She's not playing the lawyer games of let you jerk me around, waste my time, re-argue my decisions, things like that. I like the control that she is showing in that respect. She's clearly the one that's in charge of the courtroom, but she also seems, to my eyes so far, to be wielding that power fairly. She's not taking anybody's side unduly. she's not getting involved in the personality conflicts, any of the stuff like that. So I have a lot of confidence that we're going to get some fair rulings out of this judge. So now we know. Now we know. And now we're ready for once things get started. So thanks again, guys. Appreciate you all being here. Thank you for the support. Thank you for continuing to join me. Thank you for keeping your eyes out for the stream once we get going with the opening statements. I will look forward to seeing you guys then. Take care and enjoy your day off tomorrow.